the authority under that they're being held under. Yeah. Sure.
So that does bring us to the statutory authority, as Marsha already indicated. It's 7B 1902. Any district court judge has authority to issue secure custody orders. Delegated authority is the chief district court judge can delegate to the chief juvenile court counsel or their staff by an administrative order the authority to issue secure custody orders. If this comes up and you see a signature on a secure custody order that is not a judge, you need to know what your administrative order says specifically and who the authority has been delegated to. Have seen some situations where a magistrate has signed a secure custody order and they do not have the authority to do so. So make sure that you double check those things. Administrative orders have to identify which person can be contacted to approve a secure custody order, and then they have to be filed with the clerk's office. Your clerk should know where to find that administrative order. I have seen some issues pop up where they weren't exactly sure where it was, but usually your chief court counselor will have a copy of it if your clerk can't find it. So you should have a couple of different places where you can find those administrative orders. And then the superior court judge has authority to issue secure custody orders if the case is remanded, and now, of course, if the case is removed back to juvenile court. So the initial secure custody order is covered under 7B 1904. Those initial secure custody orders can be issued after the filing of a petition, but before the juvenile has been actually served with the petition. So you could have a child who is placed in secure custody who legitimately is telling you, I don't know what I'm here for, I don't have any paperwork. If the juvenile has not been served with the petition after being detained, they have to be served within 72 hours after being detained. So they should, within that window, get a copy of their petition and the secure custody order. Execution of secure custody orders is the same as the real-time rules on serving warrants. So you can look at 7B 1904.5 for some of those issues. Officers can use a copy of a secure custody order instead of the original. So that's something that has been updated in the statute relatively recently.
Got a question?
Yes.
What's the remedy for that if it's not served within 72 hours? Or is it
Dismissal.
No.
They won't get you to a dismissal, unfortunately, but
Is it release of the juvenile or?
I argue for release of the juvenile if they haven't been served, but I will tell you what typically happens is as soon as somebody realizes that there's an issue and they haven't been served, they speedy fast go get another secure custody order signed. So you might get your kid released, but they're going to put them right back in pretty fast. So just be aware of that. You can use it to make the arguments. I've had a kid where they were not properly served, and I argued that to get them out of custody. Judge ordered them released, and in the meantime, DJJ's in the back typing up a new secure custody order. And the judge had said, if they get a new secure custody order, I'm going to consider signing that. And their willingness to stay in the courtroom and wait for that process to take place is going to weigh in my decision. So we had a discussion about the child stayed, sat there knowing that he might get another secure custody order and have to go back into custody. But because he stayed, got properly served, got all the paperwork, the judge said, no, I'm not going to order him into custody. That was not a murder case. So I feel like if that happens in a first-degree murder case or an undesignated murder case, they're not going to get out that fast. As soon as somebody realizes the paperwork is messed up, they're going to get it corrected really quickly.
Thank you.
I would file a written motion to preserve it. It is a recorded courtroom, but file it. Build your record. Once you get up to Superior Court, you don't know what other issues are going to pop up. Build that record.
So review hearings occur on secure custody orders as well. So that initial secure custody hearing has to be within 5 calendar days. If it is under delegated authority, it has to be the next session of district court. So that's not the next session of juvenile court, it's the next session of district court. It's been under delegated authority. And that initial secure custody hearing cannot be waived or continued. So if you have a child, it does happen occasionally where they're angry for whatever reason, they don't want to go home, and they tell you that they want to waive it, you can't actually waive it. There still has to be a secure custody hearing. Obviously, you can shorten it if you've got a child saying that, but you do have to have the hearing within that time frame. So then for the actual review after the initial hearing, those have to be within 30 days unless a party requests hearing inside that 30 days. If a request is made for a hearing inside of 30 days, it has to be within 10 days, and it can be waived with consent and through counsel. This 10-day window, so there have been some statutory changes about this, and for purposes of first-degree murder cases, your hearings are going to be at 30 days. The review hearings will be at 30 days. The language of the statute says that at the request of any party, hearing shall be within 10 days. So if you make the request, if the DA makes the request, the judge on their own motion can order a hearing. It has to be within 10 days. And that brings us to the 13 to 15-year-olds and the 16 and 17-year-olds who are charged with Class A felonies or the Class F through G felonies. Again, review hearings are 30 calendar days, 10 days, if there is good cause shown. So if you make the request and there's good cause shown, then it has to be within 10 days. And again, those can be waived with consent of the juvenile and through counsel. I would suggest that if you're consenting to waive those, it would be a good idea if you got your client to sign something saying that they want to waive them. That's not always practical, but if you have somebody who is saying, I want to waive them for now, that might be a good idea. Remand or removal, your hearings for secure custody after the point of remand or removal have to be within 10 days. So you're in superior court, your case is getting remanded back to juvenile court, or it's being removed back to juvenile court. If the judge in superior court orders secure custody, they have to have another initial secure custody hearing, and it has to be within 10 days of that order. And they also cannot be waived or continued. So again, on review hearings, we've got capacity and secure custody issues, and we have already referenced that capacity is going to need its own special training, but for purposes of first-degree murder cases, if you have asked for a capacity hearing, when capacity is raised, hearings are 30 days from the date of the motion. Those can be waived with consent and through counsel. Hearings have to be within 10 days if it's requested and there's good cause shown. If a juvenile under 16 waives a review hearing for secure custody, those hearings can be waived for no more than 30 days. So if you do have a child who waives a secure custody hearing, then make sure that you're paying attention to the time frame that it's scheduled for, because sometimes people will go a little outside of 30 days because they'll say, oh, there's a holiday in between or something to that effect. It has to be within 30 days if they have waived.
Got another question.
Yes.
Sorry for interrupting. Good cause shown. That is a very debatable topic. Sorry. Could you give us an idea of what, just based on your experience, what your judges have ruled as good cause shown and what may or may not be good cause shown?
Okay, so for good cause shown, age of the juvenile, they're very young. Secure custody is just basically inappropriate for them because they are on the younger end of children who have been charged in juvenile court. Significant mental health issues with the need for medication. I've had a child who was severely diabetic and had an insulin pump. The detention facility couldn't necessarily accommodate the way that the insulin pump worked because it ran through an app on the child's phone. Those are all types of things that have been looked at and ruled to be good cause. There have been some lesser things that have been ruled to be good cause. I had a family member who was willing and appropriate to be a placement, and we had just discovered their information, but we didn't have them in court. We needed a short period of time to get them into court to testify and provide the information to the judge. So they ruled that that was good cause, and they would allow a shorter hearing. Things that have been not good cause, the higher the level of the felony, the more likely the judge has been to say, yep, that's not good cause. So on the murder cases, attempted murder cases, what I'm seeing happen is the arguments are being made that I have a good reason for having that shorter hearing. And even if those reasons are similar to the ones that I just listed, they're looking at, okay, well, but I'm not sure that's a great reason because the statute says 30 days. And so essentially what I'm seeing is the seriousness of the offense is being used to say that's not a good enough reason. That's unfortunate, but that's that's the reality of what I'm seeing happen. Woodring, if you're seeing something different, let me know, but that's pretty much what I'm seeing happen in court.
It's the same. That's why I asked a question to see if it was general across the state, you know.
Yeah, it seems to vary by the class of offense, and for first degree murder purposes, you can bet that it's going to be a little bit harder to get those 10-day hearings. So statutory criteria for secure custody, and this is for pre-adjudication cases. There has to be a reasonable factual basis to believe that the offense has been committed by this specific juvenile, and that one of the following factors exist. Child was charged with a felony and they've demonstrated that they are a danger to persons or property. We typically argue on this one that you don't say they are a danger to persons or property based solely on the offense charged, because they are not yet adjudicated. They are presumed to be innocent, and therefore you don't use that specific charge. Now, unfortunately, that's not necessarily carrying as much weight as we would like for it to whenever we're making these arguments, but the way the statute is worded, to me, it makes sense that the danger to persons or property is based on this child has a history, not this child happens to be charged with something today. Second factor is that they are a danger to persons, and a misdemeanor has been charged with assault or use of a deadly weapon or DUI involved in it. Again, typically I would argue they haven't demonstrated that they're a danger to persons or property just because they got into one fight at school and got charged with a simple assault because maybe they were defending themselves. Obviously, for first degree murder purposes, we're going to be focused mostly on that first one. The second one, or the third, willful failure to appear in court. ADAs like to argue this one, that they're not likely to, this one and the other one, cause to believe that the juvenile will not appear in court. They've had a history of running away from home. So a history of running away from home is not the same as a history of running away from court. That doesn't necessarily mean they're not going to appear in court. So make sure that you argue that whenever you have ADAs saying, oh, well, they're not likely to appear because they keep running away from home. That doesn't mean they won't show up to court. And then again, that they're an absconder from a residential or a state facility. PRTFs, detention facilities, prior YDC commitments, those would all be the facilities that they're talking about for purposes of this. And then the court can order for their own protection if there has been a self-inflicted injury. In this case, if that occurs, they have to have been denied appropriate treatment at a hospital or other type of facility. Those we're typically not going to see for these offenses, for first degree murder offenses, but just be aware that they exist. Willful failure to appear for court purposes or cause to believe that they won't appear, that requires proper notice. So if a child has failed to appear but they never got proper notice, that's not technically willful failure to appear. So just make sure that you are aware of that. It is the state's burden to prove all of these things. It's not your burden to prove it for them. So make sure that you're having hearings. When you have a hearing in secure custody cases, a lot of times those are very informal. And sometimes the court just says, I'll hear from the court counselor. If the court counselor doesn't have any firsthand knowledge of what happened, that can be a problem. So you need to be asking for hearings and making the witnesses come to court so that you can question them in your secure custody hearings. So post adjudication, you can also have orders for secure custody. Assuming that you have a first degree murder case and you have managed to get it remanded back or removed back to juvenile court, or you've gotten some lesser offense and it's been sent back, juveniles can be held in custody pending a placement. So they would look at whether or not they're recommended for a PRTF or some other leveled facility like a level 3 group home or therapeutic foster care. They can be held pending placement. They are still entitled to secure custody hearings at regular intervals if that happens. They can also be held pending disposition. So if you do an adjudication and disposition gets continued to another date, they are allowed to have, again, hearings in between on secure custody, but they can be ordered to be held pending disposition. It is much harder to get review hearings at regular intervals if they're being held pending disposition, because a lot of times the judges will just set those out for 30 days and you don't get anything in between. They can also be held if there's a probation violation that is alleging damage to property or injury to persons. Again, that one you're probably not going to see with the first-degree murder cases, but it's possible if you have a child who is adjudicated of a lesser offense and gets placed on probation. Most counties reappoint the same attorney, so you may see your client again for one of these reasons. That brings us to shackling.
Shackling, where maybe a certain judge in a certain county in North Carolina may have told a child to write an essay about the relationship between shackling and slavery. Don't laugh too hard. Shackling by the statute is only when, that is a standard, right? Only when reasonably necessary for the reasons actually in the statute, black and white code. We've got it written in black and white, and yet we have so much room to argue because we've got some judges that are like, they done it. They got charged. They done it. Keep them in shackles. Okay, all right. Let me chill out a little bit here. That's our job that we're arguing, right? Obviously, the children that we're talking about for the purpose of today, they are charged with the worst of the worst. They're charged with taking another human's life in some way or another. And so we're fighting an uphill battle. We are. Your courtroom is going to have a climate. This is one of those areas where you really need to know your courtroom, your judges. If you're going somewhere kind of new or fresh or you haven't been there before, please find a local defender, ask some questions, get to know the judges and what they do or don't do, what the ADA may ask for or not ask for. There's supposed to be actual findings of why a child should remain shackled before they come into the courtroom. Before they come into the courtroom. That whole hearing happens, and then after the judge decides, hopefully actually takes a moment to think about it and decide, then the child is brought in. Practically speaking, and Madrina's going to talk about this more later today, this is a really good opportunity to start forming a bond with your child and with their parents, if that's appropriate in your situation. I warn my parents, especially if it's a situation where I know my child's going to be brought out in shackles. You're going to see your child in shackles. This is not going to be easy, right? That doesn't make it easier, but it starts forming that relationship for me. Your judge should be putting findings of fact in an order as to why they left shackles on, if they do, whether that's both hands and ankles or just ankles. And another thing I would ask you to do is to check to see if those orders are specific to that child, or if the shackling orders are the same for every single child that comes before that judge. If that's what's going on, then we've got an issue. It's not an individualized decision for that child. That topic makes me sad, so we will just move on. Remote proceedings. Okay, this is up here. All I really want to say to you guys, especially when we're talking about first-degree murder charges and making sure we have high-quality attorneys, means you may be a county or 2 or 3 over from where your child is. You may need to take into consideration remote proceedings at some point. You need to be aware of when it's allowed, when it's not allowed, and make a strategic decision with your child's involvement in that conversation about whether you're going to do a remote proceeding of some kind or if they're going to come into the courtroom. Does your child understand? Can they hear? Is the technology working? If the technology is not working, we've got a big issue. That's part of the statute. So I want to point it out to you guys that remote proceedings are one of the pieces of what you're thinking about through all of these proceedings, even when we're still in just delinquency. Credit for time served. I am flying through some of this. These are details so we can spend more time on some of the juicy stuff. Credit for time served. For whatever reason, we're still getting questions from across the state when they're in secure custody after they transfer. Does the time in secure custody count for time, right, of whatever their sentence is? The answer is yes. If you have a judge that's not firmly telling you the answer is yes, we need to talk. They're in custody under a state institution. It's there, right? Like, let's talk. If that's an issue for your jurisdiction, let's just talk, but keep that in mind. Okay. Ooh, trolley circle. That's how I know where we are. So the twirly circle went around first appearances. I am also going to fly through this again because if you're doing Superior Court work, you're familiar with first appearances, basically the same concept. Again, felonies only. We're talking about first degree murder. That's a felony. It must be within, the first appearance must be within 10 days of filing the petition. So that's sort of one of our timelines. And if they're in custody, it must happen at the initial hearing. So that's statutory. If they're not in custody, it can be continued out past that 10 days if need be. And the judge has to inform the child of the allegations, of their right to counsel, of the right to a probable cause hearing, and also inform the parent of of the judge's or the court's jurisdiction over the parent. I have lost my note, but there was something in here. Let me just make sure it's not on the same page or next page. It's not. Okay. The thing I want to mention about first appearances that was in my note, our AOC form for first appearances does not note what the charge that they've been advised of is. That was really bad grammar, but it doesn't say this child was advised of this charge on this date. There's a date, there's a signature, but there's no charge. Discovery statutes and Superior Court reference first appearances. First appearances trigger timelines. If we don't have, if they're only charged with one thing, that's pretty self-explanatory. But if they're charged with more than one thing and have multiple first appearance dates, as is often the situation, be aware. Be aware that if you're going to have to reference back to the date of the first appearance, our AOC form actually doesn't have which charge they were advised of. That was my note that was on there. Okay. Yep. Twirly motions for you.
So as Portia said, that brings us to the meat of some of what we want to really talk to you about, which is motions practice, because we do need to be filing motions. It's juvenile court. A lot of people think they don't necessarily need to be filing written motions. You absolutely do, because you want to preserve the record just as you would for an adult in all of these cases, whether it's first degree murder or it's some lesser charge. So the first motion that we typically think about for any criminal case would be our discovery motions. Juvenile court has a little bit of differences with their statute for discovery from the adult statute. There's a lot of similarities, but there are a couple of differences. The main ones being that you do not have to make a voluntary request before filing a written request in juvenile court, and no statutory rights attached to voluntary compliance. So if you have open file discovery, you don't have the same language in the juvenile code as you do in the adult statute for that. Also, there's no timeline. So adult deadline is based on your probable cause hearing, a date of 10 days, but that does not exist in the juvenile code. So first things first, it is upon motion, the court shall order the release of statements of the juvenile, names of the witnesses, copies of the records of witnesses under the age of 16, documents and tangible objects, material preparations of defense, and anything intended for use as evidence by the prosecutor or obtained from or belonging to the juvenile, and reports and examinations and tests. So essentially all of the same things that you're familiar with in the adult statute. It is covered under 7B 2300 all the way through 2303. So you'll want to review those along with the statutes in chapter 15. You may want to reference Brady material in your discovery motions. Obviously, you're required to receive that information, but sometimes whenever things are being a little bit difficult in particular counties, it's good to reference that in your discovery motions as well. If you need help with that, if you don't have a discovery motion, you can contact us and we'll send you one. So the next motion that we typically would think about are suppression motions. The statute in juvenile court is 7B 2408.5. It says that it is for adjudicatory hearings, but we believe it should apply in probable cause hearings as well. It is a preliminary type hearing. I have done suppression motions in the context of a probable cause hearing and in conjunction with a probable cause hearing in sex offense type cases. Kind of depends on your judge if they try to shut you down on that and say, well, we're not at adjudication yet, but most of the time nobody has questioned me about it. We've been allowed to go forward that way. Your suppression motions are to be in writing if they're made before court, and they have to have an affidavit attached. Again, if you don't have one of those, if you need one, we have copies on our website. We could also send you one. And also do a suppression motion orally during the hearing. And the court's options are they can summarily grant or deny the suppression motion or have a hearing and make findings of fact and conclusions of law. And if it is denied, the suppression motion may be reviewed or the suppression order may be reviewed upon appeal if there's once there's a final order. The one thing that I would tell you here is if you do end up entering an admission, try to preserve your suppression argument in the transcript of admission. Put some language in there about your specifically preserving the juvenile's right to appeal the suppression issue, because if it's not spelled out in there, you may lose the right to appeal that issue. The adult statute for suppression, 15A 974, also applies, so make sure that you review that. And just some general cases for suppression purposes, things that you can cite in your suppression motions. Obviously, there's Miranda versus Arizona, police interrogations, your typical Miranda warnings. Those are applied to juvenile cases through In re Galt that extended due process rights and the Miranda warnings to juvenile cases. And then we have JDB. If you haven't read JDB, you should. It specifically spells out that age is a factor to consider in the custody and the Miranda analysis if it is known or reasonably apparent to an officer. And typically it will be because they're young kids, so it's hard to mistake them for adults. Up to you all. Keep going.
And then I'm gonna give it back to you in a really awkward place anyway.
Yeah.
All right. Real quick on these slides, the way we put them together. Yes, Michelle. On the side, if we're referencing a specific statute, it's right there on the slide, on the side, kind of turned sideways. This one in particular is, like Terry was talking about, the conduct of the adjudicatory hearing statute. That's the one that specifically says the court shall assure due process of law and shall protect the juvenile's privilege against self-incrimination. Say that 3 times fast. It being a separate statute is part of the reason why some judges are like, well, it doesn't apply. It's PCs before. Okay, well, I mean, we'll talk, right? So, but one of the reasons we have this slide up here, in particular, the youth's rights are most explicitly spelled out in this statute, 2405. The right to written notice of the facts alleged in the petition, the right to counsel, the right to confront and cross-examine witnesses, the privilege against self-incrimination or self-expression, apparently today, the right to discovery, and then all rights afforded adult offenders except the right to bail, the right of self-representation, and the right of trial by jury. So one of the tools that we're giving you are these statute numbers that kind of reference the different pieces of what we're doing. Interrogation procedures are spelled out specifically in statutes for us, for youth. We like that. We like black and white written rules of law. So that's 7B 2101. And I trust that you guys can all read. So I'm not going to read it to you. Just be aware that there are different rules that apply for different ages. And for example, whether their parent must be there or can be waived. And we have a new little nuance to part of the rule where a caretaker can, I agree. For those on the virtual world, let's see, camera, the face I just got was, so I wholeheartedly agree, but has anybody experienced the caretaker being the person at an interview? I'm curious. Of course you have, Terry. How did that go?
Not well.
Right?
Foster parent and a social worker during an interrogation of a child who did not have a parent present, and they were actively encouraging them to speak.
It's bad enough when their own parents do it. And then we've got state actors. Literally, they're being paid to take care of the child by the state, encouraging them. So if I hope the issue there is sort of self-evident.
One thing with that, be careful of it when a kid is in DSS custody, because sometimes there is some motivation to get an older child in particular placed in YDC because their issues are behavioral. And so we want them out of DSS custody and into a secured facility. And that's a way to make it happen.
Facts. My single favorite topic within the world of suppression is school interrogations. There's so much room to argue here. Children are forced to go to school. They're forced to follow the rules. So we're already in a situation where they're having to do what the big people tell them to do. And then we get into questions about what happens if I've listened to them about coming to the office and answering these questions or not, or whatever. I'm already in trouble. So there's a whole world of law and lots of gray area with it. When we're talking about interrogations that are happening at schools. With first-degree murder charges, maybe, maybe not. I think if your child is being interrogated at the school, we've already crossed into the world of a criminal investigation. So we may not have as much room to argue, but if for some reason you have a component in your case where a child was asked questions at a school, or there was a search done, they found something, be aware that we've got some very specific rules and then also some non-specific rules about interrogations that happen at a school. The bottom line of it is, though, let me see, I think I've got it on the next slide. That one is, bottom line of it is there are some restrictions, obviously. Some restrictions of the child's liberty. Obviously, they're at school, but when we start crossing some of those gray areas and thresholds, then Miranda rights begin to apply.
Tagging on to that, school interrogations, one of the first things that you're looking at is the juvenile in custody. Are they free to leave? If they're sitting in the principal's office and they're being questioned by a resource officer or principal, there's a teacher in there, you know they can't get up and leave. So you need to be looking at those situations very carefully. It is based on the totality of the circumstances. Would a reasonable person feel that they could leave? We all remember being in high school, elementary school. If you ever got called into an office for any reason, you know you were not free to just get up and walk back to your class or to say, I'm going to go call my parent. I'll see you later. That's not how it works, and everybody knows that. So make sure that you're talking to your kids about what exactly happened whenever they were interrogated, finding out where were they? Were they in a classroom? Were they in the office? And then we have to look at, was this an interrogation? We're looking at, for those purposes, words or actions that are reasonably likely to elicit incriminating responses. It's based on perceptions, not the intentions of the officer or the school resource officer. Sometimes it's school resource officer. Sometimes the SRO calls outside agencies and has them send detectives to the school. So look at that as well. The specific case that I would encourage you to look at is in Ray DAH. It has paragraphs that outline things that would qualify as custodial versus interrogation. And it specifically speaks to things like whether or not the kid was in a classroom, was the parent contacted immediately, what are the school rules about discipline and questioning at school, if it's normal for an SRO to be involved in the questioning process, or if it's typically that the SRO only gets involved whenever it is clearly a criminal investigation. So look at all of those types of things. You might actually want to pull the school handbooks, the student handbooks for the specific school or for the school board in that area, because those will give you a lot of information about what the process is supposed to be for different types of things, because your child could be pulled in to be questioned about one thing and ultimately end up talking about something completely different. So say you have a child who is getting into fights at school. They get pulled in, they're being questioned about a specific fight, and in the course of that interrogation, something comes out about a shooting that happened over the weekend. Now your child is a suspect in a drive-by shooting. So make sure that you're paying close attention to those types of things and look at this case, because it really is one of my favorite cases to read about suppression issues in school. So juvenile records, we typically don't necessarily have to file a motion to get juvenile records for our own client. But you need records for your client to put together your case from the very beginning. So if your child is involved with Department of Juvenile Justice previously, there's going to be a wealth of information in their records. They have their NC join records, mental health records, gains assessments, all of these types of things. Department of Juvenile Justice, the link is up here, has a website. You can specifically go to this link, request your client's records, and you will get those records very quickly. Just make sure that you fill out all of the prompts, because there is a catch-all on that page where you can ask specifically for NC join records. And the reason I keep saying that one is because you'll get paper copies or scanned paper copies of all of the gains information, different entries of their behavior reports, or were they eating, all of these types of things from the detention facility. The NC join records are specifically entered by court counselors and other DJJ staff. And if you don't ask for them and you don't specify that you want them, you may not get those. And there is a lot of information in those entries. DSS records, medical records, mental health and school records, may have to have your client sign releases. If it's mental health records in particular, you are very likely to have your client sign a release as well as the parents. If it is a first-degree murder case and you're trying to get records and your child was 17 at the time of the offense and they turn 18, you definitely have to get your client to sign releases, and that can be a little bit difficult, but just make sure that you are getting proper information. 7B 3000 and 3001 cover some of this, so just so in case you need that, that's the statute that says you are entitled to your client's records without a court order. Sometimes you get a little bit of pushback whenever you're trying to get things on a local level. If it is other people's records that you want, say there are other juveniles involved and you want their records, then you're looking at whether or not you need specific releases signed, subpoenas, or a court order. You may need to file a Ritchie motion to be able to get copies of other people's records. So, capacity to proceed motions, again, this is a little bit of a mess. You do need a separate training for capacity in general, but if you want an expert for your client, you can still ask for ex parte funding for experts for your client, which includes asking for a capacity evaluation on your own, asking for a full psychological, a psychoeducational, those types of things. That form is AOC G309. That process still exists. You can still do that. If that evaluation comes back and says that your client lacks capacity, then you need to backtrack and look at the statute and follow the procedures from that point, because there are some issues about when you can ask for capacity evaluation and what that does to the timelines for your hearing. If they are charged as an adult, obviously you follow the adult statute. But for juvenile purposes, the statute is very complicated and it is more involved than what we can cover in this specific training, because there is now a process for remediation. It is for offenses on and after January 1st of 2025. So if you have offenses charged before that, you still follow the old rules. But for anything after that, you've got this new statute. And so again, it's pretty complicated. Jackie Green has written a blog post on it that lays some of this out.
Yes, may I interrupt you? Sorry. So we're currently having this battle out in Mecklenburg over MFRs. So the argument is whether or not, if a motion, I know this is sorry, but whether or not the motion for review is considered the new offense to implicate this statute, or if it goes back to the original. And this is a case where we didn't have it originally. It came from another county. And we don't think the child has capacity, so we're arguing for the assessment under the MFR.
That statute says for offenses on and after, and because it's worded that way, I would say that it applies to that original offense and that original offense date, and go with that. There's nothing that covers that. There's nothing in the statute that references that specifically, but because this is worded the way it is, I think we're stuck with the wording of it. It's the plain reading of the statute is for offenses on and after January 1st, 2025. So I would just keep arguing that. Cool. Sorry. Yeah, you're perfectly fine. The other thing that I have seen pop up with capacity is because we now have a roster of psychologists who are approved to do these evaluations. There's not that many of them yet. And obviously, we know that it's difficult to get evaluators for juveniles, and it can take a lot of time. I have seen a lot of attorneys getting very frustrated with this process because they can't get an evaluator. And they are going to AOCG 309 now and asking for their own expert. It's actually increased the number of those, at least in my counties, it's increased the number of applications being done that way because this has been such a mess. So some other motions that you could file in your juvenile cases, just as you do with adults, there is no right to a speedy trial, but you obviously can file that. And if they're transferred up, certainly you can put one in the record for your client. We obviously all know how speedy trial motions tend to go, but if you're preserving the record for appeal, do be considering filing those. Experts, we've already basically covered that. There's obviously more than psychologists that you can get for an expert witness. Venue motions are covered under both 7B 1800 and 15A 131. I think for most of these with first degree murder, it's probably going to be more appropriate to file your venue motion in Superior Court. But there may be some reasons to go ahead and file it early in juvenile court. If you do that, look at 7B 1800 because it is very specific. And it actually references change of venue more towards disposition than it does towards adjudication, but it still exists. And so because it's there, I think you could make a good argument for change of venue while it's still a juvenile. Motions to dismiss, look at your petitions closely, fatal variance and fatal defects. Obviously, you might want to make a motion to dismiss for those. There's certainly other reasons to file motions to dismiss, but if you're going to make a motion to dismiss, because these have such a high likelihood of being appealed, I would encourage you to do those as written motions. Amendment of petitions is covered under 2400. You can only amend a juvenile petition if it does not change the nature of the offense alleged. Usually you're going to be contesting the DA asking to amend a petition under this, but make sure that you're aware that that exists because sometimes I've had prosecutors say, oh, I just want to amend this because, well, if they're going to amend it to a lesser offense, I'm probably not very concerned about that. But if they want to amend it to something more serious because they screwed up, they wrote the wrong statute number in, whatever the case is for that, that may require the filing of a new petition. You can file motions for a bill of particulars. I've done that a couple of times in juvenile court. Works exactly the same way as it does in the adult system, and you run into some of the same roadblocks for it. But that is another motion that you could consider filing for juvenile.
Next thing we want to talk about, probable cause and indictments. Thank you, ma'am. And I'm gonna kind of fly through it because, well, number one, we're running out of time, but really it's almost the same as adult court in terms of your strategy, in terms of, you know, those things that you're doing. We have our own statute. I just want to point out the differences. So probable cause or indictment, those are the two roads through roadways, pathway, whatever, that we can get, that the state will get the case from juvenile to superior court. It applies to all the felony cases. Okay, I'm going to skip reading the reading stuff. What I want you to really, really know is that there are different timelines for different ages. And if you have anything other than a Class A charge, there are different timelines between those as well. So here's what I'm going to do. Let me show you my chart. If you're looking at it like, whoa, that's a lot of information. That's a whole lot of things on there. That's correct. Ultimately, here, I'll point at the camera a little bit. Ultimately, that's my point. The rules and timelines, the class of charge, those kinds of things for when a probable cause hearing must be held or when an indictment must be returned is very, very specific to each child, each charge, each age. Just take a moment to familiarize yourself with that so that you can assert your child's right to due process, the right to be heard, right to move the case along, or whatever is necessary for you to make the right strategic move. And not miss an opportunity to advocate. So probable cause, this is the slide for your indictments, the rules for that. And of course, whenever possible, our DAs are using the indictment process over probable cause because it's easier for them. Cool, flew through that. Any questions on that? And I'm accidentally skipping all your slides. Let me go back. There we go. All right. Have at it.
We are almost out of time on this, so for purposes of transfer for first degree murder cases, it's going to be mandatory transfer for any of these cases. If there's a finding of PC or there's an indictment, depending on your dates of offense, those cases are going to be transferred up to Superior Court. Your statute obviously is 7B 2200 and the subsections after that. If you do have a PC hearing and you get PC to a lesser offense for the youth who are under the age of 16, you may be able to fall within the discretionary transfer process. So that's a good reason for people to be considering their PC hearings and whether or not to have one versus waiving PC. I don't have the book. So for transfer purposes, the DA is required to give you notice of their intent to seek transfer. Again, mandatory is what we're looking at for first degree murder cases primarily. For discretionary transfer hearings, the statute does require the court to consider 8 factors. They also have to make a finding about whether protection of the public and the needs of the juvenile would be served by transfer of the case to Superior Court. That last factor, seriousness of the offense and protection of the public, also has language that says, and the protection of the public requires transfer of this case to Superior Court. So look at that one closely because the state feels like usually that's one of their stronger arguments, but there is wiggle room in there for you to make some good arguments about why your kid should be kept in juvenile court. You do need to be prepared to argue bond motions immediately after the transfer hearing is done. And look at the Pretrial Integrity Act because there is room for the court to order no bond in some of these cases now. We have been arguing, especially for the cases that are pre-December, constitutionality of mandatory transfer schemes. The cases that I would encourage you to review are State v. Wilson and State v. Garrett. They do speak to those. State v. Wilson in particular indicates that counsel must appeal transfer decisions, whether discretionary or mandatory, and failure to appeal results in the issue not being properly preserved and waived on appeal, and you can request a de novo hearing in Superior Court. Now we have our new statute that removes the ability to appeal a transfer hearing to Superior Court. Statutory language is there for 2602. With that case law, I'm not quite sure where that leaves us, but we are still encouraging appealing transfer orders and making the appropriate arguments because there are certainly good constitutionality arguments and due process arguments you can make about your client being transferred without the benefit of a hearing. That is going to bring us up to remand and removal process.
Is that me? Yep, that is me. Cool. Remand and removal. These are the little bits and pieces that we said we would at least mention to you guys so that you know that there are options out there. Obviously, when we're talking about first degree murder, it's going to be rare that a prosecutor is even willing to hear you out on it. If it's something that's transferable, they're probably going to keep it up there. But just be aware that a case, if you and the prosecutor agree to bring it back down, whether it's remand or removal, depending on where it started, the judge actually gets no discretion on this one little piece. So that's helpful. One less person to have to argue with. You'll have to go back into looking at secure custody. Odds are, if it's coming back down, if the case was awful, it's probably not coming down. You're probably fighting it at that point. So odds are, if it's coming down, you've come to some kind of agreement. Maybe you convinced your prosecutor that YDC for this child is going to be a better solution for everybody than sending the child to prison. Be ready to educate your prosecutor on why YDC is better than prison for this child and probably for all of our children. If they have to be somewhere, YDC is better than prison. The difference between remand and a removal, of course, is remand is if it didn't already start and go up there, removal is for the 16 and 17-year-olds that start now in adult court. We can still at least remove them to juvenile court if we can manage to convince our prosecutor. So be familiar with that ability, the rules on how to do that. It'll trigger some expungement in superior court, and it will also trigger 10,000 high fives from us. So please let us know if this is something that you have accomplished in one way or another, because we really want to celebrate you guys and the work that you do. It's difficult, it's painstaking, you put your heart and soul into it. And more than one person needs to tell you thank you. So we thank you for everything that you all do.
If you do get that worked out, there are AOC forms that cover remand and removal, so you don't have to invent your own motion and order for that.
I'm skipping adjudication and all the rest, going to questions. Any questions from those of you here or those of you online? I see a question. Oh, no, that's Nani is lining up the next. Any questions from online that I've missed? Okay. Thank you. I will. I'm gonna help.
Nice have.
Thanks.
Okay. Well, thank you, Berja and Terry. So we're just going to roll on with our next presenter, Dr. Peter Kuntz. Hopefully some of you know Dr. Kuntz. He's the Director of Clinical Studies and Programs at DJJ. He's been in that current position for almost 5 years, right?
2020, yeah.
Actually started your career in 2003 in juvenile justice, working at, is it Dillon YDC? Yep. And then went to Central Prison, managed both inpatient and outpatient services there. Came back to DJJ in 2017, working in the North YDC, so has a wealth of experience in both the juvenile and the adult realm in working with incarcerated folks on either side. I know that it was mentioned about capacity, and probably the number one person to blame for that is Dr. Kuntz. But no, in all,
I think it was described as a mess.
right. In all seriousness, sort of my role here is to talk about stuff that nobody cares about anymore. But it took years and years and years just to get the idea on the table that we needed capacity legislation. It started out in the JJAC, and Dr. Kuntz was one of the main figures to shepherd it, not only from JJAC, in DJJ and DHHS, and finally through the legislature. And we're hoping that that's going to reap some positive benefits for our clients. So please welcome Dr. Kuntz. Oh, an expert, by the way. I don't think you wanted me to say that out loud. If you need an expert, he might be the guy to call.
Absolutely, yeah. No, I'm certainly happy to do that. I'm actually doing that next week. I'm going to Wake County, and that's fine. Murder trial. So yes, again, my name is Peter Kuntz. The way that I started my career, it started back in 1999. I was applying to graduate schools, and a professor asked me a question, which I think is a very interesting question for all of us to kind of think about. Said, what population of people do you feel like you could never work with? That as a psychologist, I was applying to be a psychologist. As a psychologist, what group of people do you feel like you could never work with? And I said, at the time I was thinking, okay, well, what is a politically correct group of people that I could think about that I could get into this school? And I said, I don't think that I could ever work with people as a psychologist that have committed sexual crimes. That sexual offenses. I feel like that is a despicable group of people. I feel like I can never have any kind of empathy towards this group of people. So then I went through graduate school. I got accepted there, went through graduate school and got out and got my doctorate, and then took my very first job at CA Dillon Youth Development Center. And at the time, I did not realize this because they did not say this in the job interview. that CA Dillon was the main hub back in 2003 for all kids that had done what? Committed sexual offenses, right? So I spent the next 7 years of my life, my very first job, my very first time of being a professional, working almost exclusively with kids that committed sexual crimes, and some very, very violent sexual crimes. And then, of course, I went on to Central Prison, where the predominant group of people that I seemed to work with were men that had committed sexual crimes. And I have gone to testify in court predominantly on issues related to sexual violence. I have gone on national conversations with the OJD and kind of presented like big talks on sexual violence in juveniles. And so that is just to say that be careful about what you say about the people that you can never work with and never have any empathy with and never care about, because that may be the population that you spend the rest of your life working with. Kind of the way like the universe kind of like says stuff, I think, to us. So today that we're going to talk about why kids kill. And ultimately at the end of this conversation, you're not going to know the answer to that question. I want to point that out. There are some factors, there's some biological factors that we can think about. There's some psychological factors, there's some sociological factors that we can think about, and we're going to talk about some of those factors today. Today what we're going to do is we're going to talk about adolescent brain development. We're going to talk about prefrontal cortex, limbic system, and dopamine. I think those are important. We're going to talk about some psychological and social factors. We're going to talk about a study, which I think every single person, particularly every defender, needs to know, called the Pathways to Desistance Study. If you haven't heard about that, that's a very, very important thing. And then talk about some legal implications and the justice system. I'm not sure how many people in this room and how much people in this presentation have watched the show on Netflix called Adolescence. It is the #1 show on Netflix right now. It's been the #1 show for the last couple of weeks. I finished it last night. I stayed up way too late watching this. I had to use the subtitles because it's pretty thick British accents, kind of going through it. But it's very interesting. Did like people in the room watch this? How many people have seen this show? Okay. Yeah, and maybe you're smart people too, the people that haven't watched this, because you're not bringing your work home and not saying that this is how I want to spend my free time, is watching stories about kids going through the court system after brutally murdering someone. So that's probably a sign of good kind of work-life separation there. Which is a good thing, but it's a very interesting show. It's very well done. It really shows the impact. I think the thing that it does really, really well is it shows the impact of this upon the families. It shows the impact of murder upon families and the community. It spends a little bit of time talking about the kid, but a lot of time talking about really the impact of this work. So when we talk about maturation, first of all, I think everybody in this room can get behind the fact that the only ACC team right now in the tournament is Duke, right? We can all celebrate that, right? You know, we can all be together. We can at least get behind this. I had this argument with my wife all the time about how, you know, she is a big UNC fan, and I say, well, you know,
Listen to her.
yeah, I know. I know. That is so right in so many different situations. But let's talk about this. So for the purpose of like illustration, this is the guy named Cooper Flagg. Yesterday he scored 30 points against Arizona, by the way.
Yeah, but Caleb Love had 35.
Okay, all right, there you go. There you go. There you go. But for the purpose of illustration and maturation, this is why maturation and the argument of maturation is challenging for a lot of us when we go to court. All right, so Cooper Flagg is 18 years old. That he is currently 6'9" and he weighs 205 pounds. At the age of 14, Cooper Flagg was 6'7" and he weighed 195 pounds. Now, your job as a defender, when we use this argument of, well, these are not full-grown adults, that becomes difficult, right? And we're seeing this more and more with the juvenile justice system, is that we are seeing larger and larger kids, more, taller kids, stronger kids coming to us. And it's becoming more and more difficult to make the argument of, look, this is not a full-grown adult when you're looking up at this person and trying to make that argument. For females, puberty begins between the age of 13, between the age of 8 and 13 years old. Growth spurt between the 10 and 14. They typically gain an additional 1 to 2 inches in the first 2 years after getting their period, and full adult height is recorded by the age of 14 or 15. That means full bone growth and full adult height is typically around 14 or 15. Males, as usual, we're about 2 years longer than that. So most boys stop gaining height by the age of 16. So these are, biologically speaking, these are full-grown adults, all right? These are as strong as they will typically be at the age of 16. For boys, that these are as strong and as tall as they will ever be. So I think that becomes, when you think about maturation, is tricky, and it becomes more complicated as we get into this stuff. So the argument has been about brain development. Well, so obviously that these are not miniature adults. That is something about the brain that is different than full-grown adults. So the period of biggest change for the brain typically happens between the age of 0 to 3. So that is the time that it's the most active part that a child is born. The average human brain is approximately 25% of its average of its adult size, and within 3 years, it reaches 80% of its full size. If you've ever raised kids, if you've ever been around young children, you will know this. That in that first 3 years of life, that becomes a very critical time of development, and you will see a rapid change in development for those kids. I had an opportunity when my son was 13 months old, COVID hit, and so I would be typically at work, and I got a lot of chance to be home and see this. And so during that period of being at home, and I got to see him, he started walking and started talking and doing all of these amazing things. So that's the period of the most change. But then adolescence is the second most significant period of growth that all of us go through. These changes during adolescence include synaptic pruning and increasing the speed of neural communication. And so our brain starts to figure out how to talk to each other. The neurons are beginning to figure out, how do you talk to each other? And how do we figure out, what do we need to be able to be full-grown adults? And so the 3 areas that we're going to talk about that have most pertinence to us when we go through cases are the prefrontal cortex, the limbic system, and the dopaminergic activity. So prefrontal cortex, this is the area of the brain that most people talk about when they talk about juveniles. It's located right within the frontal lobe. It is responsible for the inhibition of inappropriate behaviors. It guides socially acceptable decision-making. It tells us what we should do and what we shouldn't do. It's critical for higher order cognitive functions such as reasoning, impulse control, moral judgment, emotional regulation, fear modulation, empathy. It's a really critical area of the brain that tells us what we should do and what we shouldn't do. How do you control your impulses? How do you control your emotions? How do you control your fear and your empathy? And and one of the areas that also becomes very difficult with your jobs when we're talking about maturation is that the area of the brain that is the intellectual formation develops much earlier than the psychosocial maturation area. So there is a disconnect, there's an imbalance between intellectual and psychosocial maturity. And this becomes very, very challenging when we're talking to adults. So, talking to juveniles. So the question that a lot of people ask juveniles is, what were you thinking? Right? We've probably asked this before. If you're raising adolescents right now, what were you thinking? Right? When you have a juvenile that comes to you in court, what were you thinking? And Larry Steinberg is probably the preeminent researcher when it comes to adolescent development. He's written all the books and all the articles. And he made this very interesting quote. He said, "The logical reasoning and basic information processing abilities of a 16-year-old are comparable to those of an adult. Adolescents are no worse than adults at perceiving risk or estimating their vulnerability to it. And like adults, overestimate the dangerousness associated with very risky behaviors. In sum, adolescents' greater involvement than adults in risk-taking does not stem from ignorance, irrationality, delusions of invulnerability, or faulty calculations." Now, that seems really strange, right? Because we make so many arguments that says that, oh, this kid doesn't know what he's doing, right? That the kid doesn't know what they're doing, that they're out there, that they just think that they're invulnerable and they're going to be able to do it. But actually what we find in brain science is that when you put a kid and an adult together, they both understand risk. So how does that help us? How does that help us in brain science? And why is there a juvenile justice system? If that's true, why is there a juvenile justice system? And it goes down to this two important variables. There's a cold cognition and there's hot cognitions, okay? Now, cold cognitions are non-emotional information processing and reasoning. Logical reasoning, careful deliberation, emotionally neutral context, consider the consequences of actions, evaluate different approaches to a problem. Now, if you are placed in a neutral environment, which is non-emotional, kids can tell you exactly why something is wrong, and they will be the same as adults. What happens is in those hot cognitions, and this is the part that is really important. In hot cognitions are decision-making in an emotionally charged situation. Typically results in an outcome with a high risk or high reward, and especially activated by the presence of peers. So in cold cognition, those are those emotionally neutral environments where you can sit down and you can explain rationally. This is from the dorsolateral prefrontal cortex, okay? So you guys need to know exactly that word so you can sound cool at parties, right? You can say like, oh yeah, you're activated the dorsolateral prefrontal cortex here, which tends to be fully developed around the age of 15. So that controls the function of planning, developing strategies to approach the problem. So that's around 15 years old, fully developed when these kids are typically coming to us. The hot cognitions is those places when you are placed in emotionally charged situations, when you have to make a decision quickly, when your emotions and fear responses start acting up. That is the orbital frontal cortex, which is also part of that prefrontal cortex. And that is fully developed around the late 20s. So you have a disconnect there. And so this makes our job really, really difficult, right? is that you're having a fully grown adult individual that is as tall and as big as they will ever be coming to us. And when we sit them down and they're not in a non-emotional state, they can explain exactly why they shouldn't do something. They can explain the risk. They can be rational. They can look like they are just fully logical thinkers. But then you place them in a situation where they're around their peers, it's emotional, that emotion regulation starts kicking in. That's when it gets tricky. That's when juveniles tend to make really, really bad decisions. That if we can think back to when we were juveniles, we made really bad decisions sometimes, right? That our kids have made really bad decisions because we are influenced by our peers, we are influenced by emotions, and we do not have that control center that we typically develops around the age of 25. All right. For instance, that say that that you're a juvenile and you say, there was this context that we had actually a friend that like did this, that they were talking about having a rope that was attached to a car, and they were going to skateboard down the highway, right, with a moving car, right? Now, that sitting them down and saying, do you think that this is a risky behavior? They're like, yes, this is a bad idea, right? This is a bad idea to do. And that all of this is, and they can explain exactly why this is dangerous. I might fall off, I might break my head, like doing this. Then their friends show up and they say, we want to do this because it sounds fun. Then something clicks in their brain and they disregard all of the logical thinking that they were able to explain just 5 minutes ago. And that overrides, and that's when that really bad decisions typically happen. That we also have, that what we found is that neurological deficits in the prefrontal cortex and aggression. There was a study back in 1997 where they conducted a study utilizing the positronic emission topography, the PET scans, to examine brain activity in a group of individuals who were convicted of murder compared to a control group of non-offenders. And what they found was that there was a statistically significant reduction in functional activity of the prefrontal cortex in the violent offender population as compared to the non-offender population. The study found that decreased activity in the prefrontal cortex were linked to deficits in impulse control and decision-making. The study also established a link between reduction in activity in the prefrontal cortex and increased activity in the limbic system. Right. Any questions? We're good. All right. So that leads us to the next part of the brain called the limbic system. All right. So the limbic system is this part which is in the middle of our brain. This is linked and regulated by the prefrontal cortex. So if you want to think about it, the prefrontal cortex is that regulatory board that is sitting at the front of our brain and saying what you can do and what you can't do, how things should operate, how things should be put together, when to activate certain parts of the brain, when to suppress parts of the brain. That prefrontal cortex is really the gateway to that. For the purpose of this, the limbic system, we're going to think about 3 different parts. All right, so the first part is this part called the amygdala. It's right here. It's called the amygdala because it's almond shaped. That's the term. Amygdala is almond, and it's very, very tiny. It's associated, this little tiny part right here, it's associated with the emotional responses such as fear, anger, and aggression. Studies have repeatedly shown that hyperactivity in the amygdala is linked to increased impulsive aggression, particularly when there is insufficient regulation by the prefrontal cortex. The amygdala exerts greater influence over behavior with an underdeveloped prefrontal cortex. And so this part, the amygdala, is our emotional brain. It is the part that allows us to feel good emotions as well as bad emotions. And the prefrontal cortex, again, is that regulatory board. It says, okay, this is how you feel, this is what you should feel, and this is what you should not feel. And so that what we find is in the amygdala, there is hypersensitivity to emotional responses when that prefrontal cortex, that part of our brain, is not fully developed yet. What we find is the prefrontal cortex fully developed around the age of 25. So that becomes a very, very important part. And that tends to lead to heightened aggression when that is not fully regulated. The second part that we're going to need to know is called the hippocampus. Hippocampus is right here. It's very interesting when you think about the amygdala is connected to the hippocampus. Okay, so the hippocampus is our memory storage unit. It's memory formation and emotional learning. This is why, for instance, when you think about the amygdala, do you remember where you were on September 11th, 2001? Do you remember what you were doing? You remember where you were? You can probably even remember like what you were wearing, maybe what was going on, how you were feeling, what was going on through that day. It's actually pretty interesting when I talk about this and I use that example in juvenile justice situations. More and more people they're raising their hands saying, yeah, so I was 3, you know. I'm like, what? That was just like 5 years ago, you know. I was 3 years old. I wasn't born yet, you know. So I'm gonna have to think about another example, but for the purpose of this, if we can think back to that, we can exactly remember where we were, right? Now, can we remember where we were September 11th, 2023? I don't know. I could probably look back on my calendar and maybe find out. September 11th, 2024, just last year. February 13th of 2025. March 12th of 2025. Do you remember that? I don't, you know, it's, you know, so what that shows is that emotions tend to stay with us and tend to file memories that we need to hold on to. And that becomes really important when we start talking about trauma, right? Starts talking about trauma and they say, okay, these are memories that we need to file in our bank to say, these are things that we need to hold on to. So that is the hippocampus. Studies have shown that exposure to chronic stress, trauma, adverse childhood experiences can lead to structural and functional impairments, which may lead to further exacerbate aggressive tendencies. So this hippocampus is really kind of thinking about, as the whole brain does. The whole brain's job is to do what? What is the main point of the brain? What's its main job? What do you think? It's not a trick question. Keep you alive. Exactly, 100%. Our brain is saying that we've got to keep this organism alive because that without this organism, you know, alive, I cannot function. So I want to function. That the brain is trying to survive and saying you've got to keep alive. And so we're going to register all of those emotions that are negative and traumatic. We're going to keep those deep down inside, and we're never going to let you forget it because we want to keep you alive, right? And so this amygdala and this hippocampus very closely connected. And without that regulation, without that prefrontal cortex saying it is okay, you don't have to be afraid, you don't have to live in fear right now, you don't have to act out aggressively. That amygdala and that hippocampus is reminding us all the time that we have to be on guard. We are not safe. We have to be careful. The third part is the hypothalamus, which is right here. It is involved in the regulation of aggressive behavior. It coordinates response to stress and regulates emotion in fight or flight responses. So all of this is connected. You have your emotional center of the brain, you have the memory center of the brain, and then you have your emotional responses and stress regulation and regulation of your emotions right next to each other. This is that fight or flight response, which is of course connected to aggressive behavior, particularly when we don't have that regulation of the prefrontal cortex. The last section of the brain that I want to really kind of, reiterate is called dopamine, all right? So dopamine is a neurotransmitter. Neurotransmitters, if you can remember back to science class, are chemicals in the brain. They tell us what to do and what to feel and how to react to situations. Dopamine is typically involved in the reward processing and motivation. So if you're in really good shape and you go to the gym and you feel good from going to the gym, that is the activation of dopamine. It's typically called the happy transmitter. And adolescents are very, very sensitive to dopamine. Dopamine becomes a very, very important neurotransmitter when we're thinking about adolescence. And there's really kind of two main theories about the use of dopamine and adolescence, the utilization of dopamine. One is that in adolescence, there's a temporary imbalance of dopamine receptors in young adolescents that is hypothesized to create a reward deficiency syndrome. So what that means is that there is this imbalance of dopamine where they're feeling really good one second and feeling really lousy the next. And there's no consistency with that because that dopamine is trying to figure out how to regulate what you're supposed to feel, what you're supposed to being as a full-grown adult. And so that there is a deficiency in that. And so what that would mean is that something that is typically enjoyable to adults, such as taking a walk through the park or seeing the sunrise or taking a walk on the beach, doesn't do it for kids, right? They are just not feeling it, right? That does not give them excitement, and they are in a deficiency there. And so what this theory would mean is to say they need to have increased sensitivity, they need to have increased stimulation to be able to feel just a normal level of happiness. And so it becomes so boring and life is so boring that you need to do these increased, more and more scary things and dangerous and risky behavior to be able to activate at least some feeling of happiness, of some feeling of reward. The next theory is that there's that dopamine is there in adolescence, that there could be a potential higher level of dopamine, but there is no buffer. And so there's a loss of buffering capacity that results in a higher level of dopamine in the prefrontal cortex that leads to potentially rewarding stimulation being experienced as much more rewarding. So there is this flood of dopamine where they're feeling very happy, and something like going on a skateboard and riding behind, going out and having, drinking and sex and these kind of things are at a all-time high. That this is an amazing experience. And what this theory states is that if you really want to feel what it truly feels to be an adolescent, is that you should go out this weekend and have a bunch of cocaine, right? And you should come back and tell us about it, right? Yeah. But that cocaine is really kind of reaches the level of this is what it feels like to be an adolescent, is that you are experiencing a high, that you're feeling euphoria, that you're going to do crazy stuff on like cocaine, that you're going to have so much energy and an ultimate rush. And that's what it feels like to be an adolescent, is that this dopamine that is unchecked, because what cocaine does is that it really temporarily takes that buffering effect off of that dopamine regulation and that social emotional regulation center, it temporarily shuts down our prefrontal cortex and allows us to feel this euphoria, right? That's what, in this theory of dopamine, that's what it would feel like to be a adolescent. We also have some psychological factors that we need to talk about. We spend a lot of time in juvenile justice, particularly in the last 10 years, I would say, talking about trauma. Trauma is something that I know that you have heard a lot of studies on, that you've heard a lot of presentations. Early childhood trauma is associated with delays in the functioning of the prefrontal cortex. And that makes a lot of sense, right? Is that if you are exposed as a child to say that your father, when he gets drunk, that he is going to come home and he is going to be potentially violent, and your brain's main function is to do what?
Keep you alive.
Keep you alive, right? Good job. Our main brain function is to keep us alive. What we're going to develop is we're going to use all of those amazing capacities in our brain to say, can I smell alcohol? Can I know when he is going to be coming home and he is potentially intoxicated? So I'm going to develop the olfactory sensation. I'm going to be able to smell alcohol from a long ways away. I'm going to be able to tell if somebody is inebriated, if somebody is affected by alcohol, because my job is to be safe, right? And so that is going to shut down some of these prefrontal cortex, where as in a healthy childhood that we're allowed to develop in a certain level in a way that says, okay, we're going to allow our prefrontal cortex to develop regulations because we can regulate our emotions because we're safe to do that. In these situations, we are not. It also is associated, trauma is associated with that hyperactivity in the amygdala. Our emotions are going to go crazy, that it's going to be firing at all cylinders because your job is to keep you alive. And are particularly associated with reactive aggression. That makes a lot of sense. Early childhood trauma is strongly associated with impaired impulse control and overactive fear responses, that it's been linked to increase in violent behavior. There's also what we find is the presence of peers. Now that's not going to be anything new, right? If you've raised teenagers, you've been around teenagers, presence of peers and peer pressure is one of the things that people talk about all the time. That what they found is that peer pressure significantly increases the likelihood of engaging in aggressive or criminal behavior, particularly among juveniles who strongly seek social acceptance. And the juveniles that strongly seek social acceptance is about 99% of juveniles are out there trying to seek social acceptance, all right? Adolescents are much more sensitive to peer influence than adults, and studies have documented the mere presence of peers substantially increased the greater number of risks that the adolescent engaged in. There was a really interesting study about this where they did driving stimulations. A driving simulation. And they got adults to come in and juveniles to come in. And they had them drive through a series of obstacles on this simulation. And by themselves, adults and juveniles did comparably the same. They survived the simulation, that they were relatively similar. And if you think back to that cold cognition, very, very similar, okay? Logical thinking. Then what they said is, bring in some of your friends, all right? So they had them bring in 2 of their friends. Now with the adult population, and they had their friends sitting next to them, and they did their simulation, pretty much the same, actually. Yeah, that they drove through the obstacles. There was very, very little difference. When they had their peers and the kids, so it was juveniles and juveniles in the car together, the like statistically significant difference in fatalities in this simulation. Is that they started doing this risky behavior. They started crashing into things. They were driving over obstacles, driving off cliffs. It was just a major significant difference between the two. And so in the presence of peers, that activates that hot type cognition. That's the part of the brain that is not developed until that age of 25. And that is that thing emotionally charged, and particularly in the presence of peers, when you're trying to impress your peers, when you're doing funny things, that becomes much more dangerous than others. And I'm sure that if we went around this room and I asked the question, what crazy thing did you do with your friends when you were a teenager? I'm sure a lot of us would have some very interesting responses for that, right? It's always interesting to see people's eyes when they're like, So it is. It activates that hot cognitive thinking, and so that's always an interesting thing to ask the question: did you act alone or did you act with your peers? I think that's a very, very interesting thing when it comes to culpability and it comes to thinking about crime. Also, psychological factors, I didn't write it down, but there's that social learning theory. So Albert Bandura, the boba doll, I don't know if you remember that study. There was that he put up this boba doll. That's one of those things that you can, punch and knock down, and then it comes back, and then you punch again, and it goes back and forth. They found that they took a bunch of kids and they put them in a room with this boba doll, and the researcher came up and was hugging and being really nice to the boba doll, and then the kids followed that. That the kids came up and they were very nice, and then they had another person that came up and started punching the boba doll, and the kids followed and did that. That we react to what we see, and that also relates to early childhood trauma. Is that if we see what we see, and what we experience growing up, this becomes ingrained as the way that we see the world and experience the world. So that is that social learning theory. Also, what trauma does and peers do is that when we have early childhood trauma, boys tend to externalize behavior. So boys tend to get externalized behavior. That's heightened aggression. That is delinquency. And then girls tend to internalize, so become more depressed and withdrawn and have anxiety. So these are very important things. I wanted to talk a little bit about the study called the Pathways to Desistance Study. How many people have heard about this study, by the way? Okay, all right. 3 people in the room. All right, awesome. This study needs to be ingrained in every single courtroom across when we're thinking about juvenile delinquency and we're thinking about how we proceed, and also what is the best outcome for kids and how do we treat kids. This becomes a very, very important study. It's the largest longitudinal study of serious adolescent offenders that has ever been done. And it had over 20,000 interviews. So what this was that between November 2000 and January 2003, they enrolled 1,354 adjudicated juveniles from both the juvenile and adult court system in Maricopa County, which is Phoenix, Arizona, and Philadelphia County, Pennsylvania. So Maricopa, we had 604 juveniles, and Philadelphia County was 700 juveniles. The enrolled youth were at least 14 years old and under the age of 18. We had 184 females and 1,170 males. All of these enrolled youth were found guilty of a serious offense, predominantly felonies with a few exceptions of some misdemeanors. This included murder, serious offenses, serious aggressive behavior, assault with a deadly weapon with intent to kill. And each study participant was followed for a period of 7 years past enrollment. Follow-up interviews were every 6 months for the first 3 years and annually thereafter. That what they found in this study, and this study is being currently studied still, like there has been more research that has been done from this study than any other study before or after. And what they found was that naturally, over a period of time, over a period of 7 years, most youth stopped criminal behavior, regardless of their initial felony, regardless of the severity of their charge, regardless of their initial behavior, that most youth, 91.5% of the youth, either decreased or limited legal activity during the first 3 years following their court involvement. What they also found was that institutional placement and the type of setting that the kids were placed in appeared to have little effect on which high-end offenders persisted in offending and which reduced their offending. That's kind of interesting too. It didn't really typically matter if they were placed in the adult system or the juvenile system. It didn't matter if they were placed in the community. Is that still the same percentage of kids tended to either persist in criminal behavior or desist from criminal behavior. They found that longer stays in juvenile institutions do not remove recidivism or reduce recidivism. But what they found was that the presence of community-based supervision as a component of aftercare is effective for youth who have committed serious offenses. So that's what they were able to establish as significant link between, is that it didn't matter if you went to the adult system or the juvenile system. Do you have community-based care after you're released? And that's what they found was really effective. They also found that substance use treatment reduces both substance use and criminal offending. That's the only treatment that they found that really reduced criminal offending. So not necessarily mental health, which is, I'm a psychologist, I specialize in mental health. I would love to see that they said mental health treatment is the key component in that. But what they found was substance use was really one of the keys. So the high-end persisters, that these are that small part of the population that continued to have criminal behavior. What they found was that there was really two factors that had the most impact on future criminal behavior, was the level of substance use that you have and the stability in your daily routine. So do you have stability in living arrangements and work and school attendance? Are you involved in something that is stable in your life? And supported the notion that programming that focuses on increasing psychosocial maturity, that's that prefrontal cortex, if we can activate that, if we can get that going, and if we can focus on responsibility taking, temperance, perspective taking, as well as pro-social efficacy, so that optimism, that enhancing a person's belief that they can make it in a pro-social world. That's what was found to be effective. And we have seen this over and over and over. This has been repeated over and over and over when you're thinking about juvenile crime, you're thinking about what kind of sentence, what kind of punishment is going to be most effective for community safety. This is a really, really important graph to think about, is that, and this has been repeated over and over, even with violent crime, with nonviolent crime, with property damage, with really anything. What we find is that typically violent crime and nonviolent crime typically starts around the age of 13 or 14. That's when we start seeing the shift. And then it has a steady increase up until about the age of 21, 22, 23. And then there's a plateau for 1 or 2 years, and there's a rapid decrease after that. There's a rapid drop off. And so it's interesting to think about this in light of, the current criminal justice system, where we say that we need to lock away offenders for a long amount of time, because it's very, very rare that we're ever going to see someone that is 40 years old or 50 years old go out and do violent crime. typically it's almost negligible, the statistical number of individuals that are going out and committing those crimes. It's typically spikes, and this is consistent with that prefrontal cortex, right? Is that this is when the prefrontal cortex is beginning to develop those regulations and those buffering senses. And this is when it is typically developed, is around this age. And we see this correlation between the regulations of the emotions, the regulations of that buffering system, and the decrease in impulsive behavior and aggressive behavior. Very consistent.
That's crimes per 100 population of offenders, or just
Yes, so that's crime per 100. So,
of offenders, not just general.
correct. Yes,
Sorry.
yes, I believe so. Yeah. And then, of course, we had the wonderful conversation this morning about transfer population, and there's and say, you know, we have this theory that that people that have committed serious crimes are better, and it's better for public safety if we transfer them to Superior Court. It's better for us because these are very, very serious offenders. And so there's been a number of studies on this to say, is transfer effective? Because it's hard to argue against if we can say a study that says the recidivism rate of individuals that go to the adult system with violent offenses significantly decreases once you've been transferred to the adult system and are there for a while and then come out. Is there a difference? Is there a difference between the juvenile system and the adult system? That's one of those $1 million questions, which every time that I'm currently in court, that people ask. Steiner and Wright in 2006 examined the effects of prosecutorial transfer laws in 14 states and found that in 13 states, transfer to Superior Court had no deterrent effect on overall juvenile crime, with the one exception being Michigan, where there was a small effect of it. In 2005, found that transferred youth in Florida, particularly, were significantly more likely to reoffend versus those that were retained in the juvenile justice system. So that was 49% of youth that were transferred were statistically significant, more likely to reoffend following release than individuals that were retained in the juvenile justice system. And that this remained true when taking out only violent crime. 24 for the transfer population were more likely to leave and do violent crime than 16% of the juvenile justice population. In 2003, we also had a study that examined recidivism rates for 2,382 15 and 16-year-olds that were charged with robbery, burglary, or assault in New York and New Jersey. And this study is very interesting. They found 100% greater likelihood of rearrest for violent offenses among the juveniles who were prosecuted in the criminal court than for juveniles that were retained in the juvenile court. That's a very interesting study. 2011, that juveniles transferred to adult court exhibited significantly higher rates of reoffending than those who remained in the juvenile justice system. And 2010, they utilized a sample of 654 juveniles who had committed serious charges, and they found no difference between the transfer rate and the juvenile retention rate. And what we found is that there are a couple of things that we know work with reducing the risk, because ultimately the argument that needs to be made in court is that what is safer for the community, what is going to be safer for us, what is in the name of justice, what is going to work. And what we know is that treatment works and programming works, and we base that on a R&R system. The risk principle, which is a match the intensity of interventions with the individual to the risk of reoffending. The need principle is that you need a target criminogenic needs. And we know that we have something called the Big Eight. These are the Big Eight criminogenic needs that we know are related to recidivism. Those are thinking and beliefs, antisocial personality patterns, peer relations, family circumstances, substance use, education, employment, and leisure. If we can target those in treatment, we know that this has a greater likelihood of non-recidiving. And then responsivity factors is that we also have to look at the factors that are limiting our ability to be able to engage this youth in treatment. And these are things like mental health. These are things like trauma. Is that if an individual is coming to us for programming and they are traumatized and they have a significant trauma, we're not going to be able to do much until we address the trauma first, and then we can get to the criminogenic needs. If you just jump to the criminogenic needs, you're not going to be able to do much. I make the argument that this is why the juvenile justice system exists, this is what we do. This is the programming that is there. And Dr. Freisen, one of my colleagues, is going to talk at the very end of this, a presentation today about all the services that are offered. This is what we do. I spent 7 years in the adult system. I was there as a employee. And this is not what my work was. My work was on the responsivity factors. My work was saying, is this person a good inmate? Is this person going to hurt themselves? Let's talk about their mental health concerns. We never talked about the need principles. We never talked about what caused this person to commit the crime in the first place. That's not why the adult system is there. That's not why psychologists are in prisons. That we are there to really kind of tailor that those interventions to say, is this person going to give us problems in the prison system? It's not to target those recidivism factors. All right, I think I might have like 2 minutes or 5 minutes for questions. Yes.
I have a lot of questions.
Great. All right.
So many questions.
Okay.
But one of them that's at the front is, can you talk about the relationship between diagnosis of ADHD to everything you were talking about earlier? Just explain that if you could.
Sure. Okay, so attention deficit hyperactivity disorder, it's risen in the diagnosis over the last 10 years than really anything before. That it's associated with the prefrontal cortex, is that it's that ability to be able to regulate emotions, be able to regulate your attention span, to be able to focus on what you need to focus on, and to be able to filter out that non-essential stuff, as to be able to be enhanced. Yeah.
But especially as related to, my understanding has always been that kids with ADHD, especially boys, because that's what I've been mostly focused on, mature later. And part of that maturing, am I right in saying, part of that maturing is that the full development and usefulness of the frontal lobes to them is probably further out. Is that true?
Yeah, it delays it, certainly. And it's also really interesting, so I will just tell you a story that in juvenile justice, what we did was about 7 or 8 years ago, we started looking at trauma, and we started to do a trauma assessment for every single person that was coming in. And what we found before we started doing that assessment is that we were given ADHD out quite a bit. That was one of our main diagnoses, was conduct disorder, ADHD, ODD, oppositional defiant, right? That after that we started looking at trauma, what we found was that trauma can look like ADHD. That trauma, when you have an individual that is coming in, we found that the diagnosis of trauma went from the 11th most common diagnosis to the 2nd most common diagnosis that we started giving these kids. And so ADHD and trauma very closely related sometimes. That it doesn't have to be, and there is a real diagnosis of ADHD. We've certainly seen that.
Sure.
There is a delay and it is going to be more difficult. That's, I think the challenge with ADHD is the difficulty of regulating those stimuli that are coming in. And so that all of the stimuli is coming in, and all of us have to regulate that and buffer that. And I think with individuals, with juveniles that are coming in, it's very, very difficult to say, what should I regulate? What should I buffer in? And what should I buffer out? All of it's interesting, you know? And so you know, there's also been a lot of research recently to say, you know, the positive effect of ADHD as well. The ability to be able to super focus, for example. So it's very interesting. There is a correlation of aggression in ADHD. There's a high proportion of our kids that come into our juvenile justice system, into the adult correctional system, that have ADHD. And it's a good question.
Can I just keep asking questions?
I'm fine with that.
What do you, in terms of, and the reason this is so important to me right in this moment is we're facing a hearing where we're going to recommend to a judge programming for our client, both as a way of trying to help him, but also as a way of demonstrating that he wants very badly to turn, for lack of a better word, put it very simply, just turn his life around.
Yeah.
So he's going into adult correction though.
Yeah.
What programming, I mean, I have a few things that I've come across on my own. It's very hard to find out what DSE offers.
Yeah.
And where.
Yeah.
And I'm just wondering if there's some general, and maybe I could bother you about this later.
Is it a juvenile or is it
He was charged as juvenile, now he's 18.
Gotcha, okay. So he's gonna be going to either Foothills, is it gonna be
Probably
Foothills?
Foothills, would be my guess.
Okay. Yeah, so there are some, I mean, obviously that there is a requirement in the adult system of providing education. If education is there, then we certainly need to provide that. There's also some programming for work skills and be able to do that. There's also offerings of Thinking for a Change, which is something that the adult system offers quite a bit. You have to elect in the adult system to have a psychologist. You have to say that you're interested. It is not offered to everyone. In the juvenile system, we match that from day one, you are matched with a psychologist or focused on health protection. You have a social worker, you have a psychologist that is automatically matched. In the adult system, you have to elect to do that.
Right.
And so I think that's a really important thing to just let your client know. But you have to actively seek out programs. They are not readily offered and they're not mandatory.
Right.
And so you have to really kind of do your homework and be able to kind of navigate that. It's a very confusing system. And a lot of times the programming offering is not, put out for everyone. And so I would say that the best thing you can do is talk to your case manager, and then also elect to see the licensed mental health clinician.
Right.
And say, once every 45 days, you'll see someone and they can help guide you through the process as well.
Thinking for a Change is a CBT type of work. Okay.
Yeah.
That's what I thought. Is EMDR offered to kids or offenders?
Yeah, so EMDR is one of the evidence-based programming for trauma. So in the juvenile system, we do a lot of trauma-focused CBT, TFCBT. We have one or two clinicians that are trained in EMDR. EMDR is one of the system that has probably the most evidence about treatment effectiveness for trauma. Because what we find that there's a great book called The Body Keeps Score. If anybody wants to understand about trauma, it's written in a very accessible language, which, I was kind of intimidated. I was picking it up going, this is going to be super, super deep, but it's very informative, very interesting. And what it talks about trauma is that trauma is stored in our body and we don't even know it. Right? Because a lot of times that trauma happens, particularly for early childhood trauma, it happens in the pre-verbal time in our life. And so we don't understand it in words, we can understand it in our body. So they had, I can talk about this for a long time. I'm like running about it.
I'm sorry, I
yeah.
Just like the broader question, is this too much of a generalization that the greatest influence on recidivism is time?
What do you mean by time? Tell me about that.
Just aging out, because you talked about these programs, not so much maybe not mental health, but substance abuse.
Yeah.
Increases recidivism, but it seems to be this time out, not to be, I'm trying to find
Yeah.
time out.
Yeah, I think time is a very important thing. And if you can speed up time, meaning that you can speed up development by having programming that focuses on what are those skills that we need to speed this up. And so, for instance, like psychosocial maturity, is that how do we speed that up? Let's think about, what is going to give a person a sense of responsibility. That's what the military is really good for. So you can take an 18-year-old that doesn't have a fully developed prefrontal cortex and put them in situations where they're gonna have to be more responsible. And they're going to have to be placed in situations where they're being exposed to, life and death situations. And so that does increase maturity because you have to do that. And so can we replicate programming that kind of hyper speeds that psychosocial maturity? And that's what we're trying to do. One of the things that I find, I'm so sorry, I'm rambling on, but restorative justice, I think restorative justice is one of the areas that I find to be one of the best tools that focuses on that psychosocial maturity, ability to take someone else's perspective, to be able to, so we're trying to do circles within our facility, is the ability to be able to delay gratification. These are all skills that if you can really infuse in someone, we know that leads to production. That's a good question. All right. Thank you so much.
10-minute break. We'll be back here in lunch. There's snacks out here for you all.
Okay.
Bathrooms are down the hall.
Excuse me, can I maybe give you a call or send you an email?
Yeah, absolutely. I realized I didn't bring my card, but I can. Yeah, I can, there's my information. Of course, then email.
No, it's there.
Okay, yeah. I've got
that for you. Yeah, that's.
They all have different fee structures, and it doesn't say like related cases. I'm having to go through the suspects list, that was like.
So I know we're.
I brought one too, but she took hers out first, so.
Someone else.
I brought, I think yours doesn't, I've got left, but. It looks like one of them does.
Yes, certainly. There's 15 right now. That are
Yes, ma'am.
You should have seen
Yeah.
Dawn and myself this morning.
That is a mess.
Okay, that's what
Actually, really.
You're just like, there's something else.
1, 2, 3, 4, 5. Girl. So I was just like.
I think, so there is,
And it was like, oh, she would never
written
do
into
this. Trust
the
her, she only
statute
has
for
two cases on the
HHS,
calendar
there
at
is
one time. I was like, well, it's a good
there's a
thing that this is
grandfathering
the state
period
of
where
great personality.
established,
And
and
then
you've
not
been doing this for a
statute.
while, you can still
And then
continue to do it, or I think
We
you
get a bad judge. Anyway, so I was just
you
like,
have to go through
all right.
the process. So I think that if you already have experts like this,
Judge, you say, prove it wrong.
it's supposed to go through AFC, with my understanding.
She goes off.
Sort of. She's just like, she's talking about the hack. She's talking about they don't see the same calendars. And then she said, because Wake County puts out a little Word document every week saying, here's the trial order.
Yeah.
So Dawn said, it's so simple.
Yes, and I was hoping when we were working on this legislation, and somebody mentioned that this is what AOC does, and that they're currently working through the process.
You're a closer. You're a closer. See, I had her boxed in, but I was done. There was no kill. There's nothing to be done. But Dawn came in and said, we don't have to kill anybody.
They don't have to worry about the funding for remediation.
But they're doing it.
Okay.
Yeah.
Yeah, so the state,
Doing that.
so JJ is
I
funding.
I think there can be a lot of things to talk
We are,
about. I have no idea.
we have
Okay, well,
already
that's fine.
aligned.
You know, how many people are online, expect, I need a lot of feedback.
JCPC
So they're
doesn't have to
wasting
worry.
their funding.
Correct, yes, correct, yeah. The state is gonna be like, that's a state-funded, program.
I just never up that person. I do too. So much.
Oh, okay.
About,
So.
so.
Last we did another. They're like,
I'll take that. That's a really bigger person.
Gotcha. Okay,
He needs help.
yes, yeah, absolutely. I would love to do that. Yeah, that's one of the things that makes me happy, you guys. It's going to court, talking about that. Yeah, so a person to talk to is, DHHS is, Bob Cochran. He's the person that is running the Forensic Evaluation Center for DHHS and is the Director of Forensic Services. He's the person that is over the credentialing board. He's a very easy, approachable person. So I can write him also, and I can give you.
Yeah.
How's it going?
You don't see it.
I know. We're good.
That way we
Absolutely.
can
I don't have. The only
get
case that
questions
I've got
around
in
to
your
appropriate people.
district is
That's the
Clarence Hayes.
Clarence. I like
Which is like,
Clarence.
yeah, I feel bad.
I feel bad.
I feel bad for Clarence.
I used to fuss at poor Clarence. I've had him.
Yep. No, that is something that we've been very concerned about is trying to, and I think for the first year.
One time I grabbed him by the ear, like, come here.
That's, so that's really something that.
So we're still pending only because we're kind of waiting to see what happens with all the other coding.
That's something.
Yeah. No, that was the first case. Why last year.
Absolutely.
We were talking.
Yeah,
at
remember, I
CLE.
called you.
Yes,
Yeah.
yes.
She can call, had an issue, had to get, and she answer questions for other people.
Gotcha.
Hey, you gave me his number.
Maybe we.
Well, no, not that I gave you a number. He was a little upset that.
Explain that to
Yeah,
people.
I would love to do that. Yeah. Maybe Jackie Green was with that too. Yeah, that would be really good.
Yeah.
She's the person I always go to for blog posts.
I found out that young man.
Oh, yeah. Absolutely, yes. And she pointed out several things that were, this doesn't make sense and this doesn't. I'm like, I know. We tried. But
He needed an attorney.
And when I talked with the sheriff, he's like, well, I don't even know where he is. I was like, there's somebody outside. Don't you? Are you telling me your employees are not telling you where they are? So we finally get to him. He did come back after, and he gave him my card, right?
That was in session. There's
He was
no
still-
reason on earth that remediation would take.
Sheriff was
Typically, it's
real
3
upset.
months.
I thought this
Good,
was.
it's a month. You can have a
Well, I
second.
appreciate that you
And
did.
I told
6
him.
months.
I didn't,
There should be no reason for that.
I don't know how these kids with the way they think about this process stuff, it's 3 years out from the event, they're gonna, what are we still not caught?
Right, exactly, yeah. That's exactly that's the problem right there, absolutely.
Oh, good, it's like every client I have ever had.
Yes, absolutely, yeah, of course. I'll write down my.
Telling you,
It's on your
you have to
stuff.
serve.
Okay, good, okay, perfect.
I might send you a note if it's all right.
Yes, please, yeah, that's honestly one of my favorite things.
You know, you kiss the attorney.
potential.
I
I know you
Are you
haven't.
available in?
Yeah, going to court twice a year.
We can fight about it, but we'll be an attorney.
I mean, if you wanna.
He hasn't discussed that with
That's what I'm trying to.
Well, and it doesn't happen often.
Practicing in that I advocated, that's one of the things I'm gonna talk about.
get these things transferred to us,
Put me up.
like, and she's like,
You have a.
does it a lot, like, so she can over.
All I can do is just quote.
Who?
Right.
I would have to look up the documents.
I wanna know if it's a name already on our radar.
This issue though.
And they will send us.
I'm worried that it's her, okay, so.
Would you
I-
recognize the name?
Yeah,
I did it, and I'm already,
Well, that's pretty good.
I'm self-employed.
I know, if I had, 'cause I am
I
too.
wanna go.
That does.
To try.
Oh, okay, thanks, Michelle.
That's nice that your core counselors do that.
Well, I mean, I guess here's.
This transfer case, it's the same name.
Yeah.
Other issues.
I mean, usually when they call and tell us, they're already.
I'm not sure what the,
Yeah.
Well,
You called them and say, yeah.
yeah, she had dates.
First of all, the disposition of the history. So she's going back to that flat. Because our was like, she just not have to pass.
See, not the stock. So I was like, you know.
So I would say all of this.
So I've done a deep dive on Alfred, by the way. There isn't actually a necessity to admit to these about actually doing the things. We don't actually remember anything. But if you needed to go back.
Check the Alfred box.
It's not really like truly even necessary.
It does matter.
We did.
once they turn 18.
Yeah.
So
He's still not.
we raised capacity.
Actually, the majority of them.
Is he at Central Regional or is he at County Jail?
Is they're going into court. And the adult system now is out. So, whereas in the juvenile system,
Everybody worked away my.
so that, I thought that was really interesting, is that even in the system.
How are you?
It was like.
So, the other Tucker, right?
Yes,
That
yes.
used to be Kevin Boxberger, he took a judgeship in Waits, we can read from the Wayne Kevin's office to his disposition.
I would be happy to.
I put them on my calendar.
And I was like, I cannot see, I cannot see out. So I was in there, I'm on the ground, that was it.
Yeah. It's, after working at.
Somebody made a comment about it.
Personal mission.
Everybody, we're gonna get that down. Good. Yeah, I'm glad. Let me know if you need any diesel rigs.
2010 to 2017. I worked at.
Yeah. All right, we are getting started with round, what are we, 3? Round 3. Ding, 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 ding.
I got my first job.
Well, we're gonna start back. I'm so excited to have Robert Singalese here. He's an assistant capital defender. He gave this presentation for us a few times, so I'm so grateful to him for that. He has been with the Capital Defender's Office since 2015. Prior to that, he was an assistant public defender in Charlotte, North Carolina, and also a fellow at the Equal Justice Initiative in Montgomery, Alabama. We're excited to have him talk about Miller, sentencing, and a little bit about mitigation as well.
So I handle entirely adult cases, adults that are charged with first-degree murder. And my one takeaway is that you need to treat these cases like they are capital cases. You need to do all of the same work that I'm doing in these adult cases, because your clients can be put in prison for the rest of their lives, which of course means 50 years, right? 60 years in some cases. So you must treat these cases like they are capital cases. That is the work that you need to be doing. Miller hearings are distinct from capital sentencing hearings in important ways. You've got a judge instead of a jury. Usually that is unfortunate. The statute only lists mitigating circumstances, and the mitigating circumstances are different. But you've got to do the same work. The same work. The presentation is going to be in 2 parts. First, we're going to talk about the law. Even though this is the 3rd time I'm doing this presentation, the law has actually changed, and it's changed in a not good way for our clients. And so we need to talk about that. The second part of the presentation, I'm going to show you a PowerPoint that I used with my co-counsel Christine Maloney in a capital case in Alamance County in the fall. And in that PowerPoint, we included lots of the resources, lots of the direct records, right, about our client's life. And so I want you to see what you need to be collecting and then how you're going to use it, okay? For starters, when you get this case, you need to hire 2 people. Absolutely, you must hire 2 people. One is a mitigation specialist. I hope everyone here knows what a mitigation specialist is. Does everybody know what a mitigation specialist is? Awesome. You cannot do this case without a mitigation specialist. You also cannot do this case without a mental health professional. I am glad that I got here in the previous presentation, Dr. Coons, it was like, that is what you need. You need a member of your team who has that knowledge. You cannot competently do these cases without a mitigation specialist and without a mental health professional, particularly one who is versed in adolescent brain development.
Say it louder for the people in the back to hear.
Adolescent brain development. You must have a mental health professional and a mitigation specialist. Okay, the mitigation specialist, and I know there are folks on WebEx, this is a person who's going to spend a lot of time with your client. It's a person who's going to spend a lot of time with your client's family members. It's a person who's going to collect records as you are finding out where your client went to school, where your client has been hospitalized, where your client has been detained. You're also going to be getting information and records about your client's parents, right? You're talking about juveniles and teenagers. Their parents' lives are going to be really critical to the story that you need to tell. They're going to help you identify your mitigation themes and ultimately your list of statutory and non-statutory mitigating circumstances, which we'll talk about soon. One of my mentors at the Capital Defender's Office, Steve Friedman, very early in his cases, he would talk to his client and he'd say, one of my jobs is to learn more about you than you even think you know about yourself, right? And that's going to be true for you and your clients because your client's not going to remember necessarily all of the things that went into how he was formed, right? Because a lot of this trauma that the doctor was talking about recently, that's going to happen in your while your client is maybe 3, 4, 5. And that matters. And your client may not remember it, or your client may not be able to tell you about it, right? For all sorts of reasons. So, mitigation specialist, and then in terms of the mental health professional, I don't have to add more other than to say, I bet that many of you sort of have that, well, that's my psychologist. That's who I go to, okay? And that's fine, usually. But I just want to ask that you think about the client who was sexually abused at 8 versus the client who was recruited into a gang at the same age versus the client who falls somewhere on the spectrum. You may not necessarily want the same expert for those 3 kinds of cases, okay? So you need to learn a bit about your case and your client before you choose your mental health professional. That's my opinion. My opinion is day 1, you get a fact-in investigator and you get a patient specialist. Maybe month 3, month 4, after you've kind of figured out some stuff about your client, you're then going to decide this is the mental health professional that we need. There are always exceptions. If your client is actively psychotic, you want the mental health professional on day 1, right? So you have to make, that's a judgment call for you. Let's talk about the law. Roper versus Simmons is the first case that kind of starts this adolescent brain development. Juveniles are different than adults, right? So you can't execute somebody who's under 18. And Justice Kennedy gave 3 primary differences between adults and juveniles. Lack of maturity, they're more susceptible to outside influences, and the character of the juvenile is not well formed. Okay. Next is Graham versus Florida, which said that a juvenile cannot get life without parole for a non-homicide. These are all United States Supreme Court cases. Next, Miller versus Alabama. This is why we're here. Okay. Mandatory life without parole, unconstitutional, even for juveniles convicted of murder. In the previous presentations, I used to tell a long story about working for Brian Stevenson, and that was mostly to name drop, but the bottom line is, when I was working there in 2006 to 2008, they were picking their clients. They were across the country. Whose cases are we going to take? And little new law degree said, this is crazy. This isn't what the law is. This is never going to happen. Roper wasn't about life without parole, right? But Brian and the lawyers that he collected had this vision, and 6 years later, the United States Supreme Court agreed, and the law was changed. And so the bottom line for you is, you may think that motion is not going to win. Okay? You may think that that issue is not going to work. File the motion, make the argument. The court that is in charge today may not be the court that's going to be in charge when your case gets there, right? So make the argument, file the motion. Montgomery versus Louisiana simply said that Miller is retroactive. So that's only relevant to you in terms of you might have a resentencing hearing as opposed to a new case, okay? 5 years later, different court, you start getting different judgments. Jones says that the United States Constitution does not require a specific fact finding of permanent incorrigibility before life without parole can be imposed. But the court said that this doesn't preclude the states from coming up with their own rules about this. That was good for us for a while. This was the Miller fixed statute. Okay, this was passed days after Miller came down, and that's because everyone knew this was at the Supreme Court, and this is how it could go. The highlights, it's life with parole, means you're parole eligible after 25 years. Felony murder cannot get life without parole. Felony murder alone cannot get life without parole. And of course, the statute includes the factors in the procedure. One of the first cases that the Court of Appeals decided, this is actually my case. I lost this case at the trial level in Mecklenburg County. The reason I had that, it was a resentencing. The original trial attorney had passed away. But the original judge was still around and came back and made sure to sentence my client to life without parole again. And that's because one of the provisions of that Miller fixed statute is the original judge can retain jurisdiction. In this case, we called a psychologist, a social worker, my client's sister, a former Taekwondo instructor that my client lived with for a few weeks. And we even called a mitigation specialist to explain how she had collected all of these records. We put in hundreds of pages of records, right? I want to show you one example because this was a little unusual. My client had talked about how his stepdad had assaulted his mother and had gone to jail. And I wondered, oh, maybe there was a case about what happened to his stepfather. And sure enough, there was. This was in Virginia. This was an appellate decision. And this is my client in the middle here. Upon entry, defendant, who's the stepfather, was confronted by, I always get upset, James's 9-year-old son, that was my client, armed with a stick to try to protect his mother, right? And that is, that was my client's life, right? And the appellate court described this. This is trauma. This was normal for my client. And this is the kind of stuff that your judge needs to hear, needs to know about. You need to find out about it. You need to get the proof, and then you need to present it, okay? And the only other thing I'll say about that is David Andrews actually won this case on appeal, so he cleaned up my mess. And the case went to the trial court again. And on round 3, the Mecklenburg County District Attorney's Office agreed to parole eligibility, which is an important point. And that point is you need to do all of this work to be prepared for your hearings, but you are always looking for an off-ramp, okay? I don't want to be picking a jury in a capital case. That's never, 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 never good, right? We do it when we have to. We can get, in my work, a life without parole offer. In these cases, a second degree offer or a parole eligibility offer. You're always looking for that off-ramp. You do not want a trial court, a superior court judge who is elected by the people in the county to decide what to do with your client who committed a terrible crime. You don't want that. Okay, so there were two great cases in 2022. We're going to go through these quickly because they're largely no longer law. State versus Kelleher. The Supreme Court said that the cruel or unusual provision in North Carolina offered greater protection than the Eighth Amendment. Also specifically said that, cruel or unusual, and then juvenile offenders are presumed to have the capacity to change, right? It is the exceedingly rare juvenile who cannot be rehabilitated. And State versus Connor, I think it was released the same day or the same week. Same gist, right? Juvenile offenders, they must have the opportunity to seek release. And Connor was an interesting one because it was like a 40-year. Connor, they equated more than 40 years as life without parole. And so the ruling was if you get like consecutive sentences, right? I forget what the crimes were, but if you get consecutive sentences more than 40, that is unconstitutional. So the state of the law was pretty good. 2022, 2023, 2024. This year, in January, State versus Tirado. North Carolina Supreme Court says that Article 1, Section 27 does not offer more protections than the Eighth Amendment. Chief Justice Newby, writing for the majority, says that the state cruel or unusual provision will be interpreted in lockstep with the Eighth Amendment. Okay, so now we're relying on the United States Supreme Court to define what is cruel and or unusual. Justice Earls concurred, said all that Eighth Amendment that's dicta. All that language is dicta. But last week, and don't accuse me of recycling PowerPoints, this is off the presses. Last week, the North Carolina Supreme Court said lockstep, right? This is how we are now going to interpret this, the cruel or unusual. It's going to be consistent with Eighth Amendment. State Constitution doesn't offer any more protections. State versus Sims or Laves, I think is how it's pronounced. So 3 juvenile murder cases decided by our current Supreme Court, 3 life without parole sentences affirmed. Okay.
It doesn't sound so rare to me.
It doesn't sound so
Rare.
no. Well,
How rare.
right. Well, precisely. Now, what they actually say in Borlase is, it is the discretionary sentencing protocol itself that will help make sure that it is relatively rare, right? So we just give our Superior Court judges discretion, and these sentences will be rare. I also have my doubts about that. David Andrews, whose contact information is going to be on here in a second, essentially says they have unbridled discretion at this point.
Use of discretion, basically. What we're used to in the district court realm, that the judge has to be absolutely crazy before you ever rule on.
And I think that's right. Here we go. This is Borlase. In the absence of express evidence that demonstrates that the sentencing court did not consider mitigating evidence or exercise its discretion, we will not presume error. So I don't know. I mean, it takes a brainstem for the judge to be able to write, I considered mitigating circumstances. That's all they've got to do now. I considered it, and in my discretion, life without parole is the appropriate sentence. So it's unbridled smart discretion, I think is how I put it later, right? As long as they cover their bases, our appellate courts are not going to help. I did want to highlight a little bit of the language from Kelleher, because I think these were helpful. And while the holding or the ruling of Kelleher is overruled, the court acknowledged that it was wrong to describe children as predators, right? And so if your DA is doing that, you need to object, you need to point out that that is, I would say that that is still correct. The court expressly talked about ACEs, which is great. The last presenter talked about ACEs. Hopefully everyone here is familiar or familiarizing themselves with the concept of adverse childhood experiences, but it's super important. The chances of your client who's charged with a first-degree murder that happened between the ages of 13 and 17 not having ACEs, I would say is 0. So you need to know about that, and the court acknowledged that. And, you know, a child is still a child. I don't know what I did there. A child is a child, was the language from the court. So bottom line,
I have a question.
this is shutting down. That's what's happening. Yeah.
So, something that you said is kind of, I might be naive to this because I have only done a few of these cases, but so you said that if we get an offer for like, you know, a term of years or a parole, a life with parole sentence,
Yeah.
we should strongly be considering taking that, obviously. But like what you said is basically we should.
If your client is going to be convicted,
Yeah.
if you know your client's going to be convicted,
Well, how do we know that?
well, you know the evidence, right? So you know the evidence. So if it is highly likely that your client's going to be convicted of first-degree murder,
Right.
and you have an opportunity to plead to second,
Right.
you need to plead to second.
Okay. So even if it's not highly likely, we should probably still be.
I'm not gonna,
Right.
like, you gotta use your judgment. And it's also, I mean, I'm saying this as though I'm the decider, right? I'm the agent, the principal. The principal is your client, right? So of course it's your client, but our job is to counsel our clients. The difficulty that you have is you're counseling a teenager. It's really hard to do.
Right.
But yes, in my job, if I know that my client's gonna be convicted, and I can pretty much know sometimes that it's gonna happen, and I've got an opportunity for him to have a release date, that's the choice. That's the release date. And I am spending the time that I can with my client to get him to trust me, right? I'm not even talking about all of that. I mean, the work that you have to do for these cases is like, it takes a lot of time, and building rapport and trust with your client who's a kid, that's gonna take time. You're probably gonna need the support of their family members, right?
And a lot of times they have people in their ear telling them that they just have some public defender or like
Absolutely.
trying to hire a private attorney in the meantime and like,
Absolutely.
just letting the kid know that this is just like a placeholder kind of. So that's all of
They're
that.
waiting for their real lawyer.
Right, so all of that, and then if you sit there and tell them like, I think you should take this deal instead of going to trial, I think that like, how do you do that?
How do you counsel your client?
No, it's just, I don't.
Yeah, it's
foresee
hard.
that I don't foresee that happening, because it's just like, if you sit there and tell them you need to take this deal, they're gonna think, oh, you're just saying that because you don't wanna.
Okay, so here's a war story that I wasn't gonna tell, but I had a client, he was 16 at the time of offense. It was him and another 16-year-old go into a house. They don't kill anybody, but they commit a terrible crime against a woman in the house. They're both charged. There's DNA, right? I am confident that my client will be convicted. Right? I spend a lot of time with my client. A lot of time. We go through the stuff. I'm friends with his mom, right? If your client's moms don't have your cell phone number and their cell phone, there's a problem, right? They need to be able to talk to you. You need to be able to reach them. That is the relationship that you have to have. Ultimately, my client pleads guilty and gets 31 years. 30 or 31 years. Co-defendant goes to trial, gets convicted, gets 47 years. I went back, thing is, Mecklenburg County Jail, you can see who visits. That client's lawyer visited him twice before trial, from arrest to trial, right? 2 visits from your lawyer. So that 17-year-old, he's not gonna jump on a 30-year plea, right? Because he doesn't know who his lawyer is, never mind trust his lawyer. So part of the work I think that we all have to do is to get our clients to trust us as best we can, and that's super hard. It can be super hard. And your client might trust you and still ultimately say no. But What you need to be able to do is trust and go to bed at night knowing that you did everything you could to help your client, to try to convince your client to help himself. Okay.
Thank you.
You're welcome. That was Kelleher. Bottom line, Kelleher and Connor are all but dead. The North Carolina Constitution does not offer more protection than the United States Constitution. Trial courts have smart, unbridled discretion. I think the 40-year rule still applies, but you know, it's a kind of unique circumstance, and it's basically gonna, I imagine if our current Supreme Court gets an opportunity to overrule the 40-year rule, they will. So what's the bottom line? You need to win at the trial court, right? No pressure, but that's what you need to do. Or, this is what we were talking about, avoid the sentencing hearing altogether, right? This is some federal case law that David Andrews put together. And this is just, you know, this language comes from mostly capital cases, but they can't ignore mitigation, right? If you present mitigation, they can't say, you know, this means nothing, right? And so these are some cases to show that it does mean something. This is Justice O'Connor. This was a capital case, but again, this is a reasoned moral response. That's what we're asking for from our judge. This is David Andrews' advice. Avoid the trial judge, right? Get a plea to life with parole, or better is second-degree murder, right? You want a release date. At the charge conference, so this is if you went to trial, if you're in trial, ask for all of the lesser included offenses and cite due process. Okay, so I don't know what your trial theory is. Ask for all of the lesser included offenses to first-degree murder. Identify and submit a written list of statutory and non-statutory mitigating factors. What that means is, you know, there's the mitigating factors that are in the statute, but then number 9 is catch-all, anything else that's mitigating, right? Provide a written list to the court, right? Because that's going to help on appeal if the court denies your relief. If the trial court ignores you and sentences them to life without parole, your appellate lawyer's got something to work with because you submitted a written list of factors. How to deal with mental health professionals. Object to a sentence of life without parole after the judge says, thank you, but life without parole. Object facially and as applied. And this is David's email address. He currently has a case, State versus Stancil, Stancil. His brief isn't due yet. It's going to be filed, but in that, at the trial court, evidence included evidence that the client had suffered serious sexual abuse. Evidence included indictments, a sex offender evaluation of the perpetrator on the client, a written transcript of plea and judgment. The trial court described the evidence as tragic, but that it carried, quote, no or little mitigating weight, right? I don't know what to say. That case is on review. The essential argument is due process requires that you give something like that mitigating weight. That is outrageous. Okay. So that's the end of that. And let's go. How are we on time? What time is it? Oh, okay. So this is, I had to include this. This was my co-counsel, Christine Malumphey, her slide. She kind of just wanted to, you know, give the judge a little, because during jury selection, we asked jurors about mercy and their ideas about mercy, and we were not allowed to ask about mercy. And so, in closing, we just wanted to point out that Justice Scalia talks about mercy, a very merciful man, right? And so that was, I just wanted to share. This is our client, Haquan Parker. So it's me, Christine Malumphey, Richard McGuff, who's in the room, was the first mitigation specialist. Kara Richards Baker helped, he's the second mitigation specialist after Richard's retirement. Haquan was charged in a triple homicide in Alamance County. He had a prior second-degree murder conviction from when he was 14 years old. He was a very committed criminal, and his AKA was Hitman. Okay, so I am not bragging. I am saying these are hard cases, right? So you do not ever think there's nothing that I can do with this case, right? All of these cases are terrible. This was a particularly bad. There's video of my client leaving the apartment with the rifle, right? So I knew he was going to be convicted, right? We never got a plea offer in this case. So there really wasn't, we didn't have a choice. I show all of these, and I said really eloquent things to the jury as these pictures were up. These are the things you need to collect, right? Your mitigation specialist, you're in your client's mom's living room. Look at the walls, right? Look at those pictures. This Haikwan with nephew. And what are we doing, right? We're telling a story, right? We're humanizing our client. The story that the state is going to tell in your case is real easy. It's the crime. It's the blood. It's the gore. It's the violence. The story that we're telling is our client's life, right? We are humanizing our client. I admit, I confess to you, I think that is easier to do with a jury than with a judge, right? I get that. And that's why these juvenile cases are particularly hard. But I have it on good authority, some superior court judges have hearts. Some of them will consider this evidence, right? You have to. You have to, and whether or not you think your judge will, you need to do all of this work anyway, because if your client is sentenced to life without parole, there's going to be an appeal, right? So if you find out things about your client and it's not in the record, it's not going to help. What we were telling the story of our client was that he had these boulders on his back. These were all of the things, right? These are ACEs, right? FASD is fetal alcohol spectrum disorder. Neglect, which we'll get into, household dysfunction, community violence, substance use, and poverty. These were all of the boulders on his back. That doesn't mean that he didn't have agency. He always said, yes, Haikwan made choices, but his choices were limited, shaped by his life, most of which were things that he did not control. We had 2 experts talk about fetal alcohol spectrum disorder. We had a neuropsychologist who did the testing, and then a medical doctor who talked about fetal alcohol spectrum. We also had a psychologist testify, and she talked more generally about ACEs in our client's life, right? I'm saying all of these things because these are the kind of things that you just need to be imagining you can use in your case, right? FASD is not going to be for every case, but you need to figure out, and if it maybe is in your case, you need to get the experts to talk about it. Okay, this is an example of medical neglect, right? County of Durham Health Department, November 16th, 1994. This is because our client had tuberculosis when he was 1 year old, right? He received 6 months of directly observed therapy from our outreach worker. He had received his medications inconsistently from his mother for a few months before therapy was begun by the health department in May. So this was, our client's 1 year old, he's got a communicable disease, and mom isn't consistently giving him his medication. So the county health department actually stepped in. Did we learn that because mom told us that? Of course not, right? So you need to get these records. So we got hospital records, which you can get with a waiver from your client or a court order. Hospital records show, oh, he had TB when he was 1. Now I know that I'm going to try to get records from the health department. We get lots of court orders in these cases, right? A subpoena will work for some things. Your client's waiver or release will work for some things, but sometimes you need a court order. Those court order applications should be ex parte, right? The district attorney does not need to know, has no right to know, frankly, what you are working on as it relates to your mitigation. So if anybody has questions about how to do that, email me and we'll talk about it, okay? Email, I'm not trying to take your job. Email who? Email the juvenile. This is where he lived, right? The Hoover Road projects. This was the his childhood home. This picture, you couldn't like go and like take a picture of it now. UNC, they have, the Durham Herald Sun was the paper. They have the archives at UNC Chapel Hill. And so we had a student intern who went and got the best picture we could get of Hoover Road. Just ideas, right? Like think about your local paper, right? If they don't have their archive, somebody probably does. And pictures, jurors want to see this. Judge want to see it. This one, okay. This was a lot of work. Police data about crimes is generally open data. It's public information. So we got all of the information from Durham Police Department from the date of our client's birth until he was 14 when he was arrested and charged with murder. And then we got a guy from California. He's a geospatial criminologist who crunched the numbers. And it turns out that our client lived in 2 of the poorest tracts. These are census tracts in Durham. And then this was the crime rate. I haven't shown it here, but what we did was we did this. We did a median income tract, and then we did the wealthiest tract, right? And that wealthiest tract was this color. The median was this color. And then this was where our client lived. This is a really important part of the story, and it's an important part of the story because our client was on the streets at 7. This was a police report we got. How we got it was you get a court order for the police department to release all reports that have your client's name in it, your client's mom's name in it, your client's whoever in it, and all of the addresses that you know your clients lived. You're going to end up with a lot of stuff that you don't use. We probably have over 10,000 pages of records in this case, and we used maybe 20 clips in the closing, right? So this is work. This is hard work. I don't say this to everybody, but like this work isn't for everybody, and like that's okay, right? Like, but if you're taking these cases, this is the work that you need to do. And the narrative here, if you can't see it, he was last known. He's last seen July 27th at 10 o'clock in the morning. It was reported July 28th, 1700. That's 5 o'clock. That means from 10 a.m. on Thursday until 5 p.m. on Friday, he was missing. Mom didn't know where he was and didn't report him. And in my closing, I went through all the things. I have a 6-year-old and a 4-year-old, all the things that you do with your kids. From a breakfast time to the next day's dinner time. All those things that obviously weren't happening in the Parker household, right? That stuff matters. This is the reporter. Mom's the reporter. So this matters because he wasn't at home. The last presenter just talked about one of the 2 things was substance abuse and stable home, right? I didn't know about this pathways to desistance study, but I need to because that would have been part of Haiquan's case. This wasn't a one-off. When he was 12, he was gone from Sunday to Wednesday, okay? On the streets as a Crip in the highest crime rate census tract in Durham. Another nice thing about doing this case in Alamance County, I don't recommend doing a lot of cases in Alamance County, but Alamance County jurors have ideas about Durham, and those ideas were consistent with the story we were telling. Right? So if you end up in a place with particular jurors, use that. That's our job. So at 12, we talked about that one already. Again, census tract. Okay, DSS. Now, DSS records are tricky. Every county has a DSS lawyer. They're actually really easy to work with in Durham. I am struggling with 2 DSS lawyers as we speak in other counties, which I will not name. But you ultimately can get these records. You just got to go through a bunch of hoops. You do need a court order, that's for sure. And mother leaves the children home alone at night while she is out playing cards. Children were left in the care of the sister, and while left in the care, sister beat up another kid. Ruby's injuries were so severe that mother took her to the hospital. Ruby is a neighbor kid. So the Parker kids beat up Ruby while mom was playing cards. Principal of the school tells DSS, Alvin, that's our client's brother, is messed up. He's concerned that the mother is involved with drugs and the supervision of the children. And then they talked to her, they talked to mom in 1999. Hey, somebody told us your brother's selling drugs out of the house. She says, that's not true, but I'm not going to give you his last name. I'm not going to tell you who he is. Right? This is the stuff that the jury needs to, that your judge needs to hear about. Again. Chris Lyles was a counselor that Richard talked with. And he remembered in first grade that he had to bring Haekwon to the emergency room because he had a rage incident, right? So you need to get these records. And mom, does this say here? Mom says he behaves himself at home. Every time they talked to her, there were no problems at home. That was her story. Again. Okay, this is brother, right? And so part of this was letting the jury know the house that our client grew up in whenever he happened to be home. This is his brother, Alvin, actually has a worse mitigation story, I think, than Haekwon. Upon arrival, I spoke to Ms. Parker, who stated that her son, Alvin, had threatened to cut off his sister's head with a kitchen knife, then took the knife and stabbed the living room couch several times and a kitchen chair. Okay. That's what's going on if he happened to be home. This is Alvin, and this is Haekwon, right? That is pretty darn young to be throwing signs. Both brothers were dedicated Crips. This is a picture of our client's abdomen. It's a brick wall. The names are peers, friends who've been killed, and he consciously kept bricks empty so that they could be filled in. We got into a whole thing about gangs and what that means. Gangs are very double-edged, right? But there was no escape. By that I mean it's mitigating, but it's aggravating, right? People are afraid of gangs. There was no way to tell our client's story without talking about gangs. And so sometimes Terry Alford, who consults capital lawyers across the state, says you need to embrace the bad facts, right? You litigate them, but if you lose, you then need to embrace the bad facts, own the bad facts. We owned a member of a gang because it was really hard to tell Haekwon's story without it. But this is like right heartbreaking to a normal person, I hope. This was to simply show that he didn't have a father, and I went off for about 5 minutes about what dads do, right? And there's a great quote. Greg Boyle is a Jesuit priest who works with gangs in California, and he says, I never met a homie, gang member. I never met a homie who didn't have a father-sized hole in his heart. And then these are the juvenile court records. And these juvenile court records, what time is it?
7.
Thank you. You know, it's in the PowerPoint, but the juvenile court records simply show that mom didn't cooperate. Mom would go to court and say, yes, I will supervise him. And then the court counselor comes and he's not home. And she's like, well, the court counselor's like, where is he? Well, I leave the door open so he can change his clothes. Right? That was the supervision that was happening. More of that. This is mom visiting our client's biological father, who was out of his life, in prison. This is our client's visit log. 0 times, I don't know if you can see it. Mom visited her son 0 times in DAC. I visited more. And then more eloquent stuff. Our client, he was in first grade. He had a school counselor who helped him try to learn how to read, and she actually kept a notebook that Haekwon had written in. She worked at DPS for like 40 years, DPS, Durham Public Schools. She kept the one notebook one notebook in her life, because she just had this place for our client. So we got to show this to the jury too. So I generally keep it together in front of juries, not always, and that's okay. This is hard work, right? There's a lot to do. Last thing I'll say is, and I think that pathways to desistance thing and the age curve is like so important, and you have to show your judges that, right? Like, because maybe a judge isn't like Robert Singolisi, maybe a judge doesn't give two hoots about that. But what I said in my juvenile case is like, look, Your Honor, you're making a wager here. You're making a wager, and the state is asking you to make a bet in the second quarter. The state is saying, Haikwan's crime was so bad, he's never going to come back. He can't possibly come back. Life without parole is the only response. We're not saying let him out. We're saying, Your Honor, if you give him parole eligibility, that's holding on to your money. And then somebody can see what the score is in the fourth quarter, right? That parole commission will have all the evidence. We'll know what your client's been up to the last 25 years. And then they can make a pretty wise bet with their money about how this case went. That should be a no-brainer, right? That should be a no-brainer. Thank you for your attention. Happy to, I don't know if my email is anywhere, but it's robert.a.singolisi@nccourts.org. Thank you for doing this work with juveniles. And if I can help at any time in the future, please just reach out.
Thank you so much, Robert.
You're welcome.
Appreciate it. So, first of line, we'll break for lunch from 12 to 1. If you order lunch there, if you go straight into this cafe room, it's on the table to the left and they're labeled by name. And we'll be back here at 1 p.m. Thank you, everybody.
Just get a little more emotional.
That's a that would be a lot of power.
I running is going to be listener of my
How are you?
Thank you for your help.
Thank you.
Yeah.
Right.
Yeah.
It's great. Love them.
Well, my boss.
No, that's it. That's the stop right there. She created them. That's all you need to know.
I'll request smaller ones for water bottles.
Okay.
I can put it in a
Oh,
request.
you want me to go ahead? Yeah. Okay. Hi, everyone. You may remember me as my former job as North Carolina State Juvenile Defender. It's also my current job. Those of you who were kind enough to apply for our roster and were approved for our roster, looking at you, John Basinger, might be wondering why it's been a year since you actually haven't been appointed to a case. And don't give me that look, Terry.
I didn't know this.
Two main things happened. The first thing that happened was they changed the law on us. So we had to go back and figure this out and make sure we could still do it. But the second thing really is just logistics. So we fairly recently have made a determination on how the attorneys are going to be paid. It's going to be through fee apps, which is great, except now we have to create new forms. And so we have to work with AOC, who's been very helpful, but it still is a lot of back and forth about creating this because we're copying other forms, but we're doing something from scratch. Believe me, folks, if there was anybody else that we knew who was doing this and how to do it, we would have asked them. But some dummy decided this was a good idea. And we've had to build everything literally from the ground up because there's nobody around who remembers how to do anything. So anyway, I'm sure this is being recorded. All right, so if you have any questions, we are hoping to start appointments this summer. That is the goal. Just stay tuned, but you can always contact me or Terry if you have any questions about what's going on with that. Okay. Our next speaker, Wadrina Biggers. Wadrina is the best example of if you come to trainings and if you make comments and if you make helpful comments and you energize the attendees, guess what? You get asked to speak, and that's how it works. That's why you're not very nice. Oh, you thought it was a lottery or something.
I did.
If you don't know Wadrina, she's the chief public defender in Orange Chatham County since 2021. She's been with that office since 2017. She was in private practice for about 14 years before that. So before that, she was with the Durham County Public Defender's Office. She has a career of public service representing folks accused of committing crimes. The other cool thing I would say, if you don't mind me saying, is that it's great to have chiefs representing youth. Not always the case, and we really appreciate you doing that and setting that example. Thank you very much. Let's have another. Thank you, Wadrina. Let's go.
All right. I'm getting thumbs up in the background because everybody knows, and I have no problem saying it, I don't like talking in front of people, even though I'm a trial attorney. Absolutely hate it. But I love the job, so that's what we do. I'm supposed to be talking about representing the juvenile client in adult court. So when I was thinking about this, I was going, y'all are attorneys. You know how to try cases. You know what you're doing. I don't need to get up here and do a whole bunch of, oh, you need to file this motion, you need to file this motion. But I want to start off with, I think I'm doing this right. Why do you practice juvenile law? Why? I tell you, for me, I go back and think about my life when I was a kid. I refer to those years as the young, dumb, stupid years, from about 13 to about 25. You know, for my sons, I think it's till they're going to be like 27, 28, but young, dumb, stupid years. Because there were some things that if I had been caught, I might not be licensed now. I think the statute of limitations passed. I think I'm safe. But why I really do this is that I think, because I call them kids, those juveniles need someone that cares about them, who remembers their life, you know, your own life when I was that age and the stuff I did. And so when I sit down with them, I want the kids to know, I actually care about you as a person. I care about you as a kid. I'm not going to talk down to you to make you think that, oh, because I have no problems telling you my age. I'm 55 and you're 16. I know better than you do. I don't. I really don't. But what I do know is that we all made mistakes during our youth, during our adolescence period. And I'm not going to let whatever mistake you're accused of define my relationship with you. So that's why I practice juvenile law. I want to help those kids. Now, they're still kids. They're still babies. Because look at this young man. This was all over this news. This face, this reaction was all over WRAL and the news. And by the way, I want everyone to know the opinions I express, they're my personal opinions. They're not the opinions of any agency, state agency that I may be representing while I'm up here, okay? They're my personal opinions. Saying that, the news was wrong for putting this photo up of this kid all over the news because that's what people were seeing. And yes, I have social media accounts, and I saw a gentleman's reaction to this kid saying, it's too late now to be crying in court. You did the crime, so now you need to do the time. I look at this photo, I see a baby crying. Yeah, he's 16, but that's a baby crying. And what the news also reported about this young man is that when he was walking out of the court, as they were helping him walk out of the court because he was losing it, he turns and he looks at his mom and he goes, I love you, mama. That's not an adult. That's a baby. That's another reason why I do juvenile court. Because that young man needs someone to help him get through that system. We've gone through a lot of this today where we talk about know your ABCs, which court, where you starting. So I'm not going to spend a lot of time here. 16, 17, you're starting off in adult court. ABCD, right? You know this one, F or G, mandatory unless you and the ADA agree or remain. Keep it in juvie. There's your H and I's for your 16, 17-year-olds. And then that's why I have the teddy bear, your real babies, 13, 14, and 15. If it's Class A murder, mandatory. If the court finds probable cause or a true bill of indictment, whichever comes first. And then the other teddy bear, anything else that kind of flows in there. Now, this, let's see if I can get this going. I think we were talking about this. Yeah, there might have been some, illegal filming of this movie from Netflix. I gotta see if I can get it going here. But this is the intro to the movie Adolescence that everybody is watching on Netflix. Hopefully you can see it.
Police! Get down on the floor! I haven't done anything. No, you took the wrong house. I'm telling you, you're making a big mistake. Police, suspect found. Show me how. Get your hands in the air. Get your hands in the air so I can see it now. Miss D.I. Bascom, I have a warrant to search your premises, sir. Where's your son? Where's your son? He's in his bedroom. What do you need me going for? Where is he? Hey, he's on your head, man. Okay. Jamie Miller. The time is 6:15 a.m. and I'm arresting you on suspicion of murder. You do not have to say anything but me. Mr. Miller! Mr. Miller, I will arrest you for obstruction. Please stop. Please. I'm arresting you on suspicion of murder. You do not have to say anything, but it may harm your defense if you do not mention when something which you later rely on in court. Anything you do say may be given in evidence. Do you understand? Do you understand? Do you understand?
Just tell me you understand, Jake.
All right, I understand. Okay, good. Get up slowly, please. You got anything in your pockets that may harm me or you?
No.
Okay. You want to change your trousers?
And I stopped it there on purpose. That's a 13-year-old, according to the movie. I'm not going to give you the rest of it, but 13-year-old who's just been charged with murder. And you saw how the police came into his home. And I stopped it there on purpose because you can see he wet his trousers as a result of everything that was going on. Now, I do encourage y'all to watch. It's a four-part series. Watch it. Understand though, it's based in the UK. The law is different. So at some point you might be looking at the screen, screaming, that's not how you do it. It's a different law, different country, different laws. But, now I got to figure out how to go from there. There we go. What do you do now? You got a 13-year-old, 14-year-old, 15, 16, 17-year-olds charged with first-degree murder. What do you do? That's what we're here for. Where do we go from there? Public defender districts. There are some benefits to it. Know your juvenile court counselors. Mind if they hear that I'm saying this out loud, it might stop, but at least where we're at, they inform our office. They'll give us a call, say, hey, we're about to make an arrest on this type of charge, this higher level of charge. Last time it was a murder, time before that was an attempted murder. And because we play nice with them sometimes, we said, well, can we at least see the petition? And they gave it to us. And I was like, well, we're on our way to pick them up now. We know where this client is. So yes, we're going to give you that petition ahead of time. Once we got that petition, once I found out that they had actually secured the custody of that young man involved, I self-appointed our office to that case. I didn't wait until he got to the court. As public defenders, you can self-appoint yourself to a case before they even get to court. If you have that relationship with your court counselors, if your district has that and you know about that case ahead of time, talk to your chief. Say, hey, let's get in this case from the beginning, early on. Can you self-appoint? Get it printed out, sign it, and run that bad boy over to the clerk's office as fast as you can. Or if you're in the e-court jurisdiction, task that thing over there real quick with the top priority. And then you call them going, I just tasked a self-appointment over there. We need you to get that file stamped and get it officially in a record. I don't have it yet. You're going to have it. Don't worry. Just file stamp it so that we can get started on that case. Once you have that case, I would tell you the first thing you need to do is locate your client. Where are they holding him? Yes, please.
The self-appointing power will work for your own office.
That is correct. That is correct. So if you don't have a public defender
Who does juvenile?
who does juvenile work, then yes, you can't do it. But locate your client. That's really big because if they're under 18, they can't hold them in your local jail, detention facility. So you need to find out where did they take your client. Client may be 2 hours away. Client may be half an hour away. But find out where your client is. And I'm going to tell you a story about that, which caused a little controversy in Chatham County. It's going to be fun. But once you find your client, if you can, meet your client before they even get that first appearance. You're already, especially if we have been able to self-appoint and you have a chief who will let you do that, then take your little appointment and run over to wherever they're being held at and say, that is now my client. I want to talk to him or her. And what's one of the first things you're going to do when you talk to your client? Because they're kids. Kids like to talk. See, I didn't go with the modern cell phone. I went with the old school dial-up, okay, showing my age. Tell them, don't talk on that phone, don't talk on the tablet. They're kids, they're scared, they do a lot of talking. And they start, mom is on the phone, mom, dad, I didn't, and well, why are you doing this? Parents are going, well, why are you doing this? It's being recorded. And I get it, the parents don't really know what's going on, so they're trying to get information from their child. Child is trying to explain their situation to the parents. Meanwhile, it's all being recorded, and in a matter of days or a matter of hours, some either assistant district attorney, somebody from that facility, or some law enforcement officer is going to be listening to that phone call and going to be saying, they admitted to it. They admitted that they were there. We have this extra information. So tell them, stay off the phone, stay off the tablets. Now, once you start talking to your client, you need to figure out, what does your client want? Right? I have this guy facing backwards for a reason. Because here's the problem that we run into in juvenile court all the time. We're adults, they're kids. They don't know any better. We know better than they do. Client says he wants something, and you're sitting there going, dude, that is not going to work. That is not in your best interest. And you're using your adult wisdom. You realize it's not in your client's best interest. And you're trying to tell them that's not what you really want to do. You cannot, as the attorney, substitute what you think is in your client's best interest for your client's wishes. When I first started practicing in Durham, I'm not going to name the attorney, but there was an attorney who practiced in juvenile court. And it was routine for that particular attorney to make the decisions for the client and what that attorney thought the client needed. Not what the client wanted, but what the client needed. And it was well known that that particular attorney was not going to try a case, was not going to file a motion, was not going to argue against the state in any way. Because after all, it's juvenile court. We're just going to net child services that he or she may need. Can't do that. Even if you don't like the choices your client is making, you still have to do what your client is asking you to do. So, you got to get your client to think. As the attorney, you have to get your client to think. You want them to have that look and say, okay, let's talk about your case. Let's talk about your options. You want to give as much information as possible so that your client can make an informed decision. And as the client's attorney, you can give them that information to get them to reconsider that bad decision of, yeah, I want you to go in there and admit that I was there, but I didn't have the gun. And you say that, that's going to help me get my bond reduced. I'm like, oh, no, it ain't, sir. But no, you need to say that. You need to tell the judge that. Yeah, I was there, but I didn't have the gun, and I wasn't the one who fired. And I was like, sir, that's not going to help you. Yeah, it is. They'll know that I didn't do it. It's not going to help you. So it's my job to try to show them why, making that slight confession and admission of being there, trying to explain acting in concert and conspiracy theory and all of that. It's my job to explain all of that to my client so that they can perhaps reconsider that notion that they're asking me to stand up in court and admit to all of those things. And we get to this one. That's my client walking away ticked off at me because he doesn't like what I had to say. And I'm telling him, no, you don't want to make that admission. He's like, you're going to make it, as he get ready to walk out of his cell from talking to me. I tried, but I still have to do what he wants me to do. Meet with the client's family. Now, I understand you just got the case. It's early on. But you want to meet with the client's family as soon as possible. They're going to, that first appearance, they're going to be there because their child is in custody. You want to get there early. You want to pull them aside and say, come on, let's go in this room. Let's talk. Introduce yourself. Explain what is going to happen at the first appearance. They're here to formally announce the charges in court. These are the things the judge is going to take in consideration when addressing bond. And if some jurisdictions, ahead of time. If it's a murder case, first appearance, judge is going to say no bond. Just automatic, doesn't matter the age of the person accused, the judge is just going to say murder charge, no bond, y'all going to deal with that in superior court. If you know that's what happens in your jurisdiction, go ahead and tell the parents that. Because they're going to be looking at you going, well, what about bond? We can get them out. Can you get them a decent bond? Go ahead and let them know. This particular judge in our jurisdiction, you're not going to get a bond. He's not going to address, he or she, the judge is not going to address bond right then and there. Here's what's going to happen, and we can address bond at a later date. So that the parents know and have a reasonable expectation of what's going to happen in court versus you just coming in, hey, how you doing? I'm going to be representing your child. Okay, I'm going over here to talk to the DA. I'm going in the back. I'm going to go see your child. You got to start forming those relationships with the family ahead of time. You do that by meeting with them as soon as you can at first appearance or before the first appearance begins.
Yes. How do you navigate the situations where the family is either the alleged victim or prosecuting witness? And I'm just thinking of a case where my client was accused of killing his sister and just dealing with mom and
those are I would call the fun and interesting ones because you're tiptoeing a line. You're doing a little dance. You navigate that by acknowledging that I understand you are, if it's the sister and there's the mom, torn between child who's in custody for killing his sister, right? You acknowledge the mother. You acknowledge that she is in a tough situation. Like you have a child that you love who's in custody and you have lost a child that you love. I understand that there are times where you're going to be torn. I say be completely upfront about it. There are times when you're going to be torn. And all I'm asking you to do is to recognize that your interests at times may be different from your child's interest who's in custody. And acknowledge that they're going to be feeling all types of, as I say, those feels or from the movie Inside Out, you got all of those different little feelings, colors of feelings up there. But have that conversation with them from the beginning. And then I would also tell that parent, there are going to be times where I may not be able to answer your questions. And that's just because you might be a witness for the state. And it's not that I'm trying to withhold information from you. It's because I don't want you to be in a position where you're sitting on a witness stand somewhere and you're looking at your child over there, and then you're thinking about the loss of your other child, and you're looking at your child over there, and you break out in a cold sweat and pass out on the witness stand because you are just that torn between your feelings from your two kids. I don't ever want to put you in that position. So the best way I can protect you from being in that position is withholding certain information from you and not giving you everything that you might want to know. Does that answer your question? But that leads into this one. what do the parents want, right? Exactly. It's my child. I know what I want for my child. I know what needs to happen. You're going to need to do what I'm asking you to do. Ma'am, sir, no, I can't. What do you mean? You can't. I'm the parent. I get to decide. That's still a minor. Yeah, I understand your child is still a minor, but your child gets to make the decisions. They can't make the decisions. They're still a kid. I understand that. Ma'am, sir, I'm a parent. I was in this situation. I would want to make the decisions for my child too. But I can't let you make those decisions. The law and the ethics rules that I have to follow says that your minor child gets to make these decisions. That's not right. That's not right. I understand it's not right. I understand how you feel, but that's the way the law is. Here's what I can do. I can give, and I promise you, I will give your child as much information as I possibly can so your child can make an informed decision about their case. Well, I want to be there. I need to know what you're telling the child. Client confidentiality. This is where your life may sometimes get threatened or you feel like your life is threatened. You try telling a parent, ma'am, sir, your child doesn't want me to tell you anything about his case. What? You try telling that to a parent and see the response. I suggest there's at least 6 or 7 feet of space between you and a parent when you tell them that, preferably a table too. And make sure there's no sharp objects on the table or anything that they can throw at you when you tell them that.
There's recently been on the national listserv a conversation about parents not listening to that and trying to force themselves into the conversation. Do you have any thoughts or strategies about how to get around that?
Besides talking to the parents and really talking to your child, your client, because you want to find out why your client doesn't want you to talk to the parent. Because most of the time, logically thinking, they want their mom or their dad to know everything. So for me, I want to dig down further with my client to find out the relationship. Because it may be another adult that juvenile trusts more than their own parents. And the reason why is because parents have kicked them out the house. Parents have, there's an abusive relationship. So that juvenile is actually living at his best friend's house, and his best friend's mother is more of a mother figure to him than his own mother. And so for the parents who are going to try to get around that, if I get my client's permission to have that type of discussion with their biological parent, I let them know. And then I also tell them, but without giving the name of the other parent or the pseudo parent, I let them know there is an adult that your child trusts, who your child is including in these conversations to help them make these decisions. Now, does that open up a whole nother can of worms? Yes, it does. But at the same time, I also try to assure that parent, because I've had that happen, but at least your child is talking to an adult who will help them, who will guide them through, versus he's using his same friends who got him in trouble in the first place as his co-counsel and thinking about how do I handle this case. It's a hard road. I mean, when I say you're going to be dancing with the parents, you are going to be dancing with the parents, tiptoeing, especially in those situations where the child says, no, don't talk to my mom, don't talk to my dad, but you can talk to my grandma. You can talk to my other adult cousin.
Well, what about the kid that's telling you, don't tell my parents, I don't want you to talk to them, but I don't want you to talk to them. And then they go tell mom and dad, I don't know why she won't talk to you. Maybe I'm the only person that's ever happened to.
No, you're not. You have to have thick skin and be prepared for, you have to do what your client says and and then you sit down with your client and you go, your mom and dad seems to think that I'm not talking to them because I just don't want to talk to them. You realize you're the one who told me I couldn't talk to them.
They won't support me.
Any reason why they seem to believe the reason why I'm not talking to them is because I don't want to? What are you telling them?
I'm, go ahead.
I was gonna say, to be honest, I'd rather have them blame it on me. If that's gonna help their relationship at home or with their family, like, go ahead and blame it on me. Whatever you gotta tell them, you can tell them, but, that doesn't, I'll deal with that. Like, if they're telling the parent that it's my fault, then I will say that it's my fault. Like, I'm not, I don't care.
We fall on the sword all the time. And I agree, it's okay, but I think you should still have that conversation with your client to say, you realize that you're telling them, I'm not talking to them because I'm just not talking to them. But you're telling me, you're giving me different and walking instructions. It's like, okay. At some point, this is going to blow up and it's going to, and we're going to have to deal with this, right? And it's like, I'm not asking you to change your mind. I'm just telling you what I think could happen in the future. And I want you to be prepared for that if it does get to that point. And then I change subject, keep it going.
Just because they say you can talk to them does not always mean that you still want to talk to them.
Exactly. Exactly.
Isn't it just as simple as saying, at least this has worked in my experience, just to say to the parents, we don't want to burden you with too much information, you may become a witness. And yes.
I have used that line before.
I have to.
Me too.
I have used that line before.
Can you repeat that?
I didn't hear you say.
Just, you don't want to burden, I don't want to burden you, mom, with too much information because we don't want to convert you into a witness against your son or your daughter.
I take it a step further. I don't even call it a burden. I say, I'm protecting your child from you. And I'm protecting you from your child and from the system. Because what your child and I talk about is confidential. As soon as you're even in the room and we talk about it in front of you, the ADA can put you on the stand and you have a choice between telling on your child or going to jail yourself. So we're just not gonna go there.
And then I'd say that, and then I always tell them a story, young attorney in Durham when this happened. Mother was put on a witness stand. Mother was asked a question. Everybody knew just based on a question. Everybody knew that the answer was going to hurt her son's case. This poor lady, she sat up there and looked at the DA, looked at her son. That's where I get that from that scenario. You could literally see the sweat beads start popping out on this lady's head. And then she started breathing heavy. It was so bad. The judge even took a recess to give the mother a chance to regroup because we really thought she was going to come to pieces on the witness stand. And it was just silence. You're in a courtroom and people, the jury staring at her, everybody in the courtroom, son staring at her, the DEA is looking at her like, you know what the answer is. You need to answer it. The client, the attorney, the defendant's attorney has us look, trying to keep their face clear, like, oh my gosh, they asked that question. Didn't think they were going to ask that question. And the poor mother is up there. Judge says, let's take a break. And they came back. She answered the question. And then she broke down sobbing. So I explained that to parents to say, I never want to put you in that position. Because if you get on the witness stand, I expect you to tell the truth, because that's what you're supposed to do. And if you tell the truth, depending on the question, it may hurt your child. And then how are you going to feel at some later point if this case goes way sideways, that your answers to either one question or a group of questions aided in incarcerating your child for a long period of time? But this is what it feels like a lot of times when you're abiding by your client's wishes. You know, you versus the parents. Y'all are locking horns and headbutting. But you have to be prepared for that. You have to be prepared for it, and you just got to navigate it. And sometimes it's tough. The phone calls after phone calls after phone calls. I just need to know. Yes, ma'am. Yes, ma'am. Well, I saw your child 2 days ago. Your child is doing fine. We had a good visit. But what did you talk about? Well, we talked about your child's case, and it was a good visit. I'll go back and see your child in 4 more days, right? You're talking, but you're avoiding the questions. You have to become a black hole in those situations. Information goes in, but nothing comes out. Now, while you're talking to the parents and they're calling and complaining and saying, why aren't you talking to me about the case? It's a good time for you to get information from the parents. But what can you tell me that could help me? You know, what about school? What is their best friend's name? What about the neighborhood? What about their father's interaction? Well, okay, are y'all together? You separated? Well, when's the last time he saw his dad? Do you know where his dad's at? Do you know where his dad's people are? My favorite thing. Well, okay, you haven't seen the dad, but where are his people? Where his people at? Her grandmama and them. Yeah, I use that language you're talking about. Going, where's grandmama and them? Where big mama at? Does he hang around with his dad's family, even though his dad's not around? Does he still go and hang around with cousins there? That's what you can use those conversations with the sometime angry parent, because if you turn it from, I'm not giving you any information, to a, well, I understand I'm not giving you any information, but you know what? You can still help your child by giving me information. Could you tell me about this? Can I make an appointment and me and the investigator, we come over and we talk to you? Because I would like to know everything you can possibly tell me about your child. You know, same thing with teachers, coaches, school counselors. Go talk to them, get the information. And there are going to be cousins who are going to be calling, and their favorite aunt. So, side note here. I do this with a lot of my clients, because with adults and even with my juveniles, I get 5 and 6 phone calls wanting to know, what can you tell me about the client's case? And even if you're allowed to give, the client gives you permission, said, well, yeah, you can talk to them. You can talk to my family, it's okay. You can spend an entire day talking to one client's entire family. You know, I don't know if any of y'all have ever had this happen, but I've had phone calls from, well, this is with my adult clients. Well, I'm his wife, so I need to know. 45 minutes later, I'm his fiance. Like, what? I need to know. Another 30 minutes later, I'm his baby mama. I'm like, oh my goodness, I need to know. So I go to my client and I say, okay, you tell me I can talk to your family, but I'm not going to be able to work on your case if I spend my entire day talking to every member of your family. I need you to designate one main person and one backup person that I can talk to. And I will give those 2 people information, and it's up to those 2 people to disseminate the information to the rest of your family. I don't have the time to talk to everybody in your family. So designate a person. And that's really good with juveniles, because then that juvenile, if they allow you to talk, let's assume they allow you to talk to somebody. So then that juvenile knows who you're talking to. And then that juvenile knows you're giving this information, and they can confirm because they talked to mama or they talked to grandma. Oh yeah, your attorney called me the other day. She told me that. Well, yeah, that's right, Ma. She came and saw me and she told me that too. So that they know that you as the attorney, you're talking to the most important person they've designated. And they're like, that builds that trust with your juvenile client. Now, I'm a switch. We're going to do probable cause hearings, right? We talked about it earlier today. If it is 13, 14, 15-year-old cases starting out in juvenile court, you have that probable cause hearing, yes or no? Right? That is the ultimate. Because most DAs, ADAs, they're going to want to get that case indicted so they don't have to do probable cause hearing. So, you got to know, when's your next grand jury? So as soon as you find out about the case, next thing you know, you're checking your calendar, saying, when is that next grand jury meeting? Can I get a demand a probable cause hearing before that next grand jury meets? Why would you want to have a probable cause hearing? Sometimes you need the family to hear a glimpse of what the evidence is. Like, you've talked to your client has admitted to you some things, told you some things, but family doesn't know it. Family's out there, oh, he wasn't there, he couldn't have been there, they got nothing on him. I don't know why they're charged. Especially in those cases when your client's telling you, nah, don't tell my family a thing. Don't you say nothing to my family. You're like, and you're trying to tiptoe that line, doing that little line dance, slapping that fan. Y'all know the dance. Y'all know the dance. I'm still learning it, so that's why I can only do 2 steps. You know the dance, and you got that fan going, and you're like, oh, how do I do this? How do I do this? And then your client also is in denial of certain things too. That they don't have that, they don't have that. And they're pushing back on you. So the best way, have a PC hearing. That way, the client, what it also helps you do is deal with that. You're making it up. You're just helping the state. You're not trying to really protect me. You're not really trying to help me. And you also have the family saying that to you too. You're making it up. You're working for the state. You're not trying to help them. Or that's not what the evidence says. I'm like, okay, I can show you better. I can tell you. Let the state do a PC hearing. Let the officers get on the stand. It also helps you because now you get the information yourself because you don't have discovery, early discovery. You know where to start your investigation. Also a chance for you to identify early some experts you might need. And then it gives you information, request for bond at some later point. Now, there's always a downside in life that you have to overcome. That sworn prior testimony. Gosh, bless America, land of the free, home of the brave. That prior testimony. I don't know if any of you have ever had this happen to you. Have a PC hearing, you moving on about your life, case moving forward. Then you find out one of the state's main witnesses up and died. Now your client is going to hear about that witness has died and think, oh, case got to be dismissed now. They don't have a witness. And you're going to have to explain to them. That was prior sworn testimony. There is a rule, evidence that does allow prior sworn testimony to come in. No, that's not right. That can't come in. They're dead. That's hearsay. Yeah, you're right. It might be. I see how you think it's hearsay, but let me show you the rule. Let me show you the case law that says that this is okay.
Okay, this might be me just not knowing a part of the rule. What about the argument that the probable cause hearing is for a different purpose and your questions? Okay, were you going there?
Yes.
Okay, come on.
Exactly. And that is the argument to make.
Okay.
If you ever have situation. I believe, Daniel Meyer
Yes.
and Daniel Meyer out of Durham.
Wasn't even the trial attorney at the probable cause hearing. They were just trying to not have PC found in this trafficking case. So the attorney strategically held back on a lot of information and didn't do a lot of cross because that was their strategy. Well, lo and behold, that she's not there in Superior Court, they make a finding that she's unavailable, which you have to do. And then here came her testimony. So
And was he was successful with the argument?
no, he was convicted, and the Court of Appeals did reverse it. I don't know the status of it now. Actually, I think it's back in the trial court, so it must have not gone any further. But he was still in custody for a number of
Right.
2 years waiting for that. But it was only because it was so ridiculous in that case. But it's sworn testimony.
Yeah, and I believe that, I agree with you, Tucker. I think there's still some things going on with that case. So I don't think we have last time I checked with Daniel, last time I looked it up, I don't think there was a final opinion
Cool,
about
so we
that.
can still flip the tables and argue the argument.
You know what? I never turn down a chance to flip a table. Choose violence and flip a table. If you have the time, flip the table. But I'm just saying, these are things you need to take in consideration. And if by chance that does happen and you find yourself in Superior Court and they're going to try to use prior sworn testimony, you need to make sure you preserve your record, and continue. Don't just say it one time at the beginning. You object, you put all your argument beforehand, even after the witness finishes, you say it again. Even after the state finishes their case, you renew it. And even after you have finished, you renew it. And you keep renewing that objection so that you don't lose it at some point. Another thing you want to do kind of at the early stages, especially with that 13 to 15-year-old age group for the Class A's, you want to go ahead and file that motion to preserve evidence and have it heard in juvenile court. Why? Because depending on your jurisdiction, if you're like from little small rural counties, like Chatham, where I'm at, everybody knows everybody pretty much. They think that sometimes it's okay to give some of the items back to the original owners or the family. And and they don't ask anybody, they don't tell anybody. And then you start going through your photos and it's like, well, I would like to see that. Can I come? Well, we gave it. What do you mean you gave it back? What? Well, your client didn't own it. The family owns it. So the family came and asked for it. We gave it back. It's like, you realize you can't do that, right? And it took a few motions filed, nice conversation happened in a case with the chief of police in Chapel Hill. Took a nice conversation I had with them to say, yeah, y'all can't do that. You can't do that, and you really shouldn't do that unless you want to be tied up in this case too with more motions and you're coming to have to explain yourself on a witness stand. So file that motion ahead of time. File it in juvenile court, ask to be heard on it. Now, it's always great to say when your ADA says, well, I don't want to hear that motion, Your Honor. Your Honor, is the state saying that they don't want to preserve evidence in a case as significant as this? Is that what they're saying? Judge, really? It's a motion to preserve evidence. How detailed do you have to be to argue? All we're asking is that nothing is returned or destroyed unless the defense has an opportunity to review it. And then we can sign off on a consent order presented to the judge saying, okay, you can destroy this or you can return it to the lawful owner, right? So is the state officially saying they don't want to preserve evidence in this case? And then you watch the ADA become really angry at you and you try not to laugh in court or smirk. And then you just wait. And then your judge actually will usually go, well, Madam DA, ADA, I don't see any harm in making sure we go forward on this motion. And most of the time, our juvenile judges will say, yeah, let's go ahead and issue that order. And we've talked about records today. Records, records, and more records. There's the statute, how you get your juvenile's record. We discussed, I think somebody else put up there, the DJJ site to get your juvenile's DJJ records. Now, this is the difference between a public defender and a person in private practice. Odyssey, case manager versus portal. As public defender, I have elevated access. I can go into the system and I can see all of my clients' juvenile stuff. You can't in portal. Don't yell at the messenger. I think the system stinks. I think all defense attorneys should have access to everything they need in the system. So don't yell at the messenger. Take that up with somebody way above my pay grade. So, but you can complete that form to get your elevated access so you can have at least access to your juvenile's case, all right? But you have to keep digging. You have to look for records. You really do. There's the form the link I was just talking about, DJJ. There's the form right there. That's what you fill out online to get it, get those records. I'm not even going over that. And there's DSS. DSS records are a wealth of knowledge because it helps you find out your kid's background, his family life, his parents' life, how many foster homes he were in, what his life was like in those foster homes. And I will say, you know, each county does things differently. Durham County, their county attorney, you just call her up. She has a specific motion and order she wants you to use because she has certain things in there that really, truly protects confidentiality, and there's statements in there that says, well, if you get these records, once you finish, if you're giving them to an expert, you're saying that you're going to collect them back from the expert and you're going to destroy them. Just say yes, 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 I would do all of that and get those records. And there you go. That's the statute for that. School records, get those. Now, most of the time you can get those just your client's parents sign the release, your client signs the release. But 504 plans and IEPs are usually held separate from just your typical regular school records. So you want, and some districts require you to have a particularized release form to get those records. You need to check and find those out. If you believe your juvenile does have one of those, 504 IEP, get that signed so that you can get those. Social media. Now, mind you, I'm talking, try to start doing this as soon as possible, right? Yes, the case is in adult court, you might move up, but as soon as you find out, you put somebody on to getting these records and start looking at your juvenile social media. And sometimes people think they're helping out your client by deleting stuff. Too late, police already has it, right? Law enforcement already have it. So you want to see it. You want to find out who their friends are that they interact with on social media, especially on the gram and Snapchat and TikTok, because it is a horrible, horrible thing if your client's family, mama, as I once had, he doesn't know anything about guns. He's never been around guns. There he is on Instagram, 2 guns up in the air, smiling with his boys. And like, oh man, get the social media, get that as fast as you can. Even if all you're doing is looking at it and taking screenshots from your own phone so that you have it, so you know what you're looking for. Because if law enforcement, DAs do what they're going to do, they're going to get search warrant, they're going to send it off to Meta and all of those and get the dumps of the social media. You'll see it eventually because I'm pretty sure they've looked at it, but you want to see it as early as possible so you know what to do. The worst thing in the world is be up there at some type of bond hearing and you're trying to say, oh, my client is not around guns and all of that. And then here comes the DA holding up the photo from their social media. And you're like, oh, man, okay, I probably should have looked at their TikTok, their Instagram before I said that. Worst thing in the world for that to happen. Mitigation specialist. Yes, I'm retired. Don't know what a mitigation specialist is, learn, get one. Basically, they are your best friend in these type of cases. Their background, social work, psychology, sociology, some related field. They can help you conduct interviews, collect records, organize, review the records, help you identify other experts. More importantly, they can work closely with the family. And they also assist you in developing your defense. How do you get one? Ask for money. You get one. Now, IDS has a whole nice little list of them. You go down the list, you can call, you can get some help, trying to identify one that best suits your needs, fill out the form, and then you go and you ask the judge for money for it. And say, this is why I need it in this particular case. I've only had one judge tell me no. I went to another judge and got the funding.
Do you want to take your break here or?
Yeah, we can. So we're going to get into talking to the jury.
We will take I think it's a 15-minute break. Maybe about 15.
What's up, dude? How you doing? Good to see you. I saw you were on the visitors list. I was like, God, Steve.
I bet Ikra could.
Well, that's super important.
Individual.
No.
I
Look, I got a lot of coffee.
Yeah.
I had you know, judge and
All right, so I guess we're supposed to be talking to your juvenile client now. I don't know about the rest of y'all, but sometimes talking to my juvenile client feels like this. I'm talking to them all. You know, it's, you're sitting there, you're trying to, hey, let's talk about these things, and they're just staring at you. One, because they don't trust you. They don't like you, and God forbid if you're court appointed, you're not even a real attorney. We've already had a previous speaker tell us all about the cute little brain and all of that, and the issues, you know, they process questions differently, their communication skills. Side note, if you don't listen to the latest hip hop rap music, you need to find somebody who has a team and have them explain it to you. Let them draw you a diagram, listen to it, understand the lingo, because if you're sitting there talking and they say no diddy, no cap, and you're like, A minor, Webster, yeah, you know, you hear that and you don't know what that is referencing, you're not going to understand a single thing your juvenile's trying to explain to you. So if you don't listen to it, you don't watch it, you don't keep up with it, call a friend who has a teen and take that teen out to dinner, take pizza, go do something with that teen, have them play the music, Get over the shock of the language. They're listening to it anyway, so you might as well get over the shock of the language. And don't listen to the radio version. Listen to the explicit version so you know exactly what they're referencing and you can understand the language. I'm not saying you have to talk back, because if you use it wrong, your client's gonna laugh at you. Yeah, I'm like, hey, well then teach me how. But learn the lingo, right? Communication skills. Then your clients have the mental health diagnosis, learning disabilities, self-control, poor decision-making, abstract thinking. Some of them can do it and some of them can't. It's really interesting. And don't ask them to give you a timeline. Oh my goodness. They tell you like a couple days ago, and a couple days ago ends up being 3 months ago. Or 4 hours ended up being 24 hours or more. Some of my clients have no sense of time. I don't know what it is, but brain, no sense of time. And then they're always focused on the present. And what I find hilarious at times, but also very frustrating, this aspect of fairness. And that's why I put up there fairness fanatics. They want everything to be fair. And they have meltdowns if they feel like it's not fair. Well, why this person, in this pot is getting this, but why can't I get this? That's not fair. It's supposed to be fair. And you know whose fault that is? It's not ours as adults. Because think about it. From the time they're born, they're walking around and we're talking to them as young little toddlers. We talk to them in terms of doing things that's fair and what's right. And that's what they're hearing. Yeah, they might be locked up for some serious crime, but they're still thinking in terms of a child. And because that's what we focused on, that's what they're thinking about. And you are going to have to convince your client, yeah, I understand you want things to be fair, but I hate to tell you this. Sometimes life's not fair. And you're not always going to get what you think is a fair outcome here. We're going to try to fight for that, but you may not get it. And that's a whole nother meltdown there. When you're talking to your clients, my favorite line from the Philadelphia movie. Now explain it to me like a 4-year-old. We're attorneys. We love using legal language. We like to use those big words now. I may not be able to spell it, but I do know how to use it in a sentence. And we get into the habit of, because it's our everyday language, when we talk to our clients, we start using our everyday language. With some of our adult clients, some of them keep up with it, some of them figure it out and move on. But with our juvenile clients, get rid of the legal language. Explain it to them like it's like you're a 4-year-old, like they're a 4-year-old. Have that conversation. Break it down for them.
Can I ask you a question now? I've noticed something, and I wonder if this is true, that attorneys will tend to do that. It seems to me, I've never actually asked, but it seems to me that they're afraid if they don't word it correctly, somehow, they don't word it with all the legalese, somehow it's gonna come back on them that they didn't really fully explain something to their client. Is that just something that I made up, or is that something that happens?
No, I don't believe you made it up. And I think there is some legitimate truth to that of you didn't use the legal term, so you didn't explain it. So how do you get around it? Use the legal term, then break it
Explain
down.
that, yeah. That makes sense, yeah.
There we go. Strategies for talking to juveniles.
Here we go.
Big first one, build trust with your client. How do you do that? Invest time with your client. Visit just to visit. These are still kids. Don't go just to talk about their legal case. Why should they trust you if every time you're coming over, you're coming over, well, okay, I talked to the DA and the DA saying this, I got the autopsy report, the autopsy showed there was 4 bullet wounds here, there was this, this. All right, I'll see you in 2 weeks. Why should that child trust you? You haven't talked to that child, you haven't asked that child how he's doing, how are things, when's the last time you talked to mama and them, what's happening in their pod, what are you watching on TV, what are you reading? Invest time in your client. In places where I can have contact visits with my client, even though I was told one time I can't do it anymore, and I'm like, okay, whatever. I have a deck of Uno cards. And I'm coming in there and we're playing Uno. And we're playing like, take that, draw 4, and we're going, we're not talking about the case, we're playing Uno. And for this one particular client, I had just a legal pad keeping up with who won how many games, who's ahead in the Uno count. And I'll come in there and like, what do you have to, not this Uno day? Like, all right, let's play. And what I found out is that he was telling other kids in that facility that, oh, my attorney comes over and plays Uno with me. Or you play paper football, y'all remember, I'm showing my age, holding that piece of paper over that little triangle and you're hitting it to the edge. And okay, when I couldn't play Uno, I wasn't supposed to bring in cards, we started playing paper football. But the whole point of that time with that client was to build trust. Granted, I'm a little competitive, so I was keeping track of how many times I lost. And I was like, we're playing again. No, you were supposed to, no. We'll talk about your case next time. We're playing again. I gotta win. But that's how you build trust with your client. And by investing that time, they're willing to listen to you, trust you more, hear what you have to say, especially if they're about to make a decision. Like, I want to go to trial. Like, oh my gosh, you realize you were found with the weapon in your back pocket and it matches the ballistics, but you want to go to trial. What do you think I'm going to do with it? Okay, you want to go to trial. All right, we need to talk about this some more. All right. Other way of building trust with your clients, make promises you can keep. So if you say, I am going to see you on Friday, you better be there on Friday. I don't care if it's 9 p.m., 10 o'clock at night. I don't care if it's 11:58 p.m. on Friday. You are there on Friday like you promised that you were going to be there on Friday. I got a young man I got to see next Wednesday. I promised I'm going to be there. Go and see them. Now, clients, they don't trust you. You're still building that trust, and you're asking them all types of personal questions. Why don't you tell them, explain to them, this is why I'm asking you this question. I need this information to assist me in addressing the judge about your case or addressing the judge about your bond. This is why I want to know this information. I'm not trying to be mean. I'm not trying to be nosy. I really want to know about your background so that I can explain this information. Or if when you're first meeting the client and you need release forms signed. Anybody ever have a client that looks at you and go, I'm not signing that. What is that? You explain the release form and you tell them why you need their signature. I need to get your school records because those records are going to help me with your case. You see right here, this says where you sign here, it gives me permission. You know what? You don't want me to know something? You can write right up here what records you don't want me to have right now. Maybe later, after we talk some more, you'll be willing to let me get those records. But at least right now, could you at least let me have these records? When you explain this stuff, many times the clients, these kids get it. And they're like, okay. And the biggest one, listen, don't judge. Don't judge. That means sometimes you're going to have to fix your face. You're sitting there talking to your client, they tell you something, you want to go, oh my. You can't. You got to sit there, write down, take a few notes in your head. Your head is exploding inside, but you don't judge. Why should they talk to you? Why should they trust you? If you're sitting there, they tell you some secret and you're sitting there looking at them like, oh, I can't believe you did that. Why should they tell you any extra information? Because you're supposed to be there to help them, not judge them. So you just listen. And even be aware that sometimes some of your questions may sound judgmental. You don't mean for them to be judgmental, but to the listener, it sounds judgmental. So listen to your questions. And if you feel that, hey, this might be judgmental, then go back to the earlier one. Explain why you asked that question. And let them know, hey, I just need to know this because you said that. I'm not sure. So could you explain that to me? Tell me a little bit more. You're trying to be the safe haven for them to talk to you. And one of the biggest ways of doing that is, again, don't judge, build that trust. And then find your commonalities. I'm a sports fan. So for me, it's real easy with some of my clients. We get in there and we talk sports. I love it when I have a client who's a Duke fan and I'm a Carolina fan. Oh, those conversations get real fun. And like, did you see this? Like, let me tell you what happened at the game. Oh, here, I'll even bring newspaper clips. I'll print it out. Going, did you see the score? Did you see the score? How about those heels? And then if we get into football, unfortunately, I'm a Dallas Cowboy fan too. I have to take a lot of lip from my clients when I tell them that. But that is our bond. So when I come in there, whatever sports season it is, we'll talk about the sports season. Or if they like cars. I'm lucky enough that my father owned a mechanic shop, so I know something about cars. So we talk about cars. And I show them pictures, the first muscle car I had, which was a 1970 Dodge Charger. And we talk about how fast they go. But I try to find something that I can use to talk with my client that they like, their interest, and go with it. I had to learn anime. Okay, let me tell y'all something. I am 55 years old. I don't really care about anime. Didn't want to learn anime, but one of my clients was really into anime. This is where you got to have somebody who can teach you something. I have a son who's, all right, son, what do I need to know about anime? Well, which level? What do you mean there are levels of anime? Just give me some basics. Yeah.
Where's a good place to start now that you've done the homework for us?
I'm gonna give you my son's phone number. You call him and ask him. Hey, you call him and ask him. Man, Naruto was.
Right.
I did learn something about Naruto. So.
Like Pokemon? I'm just kidding. That I understand.
But I'm just saying, find your commonalities and learn it, So that, and even if you don't know it, you can ask your client, well, explain, give me, all right, the question you asked me. So ask your client, well, if I wanted to learn about anime, what should I get? Or what book should I read? Okay, get the book, bring it in. It's like, all right, I got this book. Let's explain this to me because I tried to read this graphic novel with all these pictures. I don't know what they're doing.
You mean the Japanese ones that
Yes.
you couldn't read because you may not have known Japanese or, I'm just saying.
I just went to
And that's
Barnes and
manga, by the way. Manga is the title for the comic books that are in Japanese, just.
This is scary.
Manga.
I just know. I have a child who has a bookshelf filled top with all of them. When the client said that's what they were into, I went to my child and said, could you help me out here? Could you give me something, explain something? And he's the one who started me with Naruto. Said, well, take this back, and if he says this and this, you're good. I'm like, okay, son. and I went back with the Naruto book, and we started with that. But it was important, though. But that was the bond. After that, my client really started talking to me. And he wanted to know, and I was telling him that my son, there's what, Netflix has cartoons, have it on. And I was, yeah, my son showed me this. And he's like, yeah. And I was like, okay. And this is being recorded. Okay, I'll get to it. I even, by chance, took my laptop in with my client and we watched an episode or two or three while we were discussing his case. But he was appreciative and grateful. Yes.
That's so brilliant, Madrina, because he's teaching you something, right? So it's not always just the one-way street of the fire hose of us to them, so.
Yes. And our relationship improved tremendously before that because he was a mumbler. Yeah, no. Well, what do you think? Well, I don't got nothing to say. Didn't really want to talk, didn't want to exchange information. But once I brought in that Naruto, I was in. And we were talking, and it was great. And exactly what you just said, Tucker. Teach the client and not just talk at the client. He was teaching me, I was teaching him. What was I teaching him? I was teaching him the law, a mini version of law school, 101. How many of us had to explain to a client or try to teach a client the theory of acting in concert? We don't even like it ourselves, but yet now we got to teach this adolescent acting in concert. How do you do that? And it's really difficult because, again, let's go back to what do we teach our kids when they're toddlers? If you didn't do anything, you're not in trouble, right? If they're in kindergarten and there's a group of them are doing something and, well, you didn't touch it or you didn't break it, so you're not in trouble. Who did it? He did it. That's what we teach them. And that's, believe it or not, that's what they believe, even in their adolescence. Well, I didn't shoot the gun. Why am I in trouble? I didn't fire the weapon. Why am I in trouble? Okay, there's this thing called acting in concert and conspiracy, and you can give them the legal definition of it, and then they're still looking at you like, so why am I in trouble? I didn't fire the gun. And you give them the law again, and they're looking at you like, and then they go, you mean to tell me I'm looking at first-degree murder and losing my life to the system just because I was in the car with them? Like, yeah, that's the theory that the state's going to use. And then we go back to what I said earlier, they're going to say, that's not fair, right? But it's all, think about it. It's what they've been taught since they were young, and that's the way they still think. So how do you get them to understand the law? Use analogies to assist in your explanations. Again, me being a sports fan, I use sports teams and sports scenarios a lot to try to explain the law, try to explain that acting in concert, that whole team approach. Because maybe your client at some point played on a basketball team, played on a baseball team, played football. They understand team concepts if they've played on a sports team. So you can use that same team concept to try to explain conspiracy theory, to try to explain acting in concert in a manner that they get it after you've told them what the law really says, and then you explain it to them. Visual aids is another thing I like to do. I have little mini whiteboards and my little marker. And I come in there and like, okay, you got a decision you need to make. Pros, line down the side, cons on the other side. Let's talk about all the reasons why you think you should make this decision, why you want to do this. And let them start telling me the reasons why. And I start writing it on the whiteboard. And then we start talking about the reasons why maybe perhaps you shouldn't go to trial. All the things that can happen to you if you don't go to trial. Some people are visual thinkers. I'm one of them. So seeing it written out for me as we're talking about it helps me understand, helps my client understand so that they can see it. And then after we finish that list, I will handwrite the list and then say, okay, so while you're thinking about it, so you won't forget this, here you go. I wrote everything that we have on our right board. Here you go. You can take it with you. You can think about it. Visual aids. I mean, besides pro and cons, I've used it to explain their options. Like we'll have option A, option B, option C. And we write down what those options are. But when we come up with those options, we're coming up with them together. It's not just me saying, okay, option 1, you take the plea. Option 2, you go to trial. Option 3, we stall, and see how much longer we have. Let them help you come up with those options. Giving your client input and talking with them and not at them goes back to the other thing of building the trust. I think you asked a question earlier. How do you get the client to make that decision when they need to make a decision in their case, plea or go to trial? It's by doing all of these things that we're talking about. Because by the time you get there, if you've invested that time, you've built the trust, you've worked with them, let them have a lot of input while you're explaining the law to them. When it's time to make that decision, I'm not saying they're going to make it right away, but they will listen to what you have to say about their options and your opinions about their options. Give copies of jury instructions to the charges and actually the statutes themselves. Client goes, well, again, the acting in concert one, I'm trying to tell you, I'm harping on that one because that's the one I have to explain over and over and over again. So I give them the jury instructions and say, listen, and flight is another one. I was like, this is what the judge is going to read to a jury if you go to trial. I want you to read this so that you understand those 12 people who are going to be deciding and listening and trying to decide your fate, they're going to hear this. And then they're going to apply this to the facts that are given in this case. I want you to see how bad this can be or how good this can help you, right? Give them that. Give them the statute. After all, many of them are sitting there doing their own Google research or whatever research they got, or they got some family member doing the Google research for them and telling them about it over the phone, and then they're asking you about it. Give them some more stuff to research. Let them look it up. Let them, and then talk to them about it and explain, okay, yeah, I've read that case. Oh, you got a case you want me to read? Okay, let me read it. And don't just take it from them and just put it aside and then go, all right, here's what we're going to do. Then, they're looking at you like you're not listening to my input. Look at the case, read it, take a moment, and then go, okay, I understand why you think this might apply to your situation. Here's why. I see you understand this and this, but this is why it doesn't apply to your situation. And take the time and explain that to them. And then we're back to that again. Remind the client, decisions are theirs and not their parents. And it's not even my decision. But my job is to give them as much information as I can so that they can make an informed decision. Or as I like to say, I may not like your decision, but I would do what you ask me to do. The only thing I need to know is that I have given you all the information I can so that whatever decision you make, it is informed and it's not made in a vacuum. And now I also use that type of explanation to explain the bad stuff. How many of us have clients who, well, all you do is come and tell me the bad stuff. You never tell me anything good. Well, that's because you don't have anything good in your case, but you can't tell them that either. What you do tell them is, yeah, I know. Sounds like every time I come, I'm bringing you bad news or I'm telling you bad stuff. But here's what you need to understand. If I only told you the good stuff, if I only told you all the great possibilities that can happen, and you make decisions just based on the good stuff and don't know the bad stuff, if the bad stuff happens to you, you're gonna turn and look at me like, you didn't tell me this could happen. And I'm gonna have to say, oh, yeah, you're right. Well, if I had known this was gonna happen, I would have decided this, this, and this. And clients, our kids, they understand that when you explain that to them and say, I'm not just telling you the bad stuff because I'm only thinking gloom and doom. I'm telling you the bad stuff so that when you have to make a decision, you have thought about the good, the bad, and the ugly, right? And you made that decision. So whatever decision you've made, I know I have informed you of everything I can think of. And so whatever decision you decide to make, you've had this information.
Also, if you go back to the stuff we were talking about before, building that trust, getting to know your client, you can give them the information that is probably relevant to them or in a context that's relevant to them because you've taken the time to get to know your child. Exactly.
Now, I like this next one. We've all had that. Managing our clients' emotions. That within itself, you need a therapist. You need a therapist to come and teach that one. But I will say, what I have learned, allow space for the emotions. They're going to have meltdowns. Even as adults, let's think about it. As adults, we have meltdowns. We have meltdowns in our car when somebody cuts us off. We have meltdowns in our car when we're driving in traffic and we're late. We have meltdowns as adults, so you know our teens are going to have meltdowns. And you have to allow space for them to have that meltdown. And you encourage them to talk about their emotions. Now, true story, just happened. What is today? Happened Wednesday. I'm meeting with my client, and this particular client, how I've had to learn how he handles stress is that he laughs. And he laughs at inappropriate stuff. And at first, I thought he wasn't taking his case serious. And he would laugh and crack, and I'm looking at him like, do you realize what you're charged with? Why are you laughing? But then the more I got to know this client, the more I realized his laughing was how he was handling his emotions and how he was handling his stress. So we had talked for about an hour and a half. And as we were finishing the conversation, he did something. And I looked at him and said, yeah, it's pretty bad. And he looks at me and he goes, I'm scared. And I was like, I understand. Why are you scared? Tell me. And he proceeds to tell me all of the reasons he was scared. And I looked at him and said, you know what? I'm scared too. And here's why I am scared. When I met you, you were 17. I have your hands in my, I said it backwards. I have your life in my hands. I have to do my very best in this case to try to come up with a resolution that will allow you to have some type of life and not one that's in prison for the rest of your life. It's like, that's scary for me. So I understand why you're scared, and I want you to know I get scared too. And sometimes I might growl at you because I'm scared. It's not because I don't like you. It's not because I don't want to help you. Every now and then, my fear shows up when we're talking. And that he was standing up at that time. He sits back down and he's like, we start talking about other emotions, his other fears he's had. And in the 2.5 years I've had him, that was the first time he actually felt comfortable enough to talk about those feelings. And instead of blowing them off, instead of just saying, okay, yeah, you're scared, I wanted him to know I have those same feelings, but we're in this together. And for him to also understand, yeah, on occasion I have growled at you, but understand, my growling was, I was scared too. You're telling me this, you're talking about you want to go to trial, and I'm sitting there going, in my head, I'm going, this is not a case you need to go to trial on. We need to figure out something else. And I'm thinking, what can happen to you if you go to trial, if you lose, and I am scared out of my mind, and I'm trying to talk to you about your case. But now that you're admitting you're scared, I feel like I need to let you know why I'm scared. And I believe our relationship, after that conversation, I believe our relationship is going to change. He's the gentleman I got to see next Wednesday. And we're going to talk some more. So, managing clients' emotions. Our mitigation specialists can help you with that too. They can go and spend some extra time hand-holding and talking to your client when you can't. We're all busy. We have other clients. We get stuck in court. We have to do that. You can also get an expert to help you, therapist. I've got money, funds for a therapist to come in just to help manage my client's emotions. Because I was concerned, kept being placed on suicide watch at the facility. And all they did was put him in a little padded room. They weren't trying to help him work through those emotions he was feeling. So I managed to get a therapist to go and meet with him, to help him work through those feelings, get him off of suicide watch all the time. Remember, they're still adolescents, no matter what they're charged with. They're adolescents, their brains are still growing, and they do not know how to manage their emotions. And that's what we have to do, is to help them. This is where pulling it all together. Number one, no matter what emotions your client is showing, especially when you feel that when they're coming at you angry, you have to be the adult. You cannot match their anger with your own anger. They're yelling, they're screaming at you. You can yell and scream back at them a little bit. It happens, it happens. But also bring it down after you do that. Don't match their anger with your own. It requires you to have patience. The other thing, be prepared to discuss the same issue with them over and over and over again. Because they're going to want to hear. And if you change one word or two words, they're going to point it out to you, and you're going to have to explain why you changed the words that time. Bless you. So that's why we got explain, and keep explaining. This is when the family comes in. If you've done the work, built the trust with your client, and your client has told mama and them and grandma and yes, and my attorney's this, my attorney's that, you've made contact with the family. When it's time to make a decision, that's when you can actually sometimes have the family help your client make the right decision. Plea versus trial. Now, of course, that's only in cases where your client gives you permission to talk to the family. Hopefully by then, it might start off no permission, but then later on, whether it's a immediate family or some friend of the family who's like family for the client, you can bring them in. You're going to need to meet the family too. If you have permission to talk to them, have meetings with the family. Bring them in to the office, sit them down, and explain the law to them, because you don't want the first real discussion of the case with the family to be when your client has to make an important decision. Because then the family's going to look at you like, why are we just here? No, we don't know this, and you haven't tried this. If you keep them in the loop and in the process, they can help. Yes, ma'am.
We have an online question.
Yes, ma'am.
By Camille Hill. She's asking, how do you bring the parent without raising conflict?
How do I?
She adds on, sometimes we see the parent coming in to speak with us and the kiddo, but then they're the ones that turn the kid in, something like that.
You tell them. That's that part, again, that decision where you have that conversation with them going, I'm not gonna tell you everything, or I can't tell you everything because I don't want to make you a witness. While your child has given me permission to talk to you, I'm letting your child know what things I'm willing to tell you and what things I'm not willing to tell you. Because my job is to protect you as my client. And you tell that to the family member. And if the mom is the one who turned them in, you tell them, well, ma'am, you are a state's witness. You turned in your child. So because you could possibly be called to the witness stand in this case, I am going to be very limited in what information I tell you, because when you get on the witness stand, the state can ask you any question they want, and I expect you to tell the truth. And what I don't want to happen is that you give an answer that hurts my client's case, but the only reason why you know this information is because I told you. I can't do that. I have a duty to my client. Now, would a parent like that? Probably not. That's not my issue. My issue is to protect my client. And if I've told that to my client, most of my clients get it and understand. Now, if they tell their parent the information, I can't stop that, even though I've tried to tell them, don't have that conversation. But if they choose to tell their parent that information, even after I give them 100 million warnings, that's on the client. Oh, you're welcome. Ooh, new glasses, I can see everything. See the tiny print now. Okay, final. Listen. I can't emphasize that enough. Listen, listen, listen. Just let them talk, let them rant, let them tell you how much they hate you, whatever. Just sit there and listen, and go back to the earlier statement. Listen without judgment. And remember, yes, they're charged with an ugly, nasty crime, but they're still kids. And if you constantly go back to your own life and how you were at that age, and you're like, oh, I'm so glad my parents didn't do this to me. How did my parents tolerate this? Or if you've raised kids and you and you remember your kids at that age and you start thinking, yeah, they didn't listen. Keep that in mind while you're talking to your juvenile. And remember, I don't care. They could be 6'5", looking like they're 6'8", looking like they're ready to be a linebacker on some professional football team. But they're 15, okay? They're 15. Their brain is 15. They think like a 15-year-old. I don't care how big they are. I don't care what they're charged with. They are still a child, still a teen, still have the teen thinking. If you listen to them, then just maybe when it's time to make a decision and they're asking you for your input and you're telling them your input, then they actually listen to you and make a decision that in the end is probably in their best interest. Perhaps maybe even taking a plea versus going to trial when the gun was found on them and matching bullets were found in their front pocket and everything matches at the crime scene and they want to go to trial. So that's it. Any other questions? Good. And yes, y'all know me. Choose violence. Choose violence. Thank you.
Take a quick close. You have Timothy. We're gonna switch up the PowerPoint, so feel free to stretch, go to the bathroom, grab a snack if you need to.
I caught you.
Are you working out?
You might have.
I just got.
Yeah, that was good job.
Just really good. So if I were to go to that, like without,
Refile it.
Zach's great. Back person though. Such a smart person. I have
Yes, exactly. These patients.
Say what?
So, are they gonna? They'll open back up, right? I don't know if teachers have grades. Find what?
How are you? I just plugged.
Are you a backside?
Yes, I am. So much. Right.
Down here. So.
Thank you so much. And then you have a video. Yes. That's all right.
I'm trying to start this plea and my voice is cracking.
So much.
I'll copy off
Driving in the Oh, okay. Just in case. Yeah, my relationship with you now is great. Well, not great. You know,
Yep, just like
It's like one of the worst months ever.
Oh, okay.
And those are.
I hope this is the right one.
Yeah. Right.
Sometimes you baby do it, sometimes you don't. That was my example of.
Yes. Hey, for those of you guys online, can we have somebody chime in just a moment when Timothy puts his PowerPoint on? It's going to have a video. Let us know if you can hear the audio, please.
Donna, Ms. Vito's expertise is in general automobile.
I love that movie.
We can.
Thank you. I'm at the Center for Desk.
Awesome. Thank you.
All right, snack time. I've done my piece.
Is that something?
Oh, yeah.
I will.
Yes, I feel like your contact information's gotta be on something, and I know it's online too.
Really enjoying this.
Okay, perfect. Is that what I'll work?
Aren't you glad you came in first?
I'm definitely becoming a person from now on. There's no way I'm gonna be virtual ever again.
Five, 6, 7.
6, 7, 8. Okay, I do understand. Hold on.
Back when I used to memorize phone numbers as a young
I have
people.
materials.
My friend's number was 301-787-654, and nobody said 6543, and nobody ever believed
We're
it.
having a nice bio, so I'm going to read it. Timothy Heinley is an expert on North Carolina civil matters, including evidence, abuse, neglect, and dependency, incompetency and guardianship, and child support contempt proceedings. He is a faculty member with the school's Public Defense Education Program, and his primary focus is on providing education and resources to civil defense attorneys, including parent attorneys and guardian ad litems. In addition to his work with civil defenders, he teaches attorneys and other judicial staff persons, so he teaches our judges quite frequently.
Jerry, it's you. No, I'm just kidding.
Okay. You keep going. So he was awarded the Albert and Gladys Coates Term Professorship for 2025 and 2027. In 2022, he received the school's Performance Excellence Award for collaborative, dedicated, and innovative efforts that advance the mission of the School of Government, and the Margaret Taylor Writing Award for outstanding writing that displays clear and direct style for the first 7 days as a parent defender. So with that, we're going to start our last presentation, or next one.
Thank you. Wouldn't it have been better if she just said Timothy's here? Yeah. Thank you, Terry. That's very nice of you. There'll be a quiz on all my many accomplishments later.
So thank you all for having me. How's the program been today? It's great, awesome, good. If people are online, I encourage you to jump in with questions and stuff as well. I think folks are monitoring that. I can't see it, but other people can, so feel free to. So let's say we have a 16-year-old. The 16-year-old gets out of the car, chases the will-be victim, fires multiple shots, strikes the victim in the back, killing the victim. 16-year-old is charged with first-degree murder. The state's evidence at trial includes eyewitness statements and testimony. There's a lineup identification, and there's an apartment complex that had a security camera. Didn't get a great look, got a look. I'm not giving you a whole lot of detail here, but based off this detail, the defense wants the jury to consider the fact that their client is 16 years old, has a juvenile's adolescent brain. What the significance of that is. What do we think about that? I see a thumb down, I see a thumbs up. Tell me, what do we think? Based off what little I've given you here, what do we think about the defense wanting the jury to consider this juvenile's brain?
I would think about it. And the reason why I would think about it is I'm sitting here thinking, kid jumped out of a car and chased somebody down. That's not normal. That's normal behavior possibly for a 16-year-old, but as an adult, you don't really see it. So I would want to try to explain why this kid thought that that was something or somewhat okay, like in the heat of the moment, didn't have the rational mind to think this through, that perhaps maybe I shouldn't do this or shouldn't run and chase somebody down firing shots at them.
So you feel like it could be relevant, someone could be useful to your client. What's the problem with what's below? What do we think?
The way I interpreted your question, can the jury consider, I took your bullet points to mean that was the information provided at trial to the jury. And within your bullets, I see nothing opening the door to the jury considering adolescent brain development.
Very astute, Berja.
Thank you.
Yes, yes, I have no prizes for you. So, I know you can leave now, it's okay. Friday. The defense, by the way, I'm sorry, I move a little bit when I teach. I will try to stay camera focused, but I just got my evaluations back from a program I did for parent defenders in March. And okay, good, this person liked this speaker. Okay, good, this person learned this one. And then somebody said, hold still. So my job is to stay good. It's hard for me.
That's fine.
Thank you. I was like, you know, I sit in a chair and fall asleep. At least there's a chance of me tripping this way. So the bench says, Judge, you need to instruct the jury at the close of this trial. You need to instruct the jury on intent, premeditation, deliberation, and how it's different for an adolescent brain. And it is true, is it not? You all are the juvenile defense experts. I don't pretend to be. Maybe I pretend to be, but I'm not. Law recognizes juveniles are different than adults, right? In a lot of ways, our system recognizes that. So how is it the jury can determine whether this client, this defendant, had the necessary mens rea for first-degree murder? The trial court said no. Will not be instructing the jury. They had a proposed jury instruction talking about how reactive youth are, how they don't understand the nature of their consequences. I begged to not follow Madrina, who is a much more entertaining speaker than I am, but I did. So I got to see her slide with the brain and the list of things that are different about an adolescent's brains that you all are very familiar with, and oftentimes your judges are not familiar with. And I suppose that is probably especially true when you're in superior court, right? Those judges may not deal with a lot of 16-year-olds. They may not have the same training as your juvenile judges do. Trial court said, no, we're not doing that. The Court of Appeals said specific jury instructions have to be supported by the evidence. There was no evidence offered at trial. Now I'm talking to a group of defenders. You all don't really love putting on evidence, is my sense. There's no evidence regarding the adolescent's brain or development or what that means at trial. And the Court of Appeals said it very well may be true that the science says the juvenile adolescent brain is different. You have to have this, it has to be supported by evidence, not just science. And nobody gave us the science. Nobody gave us evidence. So it's not before the trial court. It's not proper. The Court of Appeals, this is important too, because I don't want to make it seem like it was just the lack of evidence. The Court of Appeals also says it matters what purpose you're trying to highlight the adolescent brain for. We do, as a justice system, acknowledge that youth are different than adults. Let me interrupt myself to say this now while I'm thinking of it. You do not have my PowerPoint. I apologize. I have a handout for you that will have everything I'm covering. Feel free to take notes if you want to. Folks online, Yolanda's going to email you the electronic version of the handout I have. Sorry. What purpose is this being offered? Yes, the system recognizes the difference between these two brains. But we have never extended that, the Court of Appeals said, to the guilt question, to the intent question. And we declined to do that here, which makes me wonder, can you do it for mitigation? Can you do it on sentencing? Could you try to do it for guilt and be a case of first impression? But maybe if this trial had included evidence about the adolescent brain, it would have been a question properly before the trial court. Maybe the decision comes out different. Did you have a question?
You answered it. I was asking about with the right case, right set of facts, did this opinion leave the door open for using it for guilt?
Yeah, so I read the opinion to say we're not taking a position on that. We have not extended this to guilt before, and we declined to here. But they did not say it would be inappropriate to extend it to guilt, or the rule of law is that it doesn't apply to intent and guilt. They just did not take it up here because there was no evidence before the trial court, and so the trial court couldn't consider it anyway. Does that make sense? So I think they cast a little doubt on it. I'm not saying it was a open door, come on, come on with these arguments, but I do wonder if a defender put the right kind of evidence on in the right kind of case, how that might work out.
Can I ask a question?
Of course.
And this may be too much for now, and I can get it answered later. I've never gone through a juvenile first-degree murder trial for jurors, so I don't know the answer. But in the capital context, we would front load that. In other words, it would come in. Is that a possibility in a juvenile case to front load the mitigation version?
Yes. That last bullet point that he had on the slide
Yeah.
prior is where you need to be careful. When your person that's putting that evidence on is presenting it in the context of mitigation versus the context of guilt innocence.
But-
And certain people can speak to it in different ways, which is probably what Timothy's getting. But so in terms of guilt innocence and brain development, you're gonna need a specific type of expert, psychiatrist, psychologist. Mitigation, your mitigation specialist can present a lot of that information. So the answer is yes, you should be front loading, but be careful of how you're presenting it so that you are checking that checkbox of saying this applies to the consideration of guilt innocence as well.
But in the juvenile trial, is there a sentencing phase?
Especially with first degree murders, they run the same. And you've got that extra sentence Miller hearing at the end.
Gotcha. All right,
So
okay.
yes, very much yes.
I'm just showing my.
No, it's a good,
No.
it's a good question. Now, I thought about that when working on this and reading some of the cases about that. I never was this heavily involved in criminal defense when I was in practice myself, but I assisted on some capital cases. And the way you front load with mitigation is fascinating and different than a lot of other trials. And so I wondered the same thing. I mean, I think Burge is exactly right. So what, to that point then, what could defense have done differently potentially at trial? If they wanted to make this an issue, they could have what? Yeah, put on evidence, which might have been included hiring an expert. An expert could help with all sorts of things, potentially in terms of the adolescent brain. You might have other types of experts in first degree murder cases, though, beyond just the adolescent brain. What are some other types of experts? What's that?
An investigator, but that's not really an effect. Well, I mean, I would argue they probably have some expertise.
Depends on what they're testifying about.
In the scenario you put up, maybe even if young client said it wasn't me, eyewitness identification.
Yeah, an expert in eyewitness identification, maybe an expert, depending on the quality of that apartment complex, security camera. I mean, that was an issue in the real case that this is based on, was the quality of the image that came through, and how reliable it is or not, that sort of thing. There could be ballistics, firearms experts, right? There could be blood splatter experts. Cell phone experts, absolutely. Forensic technology experts. I mean, it's fair. The list is large, right? And so what I want to encourage you all to do in your cases, even though I am talking to a group of defenders, is to think about the possibility of evidence that you might put on in every case. And that should include, especially in cases with this level of seriousness, the possibility of experts, which Rena mentioned, getting a therapist for her client during the last session. How can an expert help you with your case prep? And how can an expert potentially help you at trial? If you have not, I just wanted to include this slide because I often get asked, where can I find, I don't know, where can I find an expert? It's sort of like, getting a realtor or something like that. Ask people you trust for recommendations, ask the listservs, ask the Office of the Juvenile Defender. And then, I don't know if you all are aware of this, I'm sure some of you are, but IDS maintains the Forensic Resources Database. Sarah Olson with IDS is in and of herself a tremendous resource. And then she maintains this database. And you can search by location, you can search by topic for different experts across North Carolina. It has their contact information. And I would encourage you, Sarah's not here to tell me no, so I would encourage you to reach out to Sarah too, if you are in this situation, because one thing that Sarah can do and has done for me before is say, yes, this expert is listed. We haven't seen him show up for the defense in about 7 years now. He's been there for the state a lot more lately. That might be useful information as you think about who you want to reach out to. Or this expert is really good about understanding how to present a story, how to testify. That might be something you want to know. But it's a great database, so I just wanted to highlight it. All right. So we're going to spend a little bit of time, not much, on fact versus opinion testimony and who can say what. Lay witnesses, expert witnesses, that's stuff we all sort of feel like we know, but I've seen many attorneys, many judges get tripped up sometimes, and it can matter. And then the meat and the potatoes will be, how does somebody become an expert? Who is tendered? How do I challenge them? That sort of thing. Easy question to start. Burge is at least as old as I am and can remember this. What color? Okay, we have blue and black.
Blue and black.
Blue and
It's
black.
always
Two
blue and
for
black.
blue and black.
Yeah, always been the. It's
Yeah,
blue and black.
Do we have anybody who sees something besides blue and black? Yolanda, yes.
White and gold or white and yellow.
White and gold. Yeah. We have two on. Anybody see a third combination that hasn't been mentioned? When this dress broke the internet 10 years ago, it also broke my brain, much like I think it did to yours. It's just got gold and white.
Spent so much time,
Because
like,
I looked
screaming
at this and I said, I know exactly what this is. And somebody in my office said, no, it's the other. And I said, you're kidding me, right? And then we went down the hallway, picture one person at a time with a picture, and we were split about 50-50. Wouldn't it, if I had started this session by saying, is what color I'm wearing a fact or an opinion? You probably would have said a fact, right? But how do we disagree on this? How do we see this different?
Different version of people who are lying.
So we have a theory that everyone who disagrees with us is a liar. Which is a theory. I like it. I tend to think everyone else is wrong. I actually see, and I hate to say this, I see a third combination. I see blue and gold. I see blue and gold. I can see white arguably. People who see black should be drug tested. That's not. The point is, because I don't know, look, the answer has to do with rods and cones and all sorts of stuff, and you need an expert optometrist, and I am not, to sort this out. The point is, the line is a little bit blurry sometimes between what is a fact and what is an opinion. Who can testify to facts? What kind of witness can testify to fact testimony?
Or anyone.
Anyone.
Anybody. Both of them can, right? And guess what? Good news. It looks the same. It looks the same, whether it's fact coming from an expert or fact coming from a lay witness. Who can? They're blue gold. Those twins are just gold, just gold. Who can testify to opinions? Experts. Experts? Can anybody else give their opinion?
Yes.
Yeah, it's different though, right? It's not quite the same. It's not quite the same. Expert opinion testimony is different than lay witness opinion testimony. Lay witness testimony is generally inadmissible. That is the general rule, except where it is rationally based on the witness's perception. Rationally based on the perception of the witness. So if this witness says to you, that car was red, but we just saw from the dress, that gets a little bit, we have differences sometimes in how we perceive colors, how we perceive facts. But that's basically fact testimony, right? This lay witness can say this. And even if it was somehow opinion, it's based on her perception, presumably. What though if the driver gets out of the car, she testifies and says, the man driving is old. He's old. Is old a fact or an opinion?
Depends on how old you are.
Depends on how old you are. My nephew thinks I'm 100. Yeah.
Notice only the older.
The man was old. What matters here? Does it even really matter if it's a fact or an opinion? What matters? It matters if it's based on the perception of this witness. How do you know he was old? Well, he had a cane, he was bald, he had wrinkles, he was wearing a shirt that said "Kiss me, I'm 80," whatever the case may be. Okay? What if she gets on the stand and says the defendant was wearing a hat and gloves when I saw him that day? It was cold outside. How cold something is. I think temperature seems like a fact, but how it feels starts to be murky. What is her opinion based on? What is her statement based on? That's what matters here. But if she wants to say it was cold enough to cause frostbite, that feels like opinion, right? So you see, it's a little bit of a spectrum. It's a little bit of a spectrum. Frostbite is probably going to require more than most of us generally have knowledge of. I love this insanely overstuffed quote. Lay witness opinion is allowed when it's the instantaneous conclusion of the mind derived from the observation of a variety of facts presented to the senses at the same time. In other words, we usually let lay witnesses give their opinion if it's a shorthand statement and it's something they saw, smelled, tasted, heard. Boom, what's your reaction? The man was drunk. Assume this is not a DWI trial where that's a legal conclusion. The man was drunk. Is that a fact or an opinion?
It's an opinion.
It's an opinion. I think so. Can a lay witness say it? What's it depend on?
What they saw at the time.
Yeah,
The observation of the.
absolutely. It depends on these senses, right? So if the social worker says, Dad was drunk, how do you know he was drunk? Did you give him breathalyzer? No. How do you know he was drunk? He came in the parking lot on two wheels. He parked on the curb. He got out of the car. He stumbled. There's a beer can in the cup holder. His eyes are bloodshot. He smelled like beer. That man was drunk. Shorthand assessment based off what this witness perceived. We have a case in North Carolina that says that's allowed. That's lay witness opinion. If the witness wants to talk about how alcohol causes processing delays, especially in the adolescent mind, that's expert opinion. That's scientific, that's technical, that's special knowledge. Any questions about any of that? I just got an alert on the computer that says it will automatically restart in 23 hours. So I'm gonna have to rush.
You can hit,
What's that?
you can hit snooze if you want to.
I think we'll wrap up by then. We'll wrap up.
Challenge is on.
Challenge accepted. Yeah, I do have to hit snooze because now the clicker doesn't work. 1 second.
So while you're doing that, does
Yes.
this go into that whole police officer identifying marijuana versus hemp thing?
Oh, you should have brought my colleague Phil Dixon to discuss the odor, it smells like nothing, therefore I had reasonable suspicion that it was marijuana. It smelled like a gym sock, it must be marijuana. Right? Yeah, it's an interesting question. I don't want to wade into that and be wrong, so, but it's an interesting point. All right, any questions about that? Let's see. I can just do it on the keyboard if I need to. Let's talk about the who, what, when, and how then. What are the procedures and requirements for qualifying expert witnesses? So the standard for tendering and admitting a witness as an expert has changed over time. Prior to 1993, thank you, sorry, I got it. Prior to 1993, the standard was, is what the expert is doing, are the methods they're using, the basis of their opinions, is it generally accepted in the scientific community? That was the test. What happened in 1993? Dauber. Who said Dauber? Fake prize goes to you. Dauber happened. Everyone's favorite, least favorite case. And Dauber at the US Supreme Court said there's something different about expert testimony. We have got to have higher standards, greater inquiry, before we let people come in here and opine on very serious matters and very complex matters. Never one to rush. 18 years later, North Carolina amended Rule 702, which deals with expert witnesses in our state, and adopted the Dauber standard. A few years after that, our state Supreme Court in McGrady. Has anybody read McGrady? You know what? You don't have to answer this. Think this to yourself. I would strongly encourage you to read McGrady, especially if you have questions or a case coming up about expert witnesses. McGrady I'm not weighing in on the opinion itself. The writing in the opinion, the explanations, it provides a lot of detail and I think in a digestible way about expert witnesses in North Carolina. And McGrady said, that's right. There needs to be greater rigor in these cases before a witness can be considered an expert. So question for you. What about all the case law on expert witnesses for 2011? Is that case law still good when it was a lower standard or not? I have good news and bad news. The good news is the McGrady court actually addressed that. They took it upon themselves to address it. The bad news is they gave the classic lawyer answer, it depends. Okay? But what they said essentially is any case law that came before 2011 that would meet this new higher standard is good. Any case law before 2011 that wouldn't stand up today is not. So what does that mean for you as defenders? How can you use that to your advantage? What if the state tenders a witness as an expert and they offer a case, or you're tender an expert, and the state is offering a case they want the court to follow, and it's pre-2011, what are you going to do?
Yeah, it's not the standard
If they try to use a pre-2011 case, you're gonna say, there's no way this would hold up today. Right? If you try to use a pre-2011 case, you're gonna say, this absolutely would hold up. But your job is to prepare that ahead of time, and I'm willing to bet you, you will catch DAs off guard. If you come prepared with that argument, and you know that McGrady said that case law is a case-by-case determination, and you're ready with why that case does or doesn't hold up, I bet you'll catch the state off guard with that. The real takeaway of that timeline is this. Trial courts are gatekeepers. They perform a very important gatekeeper function when it comes to expert witnesses. How many of you watched Game of Thrones? It's like 100 million people. There's gotta be more than Berger. How many people else? Okay.
More than watched anime.
More than watched Naruto.
That was an inside joke from.
They probably more than once. That's right. Thank you, Cynthia. I too have watched it a mere 3 times. It doesn't get better at the end. It's all right. I still love it. It's not flattering to the judges that I compare them to Cersei Lannister or the Mountain, but it is their role here. Their role is to keep out so-called junk science. That is the philosophy behind that evolution of expert witnesses. When I think about expert witnesses and qualifications and whether they should be admitted or not, I always found Dahlberg to be a little bit overwhelming, a little bit complex. It helps me, and Lord help you if your brain is like mine, but it helps me to break this into 4 chunks. Okay? And so that's what I want to spend the rest of the time going over is how do we know if this witness can serve as an expert or not? And I want you to think as we go through this about what you would do with this information if the state is tendering an expert and you're challenging it, and the vice versa, how you would use this to build up your expert. And I do want to preface, the lines between some of these when you read case law get a little blurry. I'm not saying it's the courts and not me, but I am saying that sometimes they use words like qualified to mean, I think, other things. So we'll take a look at that. But first and foremost, procedure. What are the procedures? Surely we must have grand procedural requirements for such a complex area of the law that has generated so much case law. We do not. Trial courts have tremendous discretion about how and when to consider whether this witness meets the standards of expertise. What are some ways we can find out? What are some ways we test whether a witness is an expert? And by that I mean, at what point in a trial do we do this?
Voir dire the witness.
Voir dire the witness, that's probably the most common one, right? You could voir dire the witness. We're going to question it. We're going to have a mini trial within a trial, right? And question the witness to see whether they meet Rule 702's requirements. What other ways can we do it? Prior testimony to try to compare their testimony against it. Yeah, it's for impeachment purposes. We would look at that. What about in limine hearings? Anybody ever do one of these before the trial actually gets started underway in earnest?
Yeah.
So it's before the trial truly begins, before the jury is in the room, right? You can also use affidavits. Courts can require witnesses to use affidavits. And we know that especially in complex areas, a court can require multiple of these. It can say, I want every expert in this case to submit an affidavit, and we're going to do an in limine hearing. You can think about how you might use the procedural flexibility to your advantage in a case, what you might want to ask a court to do. There are some benefits to having these inquiries done in limine versus during the trial. What are some benefits to doing it before the trial starts? Why would it help you or the court?
State can't open on it.
Say that again?
The state can't open on it.
The state can't open on it, meaning if the court were to decide
To block it.
to not let their witness in, they lose an arrow in their quiver, right? Good. What else? What is another benefit of doing it before the trial gets started?
Well, I mean, it allows you to adjust your case as necessary.
Yeah.
And then you also get a chance to see how that expert will present from the stand. So
so you can still make more adjustments. That's a great, yes, yeah, Cynthia says it'll help you see how an expert is going to appear in front of a jury before the jury is even there, right? Yeah, that's a great point. I was thinking about it, the first part you said, which is it lets you know what the rules of the game are before the game starts. That's an upside. It lets you know what the state can or can't do or what you can or can't do. It also might, it depends on, you might not always view this as a good thing, but it might encourage a better plea deal. Right? It might encourage not having to go to trial. If you know the state's case comes down to one expert and you manage to keep that expert out before the trial even starts, your offer hopefully is getting better, right? Or you can adjust your strategy. Absolutely. All right. How relevant must a witness's testimony be for it to be expert testimony? Who here knows, you don't have to get it verbatim, what Rule 401, Rule 403 are about relevance? What is the test for whether, forget experts for a second, whether evidence is relevant?
Balancing test, right?
Well, what does evidence have to do in order to be relevant?
Make a fact
Oh,
more or
has to-
less probable.
Yeah, it has to make some sort of fact more or less likely true, right? Experts is more than that. For an expert's testimony to be relevant, it is more than what standard evidence has to be. It's more than Rule 401. So I call it relevance plus. That is not in the case law. That is a Timothy made-up term. Be careful quoting that in court. But it's more. It's higher than Rule 401. What is it? It's made up of a couple parts. To be relevant, an expert's testimony has to be about certain kinds of stuff. One of those things is scientific. It has to involve scientific knowledge. The Daubert case, which everyone's familiar with the title, not everyone always knows the fact pattern. Daubert was a lawsuit against Dow Pharmaceutical, where a series of parents gave birth to children, babies born with birth defects. And the parents blamed Dow Pharmaceutical and sued. At trial, Dow Pharmaceutical's expert took the stand and said, there is no study that connects our medicine and birth defects. The plaintiffs put up an expert. They said there are studies, but they involve animals, not people. The US Supreme Court said, we're no longer in that pre-1993 general acceptance in scientific field. Animal studies are fine for lipstick and that kind of stuff. So it's not good enough for birth defects in humans. We need something more. Kumho came along a handful of years later, I think 6 years later. And in this case, it wasn't a scientist who was testifying. It was a technician. The technician was testifying about blown out car tires and saying there could be no other cause, in my expert opinion as a technician, other than product malfunction. That was the cause here. The Court of Appeals said that you're quote unquote just a technician. But that evidence is coming in, even though you don't really have the same expertise that was required in Daubert, but it's okay because you're not talking about science, you're talking about something technical. You're talking about something else. No. Supreme Court came in and said Daubert extends to areas other than science too. So for expert testimony to be relevant, it has to involve some sort of specialized knowledge, technical knowledge, scientific knowledge. And this is really important, it has to actually assist the trier of fact. It's not enough to get up there and tell the whole world everything you know about science. It has to actually help. Again, McGrady was a really good case with a lot of good stuff to read. They talk about how the expert, to be an expert, to be relevant, sufficiently relevant to be an expert, the testimony has to offer insight beyond the conclusions that could be drawn by anybody else. And in McGrady, that failed. It was a self-defense expert. And what he basically wanted to say was, his testimony was going to involve saying, people are put in fear. People are fearful based off what they see about their potential assailant. And it depends on the assailant's size and their gender and whether they're holding a gun or a knife or not. And the court said anybody would know that. The jury would know that. The jury would know it would matter whether this person was a foot taller than you, bigger than you, and had a weapon. It's not specialized enough. So it has to actually assist the trier of fact beyond what the trier could do without them. That's relevance plus for an expert witness. Any questions on that? Y'all hanging with me? Most of you are. It's late, I know. I saw you started at like 5 a.m. I didn't set the schedule. Or once, it wasn't me, it was Yolanda. Don't confuse anything I just said in the rule 401 and 403 don't apply. So even if the expert is ready to talk about something scientific and it's going to assist the trier of fact, if it's a waste of time, it's unnecessarily cumulative, or to what I think Javon was talking about earlier, if it's unfairly prejudicial, that still applies. You still have another chance to kick out the state's witness, okay? All right, qualifications. The one most people think of when we think about this. Great. So my testimony as an expert has to actually assist the trier of fact. What does my testimony have to be based on? What is my special knowledge, my technical knowledge, my genius? What does it have to be based on? Where does it come from?
Based on my experience and training.
Experience and training. Somebody has sat in a courtroom. It has to come from their knowledge, skill, experience, training, or education. What's the most important word on that screen? And it is a trick question. Or. It can be any one of them. It can be a combo. Or. All right. We'll see if I can make the audio work. Because if I can, this is the greatest example of everything we're talking about I have ever seen.
Your Honor, Ms. Vito's expertise is in general automotive knowledge. It is in this area that her testimony will be applicable. Now, if Mr. Trotter wishes to voir dire a witness as to the extent of her expertise in this area, I'm sure he's gonna be more than satisfied.
Okay.
All right, all right. Now, Ms. Vito, being an expert on general automotive knowledge, can you tell me what would the correct ignition timing be on a 1955 Bel Air Chevrolet with a 327 cubic inch engine and a 4-barrel carburetor?
It's a bullshit question.
Does that mean that you can't answer it?
It's a bullshit question. It's impossible to answer.
Impossible because you don't know the answer.
Nobody could answer that question.
Your Honor, I move to disqualify Ms. Vito as an expert witness.
Can you answer the question?
No, it is a trick question.
Why is it a trick question?
Watch this.
Because Chevy didn't make a 327 in 55. The 327 didn't come out till 62. And it wasn't offered in the Bel Air with a 4-barrel carb till 64. However, in 1964, the correct ignition timing would be 4 degrees before top dead center.
Well, she's acceptable, Your Honor.
Marissa Tomei won an Oscar for that. And it is seriously the best depiction of these issues, far better than any academic monkey like me has put together that I've seen on these issues. Mona Lisa Vito, I asked how many people watch Game of Thrones. I won't ask anybody who has, if they haven't seen this, but if you haven't, make it your Friday night plans. Mona Lisa Vito is not an engineer. Mona Lisa Vito is not a college graduate. Mona Lisa Vito grew up with brothers and a dad who were mechanics, and they operated out of the garage at their home. She got that knowledge from her experience. From her experience. She is an expert witness. She is not a lay witness. She did not simply say, I saw the car speed out of the gas station. It was going fast. Look how proud she is. She's an expert. And can you tell from the facial reaction of the judge that her testimony is beyond the conclusions he could have drawn on his own? Yes. She got that from her experience. When I moved to North Carolina, don't hate me for this, I am from New York originally. Why not? We got one. When I moved to North Carolina to practice law in 2009, I was sworn into the bar by a judge in a different part of the state, which I know at least one person in here is familiar with, but I won't name because he does not like the comparison. But that judge is exactly that judge. And when I got out of being sworn in, I called my brother and I said, "Holy shit." I said, "I'm in my cousin Vinny. It's just like what we found. It's real." We went across the street to the diner. They had breakfast $3, lunch $6. But I found it. I found my cousin Vinny. Mona Lisa Vito is an expert, despite the lack of academic training. Did I say that academics are irrelevant? No. No. The McGrady case, Charles McGrady was indicted for first-degree murder. He admitted to shooting and killing his cousin. But he said, "I did it out of defense of myself," and I believe his son, another family member, I believe it was Charles' son. He wanted to call a self-defense expert who had studied the basics of the brain. But he wanted that expert in part to testify about the central nervous system and its reaction to stress. And that expert had, tendered expert had said, "I didn't get a degree in any of this. I'm not a neuroscientist. I took some general psychology courses in college. I've read some articles. A few doctors have trained me on the issue." And he said, and I do appreciate the effort here, "I've had personal experience with stress, so I can testify about it." And the court said, "You may be a self-defense expert, but you do not have the formal education required to testify about the stress response of the sympathetic nervous system." And they said, it is true. Rule 702 does not require an across-the-board academic requirement for to be an expert. But that doesn't mean the trial court can never require it anyway. Defenders, how are we going to use this? How could this help you? It's very similar to my case law question.
They don't have the training.
Then what?
Then
Then who said attack him? And if you offer a witness who doesn't have the training, then what?
we reference
It's
this
perfectly
rule.
acceptable.
We say it's perfectly acceptable. It was Mona Lisa Vito is an expert. Absolutely. But you want to keep this in mind. If the state tries to put up a witness as an expert, and that witness lacks academic credentials, and especially if it's a complex topic, say, "Judge, you simply need somebody who has more credentials than this." Look at the McGrady case. The point is, don't confuse professionals and experts. They're not always the same thing. Sometimes non-professionals are experts. Sometimes professionals are not. Is every cop an expert?
In their minds, oh, said it out loud.
Probably not. No. The most experienced realtor in Raleigh is not necessarily an expert in the housing shortage crisis or mortgage interest rates in the feds, right? The case-by-case analysis, and part of your job and part of my encouragement to you is to not just roll over on these things. These are places in which you can kick out potentially the most influential evidence the state has. Let's meet somebody here. This is a medical examiner in the Daughtridge case. This medical examiner is experienced, she's educated, she's trained, she's good. First-degree murder case. She talks to the police. She gathers her information from law enforcement. She testifies and says, based upon these interviews, there was some sort of verbal fight happening in the bedroom. Something like a gunshot was heard. The person who came out of the room was described as the decedent's boyfriend. In my opinion, the manner of death is homicide. She was not qualified to be an expert. There are sort of two reasons. One of them may seem more obvious than the other. Anybody guess what went wrong for this medical examiner? What went wrong for the state here? She's experienced, she's educated.
It's not based on that experience.
That's yours.
Her opinion is based on, or not based on
Not
what?
based on her experience that she was
qualified for.
So because it was based on interviews, is that what you're saying? Like she based her opinion on interviews with the police, or am I putting words in your mouth?
It's hearsay.
So
That's fine.
an important part about expert witnesses is when we're talking about tendering them as an expert, the rules of evidence largely don't apply. So when we're talking about whether she qualifies or not, that inquiry, hearsay is allowed. When it comes to her actually testifying, how she gathered data is different than saying this is true because the police said it is. Does that make sense?
I'm not a lawyer, by the way. I just play one on TV.
Yeah, you and me both. I used to be one. So, yes, her opinion was based on general information from law enforcement. And we'll talk a little bit more about that. But this is really the crux of it. She did not apply her specialized knowledge. Is that what you were saying?
Yeah.
Yes, okay. This was an expert in listening. She did not apply her specialized knowledge. She just regurgitated, right? Here's the thing. My mother, God love her, is back home in New York. She is a wonderfully talented seamstress. My mother makes, designs, and sews opera costumes and theater costumes and bridal gowns in New York. She wouldn't know a courthouse if you put her in one, okay? She's never seen an episode of Law and Order in her life. If I said to her, a boyfriend and a girlfriend got in a fight, they went in the back room, kept yelling, I heard a gunshot, dude walks out with a gun, she's dead with a bullet hole. What do you think happened in there? I think she's gonna say, in my opinion, the manner of death is homicide, right? This medical examiner did not apply her specialized knowledge. She is not in a better position than my mother, the seamstress, to draw a conclusion here. She's not qualified. Notice, this doesn't go to the weight of her testimony. She doesn't come in as an expert. The defense counsel stands up and says, she's not qualified. She's not qualified. She is not giving you anything you can't do yourself. That's required for experts. All right, last piece of the puzzle, reliability. Notice I have reliable plus again, a term I made up. Why do we think I have a picture of a fork? Good luck reading my mind. Why do we have a picture of a fork up here?
You have to eat effectively.
You have to eat effectively. That's the second answer. Very good, Eric. What does that fork have on top of it? How many prongs? That means we're at the dreaded Daubert 3-prong reliability. Tucker just made the face I made every time I've ever heard it. Ever heard it?
My fork has 4 prongs.
Your expert is going to have a harder time getting in. The testimony of the expert has to be based on, so notice, reliable plus. It's more than just, are they trustworthy? Is this credible? The expert's testimony has to be based on sufficient facts or data. The testimony has to be the product of reliable principles and methods. And they have to reliably apply those principles and methods to the facts. Now, if you are like myself or Tucker, based off the face she just made when she saw this, I have glazed over every time I've heard these 3 in my life. I have never once successfully heard and understood all 3 of them at the same time. So what does it mean instead? We want to know, is this expert using established techniques? Are they hammering a screw? Okay? Can they get up there and tell us what the error or potential error rates are? When we do this type of blood analysis, we are certain to 93%, but there's a 7% chance of error. This third one I think is important for you all. Have they accounted for alternative explanations? Because if you can come up with a plausible alternative that they did not, their testimony is not reliable. Therefore, they should not be tendered as an expert or admitted as an expert, arguably, okay? This last one's a little wordy, but it's also important. Did they justifiably extrapolate their conclusion from the premise? Or as the court say, is there an analytical gap? What they were doing looked good, but the conclusion isn't the same. You know how with our court orders, especially if any of you do civil court, you got to have findings of fact that flow from the evidence, that flow into the conclusion. conclusions that logically lead to a decree. Same thing here. The expert has to take steps that make sense and arrive at a conclusion that's plausible from those steps. So a simple example, if you look at the expert's testing results, and it indicates the minor child is not victim of assault, and the expert gets up in there and says, that child's a victim. I know these children, that child's a victim. Reliable methods must be reliably applied. Otherwise, the issue is that supposed expert is just saying, I believe the victim. They don't get to make credibility determinations. Their methods and their conclusions have to make logical sense together. Okay? Another example. We have a doctor tendered as an expert in child psychology. The doctor relies on information from the Department of Social Services and the child's guardian ad litem, on family interviews the doctor does, and questionnaires. Court of Appeals, oops, we got another snooze. Only 22 hours left, folks. You're almost done. Court of Appeals says that opinion is based on sufficient data. The doctor also followed a clinical protocol for assessing emotional abuse. That opinion is the product of reliable principles and methods. And finally, the doctor concluded that the juvenile's exposure to conflict and the lack of boundaries in the home rose to the level of emotional abuse. The doctor reliably applied the methods to the facts. 1, 2, 3. How is this doctor different from our medical examiner? Our medical examiner got all her information from the police. This doctor got his data from DSS and GL and others. How is she different than this doctor? What did she not do that I misunderstood you trying to tell me?
He testified about what he's actually an expert in.
He actually took that conclusory step, right? He applied his specialized knowledge and said, this is emotional abuse. He did something that I can't do. I can't follow clinical protocols and determine based off of that if it's emotional abuse or not. She just regurgitated the police. He used his expertise. Exactly. Any question on those 4? No? All right. So a few common questions that come up. How certain does an expert have to be to give their opinion? How confident in their opinion do they have to be? Do they have to be absolutely certain? No. Degrees of belief are okay. Absolute certainty is not required, but 2 things for you. If the state's witness is unsure to any degree, jump on that. Goes to weight, goes to credibility. And know that there's case law out there that says if it's overly speculative, testimony is overly speculative, overly equivocal, does not assist the trier of fact, which means what? Out. They're not an expert. It's not actually assisting the trier of fact. So watch for that. Can an expert opine on the ultimate issues? No. How close can they get? Pretty close, right? This is how the courts word it. Cannot testify in the form of a legal conclusion, but you can, an expert's testimony can embrace an ultimate issue to be decided by the trier of fact. What the hell does that mean? Let's look. An expert was appropriate in testifying that the victim's injuries were caused by a male sex organ or something similarly sized and shaped. That expert cannot say this was rape, right? That's the legal conclusion. That's the ultimate decision. But his testimony can embrace those issues. A nice way of saying dance around the ultimate conclusion. An expert cannot say, I am quite certain her father did this. An expert can say, when I asked whether someone had touched her, she responded, Daddy did. Now, I have a note here, which you will appreciate, which is if it satisfies a hearsay exception, it very well may satisfy the medical diagnosis treatment exception, for example, or something else. But you see the difference between saying it was her dad versus here's the dad I have. If the state puts a expert witness up, do you have a right to look at an object or a writing, some sort of document that they use to refresh their memory? What if they use it while they're in court? Yes, right? What if it's before testifying? Anyone know? It's a harder question.
Is it just being used to refresh their memory?
Yes.
They base any part of their opinion on it.
They based their opinion on it, they relied on it. If they're using it in preparation, it is up to the court. Use that to your advantage. Try to argue the court to use its discretion the way it would help your client. And it's based on the interests of justice. Any questions on all that? I know that's a lot for a Friday afternoon. How many of you have ever been in a case where the other side called an expert? How many of you have called an expert? About the same number. The first time I called an expert witness, I could have used this. It did not go well. I was not sufficiently prepared. I did not fully understand Dahlberg and the lessons from it. And I think the judge extended me grace and gave me a lot of chances to qualify that expert. I would encourage you to not be intimidated by calling an expert. They can make a huge difference in the right case. But be prepared. You want to be familiar with what the requirements are. You want to anticipate what the other side's arguments are going to be against that witness. And be prepared to bolster them and say why they should get in. Yeah, Tucker.
If you're gonna use an expert, you might want to talk to your jury ahead of time that we're gonna have some experts.
Yeah, give the jury some heads up, see what you can learn about them and in that process as well, right? All right, I told you you did not have to take notes, that I have something for you. So this is basically everything we just covered, okay? This is what I wish I'd had the first time I called an expert. I hope you find it useful. It's a resource I created that helps break down everything it requires for an expert to be admitted. I had a judge recently call me and say, I was using your cheat sheet in court. And I said, okay, good. And they said, yeah. And then I looked down and the defense attorney was using it too. It's available for everybody. The backside of this, we did not, for your benefit, have time to get into today. But the backside of this is what testimony can an expert say about children? What can they say about a juvenile's credibility? What can they say about delayed disclosures, characteristics of abuse or assault, that sort of thing? And it's all got citations so that you can pretend in real time that you knew the case and you knew the reporter it was in. I hope this is helpful to you. Please feel free to let me know if you have questions about it or if you have improvement ideas for future editions or whatever. But I will leave these up here. Happy to stick around and answer questions, but I want to get you out on time. So thank you all for having me. Good luck with the rest of you want me to? Your mom says pass them out so we don't forget.
So I don't forget to grab them.
Good call, good call.
Don't mind passing it on.
And for the folks online, we will have a online version for them as for you all as
Yes,
well.
I will email this to the line.
Perfect. I don't want to do this.
All right, so we're gonna keep moving along. Thank you.
Just one, thank you. Is this online now? Yeah, is this online now?
You have one? No one.
Thank you, Susan.
This is great.
There.
It is awesome.
Yeah, I mean, this is just so, I've got something.
We're gonna keep moving along.
But every now and then, yeah, something good, so this is just great.
I'll go ahead and introduce Dr. Friesen. Dr. Friesen.
Sydney just got a first degree murder case dismissed. Well, yes, so she has to go. She has to go.
So I'm gonna go ahead and introduce Dr. Friesen, who's here from the Division of Juvenile Justice. I know it's changed. She received her PhD and Master's in Public Health at the University of Alabama at Birmingham. She also completed her internship at the University of Illinois at Chicago. She spent her entire career focused on youth, young people and their families, studying how to best help them. I know that she has spent, I think, the past 20 years working in this field and has a lot of wealth and knowledge to teach us about some of the services that are available to youth while they're in detention. Specifically, we're looking at those 16 and 17-year-olds who are awaiting either, or they started in adult court, so who may be sentenced in the adult world, what is happening while they're in detention. So she's gonna talk about that.
Thank you so much, thank you. I have a lot of respect for UNC School of Government. We actually worked on a process with them for consent sharing. I'm going to talk about that briefly today, and I'm going to get you out on time. I'm going to try to stick to our 30 minutes. And I know you focused a lot today on legal issues, and I'm going to just focus on maybe ending the day with what's happening to the young people that you're serving, and what do we try to do to help meet their needs, and then give you an opportunity to ask any questions you might have to support the work that you're doing and working with these young people. And I'm not a comedian, so I'm sorry about that. I wish I could say I am, but I am passionate. He seemed very passionate about this work. I am very passionate about the work that we do. So we're just going to talk today, and again, about 30 minutes, about what happens to the young people when they come to the juvenile detention center and the general programming we have. I'm going to spend the most of the time talking about mental health services expectations and what are some of the differences that we have tried to account for the young people that are in the adult side of the system. And what have we done? What shifts have we made to serve these young people over the last few years? And then I have a small survey of the young people we have on the adult side. And I use that term adult side young people because I really want to focus in on them still being young, but they just happen to be on the adult side of the system. So we're going to talk about that survey and what were some of the key points from the survey that the young people participated in. All right. So with our young people that are coming into detention, we have 10 juvenile detention centers in the state of North Carolina that are state run, along with 3 county detention centers. So I'm really talking today about the state facilities that we actually provide support and services for. So when the young person comes in, every young person, whether they're on the juvenile side or the adult side of the system, has some basic things that we go over when they come in. We, of course, review their legal paperwork to make sure that they are supposed to be in the detention center. We want to make sure that they have a secure custody order, or on the adult side, we want to make sure that they have that document on the adult side, the bond type document has all the information. I'm not an expert on that documentation. I am more an expert on the mental health, but we have folks that look at and make sure that that's acceptable before they are locked in our facilities. Of course, we do security screening, no surprise there. We do a medical screening. One of the big things that we've had to do over the last few years as the population of detention has gotten older is we really have tried to pay attention to youth that have some signs of substance use. And we have sent many of our youth to the hospital to make sure that they have a medical screening and for law enforcement to make sure they're clear to even come into our facility. So we have a lot of young people that are withdrawing from substances, so we want to make sure that they have that medical screening before they come and are secured. And then we have mental health screening, which I'm going to share some of those elements of what we do. Property inventory, we review their rights, including Prison Rape Elimination Act, the rights that they have around that. And then we review the expectations of them while they're with us. And then we do notifications to court personnel, and we of course notify their guardian and let them know that they've safely arrived into our facility.
Do you have time for questions during your presentation?
Yes, please. I only have 20 21 slides, so we should be good, yeah.
When you're reviewing those things, what, how do you take into account or assess their understanding of the information you're giving them?
So one of the things like, for example, I use a tool called the Macy. In the Macy, we actually, it's gonna be on the suicide screening, when I show you in a minute. I actually give them the form and I'm reading the form to them as they're looking at it. And so, and then I instead of giving you, because we used to train people that they would give the young person the form and then they would just circle. I actually asked the question, and we started training where you ask them the question and you look for the fact if they seem to understand. If you don't understand something, please let us know. We have other things where we said, like our mission placement screening. We say if you're not sure, please tell us that you want us to read something again. And so we try to use like motivational interviewing techniques with our staff to say, you know, take some cues on whether they understand what's happening. Now, are we doing the testing that you would do on a court side? No, but we are trying to do some things like the audio and the visual, making sure they understand what they're going over. Is that?
No, yes,
Okay.
thank you.
Okay.
Thank you.
Yes.
Sorry, I have a question. Were you finished?
No, you're good.
Oh, okay. All right, so you were talking about the medical screening.
Yes.
And getting medical clearance. So for a lot of my clients, our clients, they do have a substance use issue. So when you do that medical screening, does your program have any type of programs which allow them some form of medication as they're coming off of withdrawal? Or are they, okay, yeah, they're detoxing, they're withdrawing, but they're just going to have to go through it cold turkey?
One of the examples I'm going to give you in a minute on the youth that's on the adult side, we actually have a young woman that's on methadone maintenance. We have to actually take her to the clinic every single day from detention. And we're actually working with an agency called Integrated Care Greater Hickory, but they're broader than that. It's ICGH, and we're trying to establish, besides us going to the hospital back and forth, right, or utilizing our substance clinicians that are paid for by Department of Health and Human Services, where we can actually have a virtual medical appointment with a substance use expert and provider when they first come in, when the hospital sends them back. Because our routine practice is we'll take them to the hospital, but the hospital has this certain high criteria that they're looking at. If they meet that, they clear that high criteria, they'll send them back to us, but they still may be showing signs of withdrawal. We need somebody to help us with that aspect. So we've been working with our substance use clinicians to help with that, and then we're trying to get a contract to have a medical provider to support that, to support the medical withdrawal. But yes, we want to have access to the outpatient medications, not the in-clinic medications, but the outpatient medications for the medication assisted treatment. Does that answer your question?
Yes.
Okay, thank you. It's something that it's shifted a lot because of our population getting older. And we're having a lot of that with the fentanyl and laced substances, yes. So we're definitely trying to, and we've been working at this case by case, and now this contractor, we're trying to make it as something that we are standardizing versus a case by case situation. Okay, thank you, great question. So just a general description of programming in the juvenile detention centers. All of our youth have phone calls, they have phone calls every day. They have mail in and out of the facility, and then they have opportunities for in-person or virtual visitation, depending on what their families are able to do. All youth have access to educational programming, and about 4 months ago in one of our facilities that I've been helping out until we had a contractor, we had a youth that graduated with full high school diploma, had a ceremony. So we celebrate that. It's a big deal in our detention facilities for our young people to graduate or earn their GED and in that facility. And then we also have, through our tablet, we have new tablets that are able to do vocational programming. And so young people are earning vocational certificates such as ServSafe, and then some other, we're going to be looking at how can they do construction training, other trainings, so that when they actually get out, because some of our young people are getting out on the adult side, they're getting out because of what's happening in their case. We want them to be prepared, whether they end up, in a long-term facility or they get out. We want to be prepared for when they go back to the community. In the recreation program for youth on the juvenile side and the adult side is the same. They have to have a certain period of time of leisure and then large muscle activities every day. And then in youth in detention, participate in level systems where they earn incentives such as later bedtime, different clothing, longer phone calls, special meals, more access to movies on tablets, things like that, so that they're able to earn some of those incentives. And then adult side youth impacted by the new legislation. Now, actually, we have adult case managers that started in December of this year, because we know the court counsels weren't able to meet those needs because they weren't on the juvenile side. So we have adult case managers now that are doing that work, and they're actually doing some great work. And I think they're interfacing with you. I think hopefully over time we'll get that even more streamlined. We are trying to really adjust and make sure that we're meeting the needs of our young people. So back in 2021, in order to have where we are streamlining all of our services, we went to every state facility and said, hey, what is going on besides suicide prevention? Because the old model of juvenile detention was, we want to do suicide prevention, so crisis counseling, and that's pretty much it, because youth were in there 5 to 7 days, right? Couldn't do much when they're in there for a long period, for a shorter period of time. So we developed, and if you ever want any of these documents, just let Ms. Fair know and I can send them to you electronic. We developed some of the basic elements of what they're supposed to have, and that's what I'm gonna, like I said, spend the most time talking about today, what they're supposed to have while they're in juvenile detention center. So suicide prevention practices, some of the expectations, the main expectations are every young person at intake and after their court hearings has a suicide risk screening. Okay, so we know that court is a high risk time, so we do suicide risk screening after every court hearing. We do it again at, like I said, at intake. And if they have any kinds of signs of suicide history or current suicidal ideation, they're seen by a mental health clinician within 24 hours. And then if they don't have any signs of suicidal history or current ideation, they're seen by a mental health clinician in 72 hours. That's a new policy. Everybody's seen within 3 days by a mental health clinician. And we do mental health consultation with every young person in detention. Then suicide risk assessments are done by the licensed mental health clinician on youth that are on suicide watch. These are youth that are actually suicidal or have had some kind of suicidal gesture or behavior. And often our routine counseling is suicide risk prevention measures. So one thing we've been trying to do is get as many people in 7 days a week in person, our mental health clinicians 7 days a week. We have 6 facilities out of the 10 that have 7 days a week clinicians. We're struggling with some of the other facilities because of their regions and where they're located, but that's one of the things we're trying to do. Because what we found is when we had routine counseling every day, no surprise, suicidal ideation behaviors went down. And so we're trying to make sure that that's happening. And then we also have, and I'm not talking too fast. Slow down, I'm good. Okay, self-harm prevention orders to educate staff around what can happen with that young person, what they're allowed to have in their room, et cetera, for their safety. And then we also conduct suicide prevention training of all new staff, and then everybody's trained every year. So these are the basic expectations we have in every facility, and our contracted licensed mental health clinicians make sure that these basic expectations are met as part of their contract. One of the biggest challenges we have, honestly, is our crisis access. We do suicide prevention work. We counsel with young people in crisis. That's part of our expectation. But when a young person is in a high-level crisis where they end up in a hospital, where the hospital says, yes, this young person needs to be an inpatient hospitalization, we have a challenge in getting them into a placement. This is where we see a huge barrier for both juvenile side, but it is completely a barrier for adult side. Because most of the adult side youth, I think when they see that that young person has a bond, they won't accept it for inpatient. So we are having that challenge, but this is just our key points of what we are asking all of our team members to do. We developed this over the last year to make sure that that young person we're trying to do everything we can to get access to them being in the hospital. I got 2 questions, so yes.
You said that facilities won't accept them if they have a bond. Does that include unsecured bonds? So they're released, but it's unsecured?
If they're out in the community, that's different. If they're bond and they're in our facility, if they have a I may have said it wrong because I'm not legal. If they are in our facility and they are waiting for somebody for their $250,000 bond, and they're in our facility and they're in our custody, they will not take them. They won't take.
That was my question too, I guess, sort of, do you have a understanding of why that is? I feel like that's something that.
So you think about, if you look at some of the hospitals that require, that meet the criteria for IBC, like the Holly Hills and the Old Vineyards, think about how they're structured. Those youth can actually just like, honestly, you've been there, walk out, figure out a way to walk out the door. They don't have, our staff are going with them. And so they don't have
The security.
the security factor. They're secure facilities, but they're secure facilities on the definition on the mental health side. Does that make sense?
So where do they go? I mean,
They stay with us. They come, but they send them back to us. They don't.
Because they're not,
And yeah,
they have to be a danger to themselves or others. That's why you can't get an adult person transferred from a jail, because if the
Yeah.
jail's saying they're not safe.
yeah.
Which they're never gonna say. So
Yeah.
it might be sort of the same thing, because
Yeah.
they're safer with you.
And well, we actually, we put them on suicide watch, which means that staff members watching them 24/7, they're with them. But that we still think they need to have that hospitalization, because the hospitalization is gonna give them to make sure their needs are met. So what JJ, Juvenile Justice, has done is we put in legislation 4 times, this is the 4th time, where we have asked for overlay of crisis clinical services, like by New Hope or another organization that will come in. And this 4th time is coming through this legislation, which this year, the year of Helene, we're not anticipating it's going to be funded. And we're also working with DHHS to see if they can fund an overlay of services. Because the thing about juvenile justice is if we add extra clinicians or services, we have to get it approved by the legislature.
Right.
So,
Us too.
yeah, okay, yes.
This is a situation for one of our clients. How could an attorney find out? Because usually we could go advocate and have a bond hearing and maybe we can't get it reduced, but if we could, is there a way that an attorney could find out that this is happening?
We can definitely make sure through the family that you guys find out what's going on, or even, yes, we can definitely do that. We haven't explored that piece because we didn't know what legally can be done. Because I think the bond is issued, but I will tell you, maybe out of the last 10 of the juvenile side youth, and I promise I'm sorry, the last 10 of the juvenile side youth, we had 1 that was accepted in the inpatient on the juvenile side, and they had no bond. So we have some that are very small that are accepted on the juvenile side, and then none so far on the adult side. We'll send them to the hospital, and then they will send them back because they have a right to refuse. The inpatient hospitalizations will have a right to refuse. And then Central may say, we have a 4-month waiting list or whatever their barrier is. Yes, sir.
That's okay. Go ahead.
I'm sorry.
No.
Okay. If it's frustration, we are frustrated too. So yeah. If there's ideas, we are open to ideas because we want to be able to address this. The other thing we got really excited about was there's facility-based crisis centers all around the state that they're opening up for children, and they're trying to make this an alternative to the hospital. These are people that are specialized in training with behavioral health. So these are our substance use withdrawal management, the term detox. These are our detox facilities. These are the facilities that can do IBC. Some of them, they have to go through special training, but they can do IBC. And we probably have had 2 acceptances over the last year. So once a young person, I say this, is once a young person comes into our custody, it is very hard to get them into either one of these facilities. But if they're bonded out, they might have a better opportunity, or if there's some kind of way to get them out of the facility, out of our facility, they may have an easier opportunity to get in. And we are working on this, trying to make sure there's some options. Yes, sir.
Is the striped one where they're gonna be, or?
Yes, that's where they're gonna be. Yes.
Oh, wow.
Yeah. All right. And so I already said these 2 major options for youth and juvenile justice facilities. And so we talked about that. No acceptance yet for on the adult side. And so I'm going to give you some examples of young people that were in this was the week of March 13th. These are youth that raised up to my level, because my job is to work with youth that have high behavioral health needs along with their contractors. That young woman I talked about we take her to every day to the methadone clinic, and when they're not open, we take her to the hospital to get her methadone. And I think they believe that, I don't want to give too much details, but I'm allowed to keep it general, but they will not adjust it because there's some medications we can give. We can't give methadone. Only certain clinics can. Another young person was hearing voices and hurting himself, hurting other people. We IBC'd him. He stayed in the hospital for a week, and they couldn't find a place that will take him. Another young person had the same kind of situation. A student has a bond and issues with going to other places. We haven't been able to get him into any hospitalization. And then this last young person is just having a lot of aggression. And they started psychiatric consultation with dentists. We have psychiatrists, but it's not the same to have a psychiatrist that consults versus the actual inpatient hospitalization. And staff overwhelmed with a combination of aggression and mental health behaviors. So this was just that week. The young people that we had that were on the bond side. Juvenile side, we had 5 more. So there's 9 young people that, it may not seem like a lot, but that's a lot. And they're suffering. They're suffering through this. Yes, sir.
Has there been, maybe you said this and it's so gone over my head. Have you thought about, instead of bringing the kid to the services, to bring the services to the kid?
Yes. Perfect.
Well, but not with that, not taking them, but having some sort of like almost mobile response unit.
Yes. We actually asked for, can we bring the mobile unit for the substance use situation?
Yeah.
Can they bring the mobile unit? Because they have some mobile methadone treatment. They said we would have to still provide the methadone. They would bring the medication to us and then we would provide it.
But the folks who, not for medication reason, but for other reasons, bringing, like you say, the experts to them so they're still secure, there's not an issue about flight with the bonds.
So the Center for Medicaid and Medicare Services will not allow for Medicaid-funded providers to provide services to individuals who end up in a incarceration status. So our youth that end up in a YDC or end up in a prison cannot be provided services in this kind of setting.
Is that a state law or a federal law?
That's federal.
Thank you.
That's federal. So but we're open to any kind of, we're very open. But yeah, the federal regs don't allow it. So they have tried to do some waivers. We've been working with Division of Health Benefits, which is NC Medicaid, to try and see if we can get some waivers. And like I said, DHHS has been progressing with the possible getting a new hope to provide services overlaid in one of our nicer facilities where we provide staff and then they provide the clinical staff. Yeah. That's, Go ahead, I'm sorry.
Well, I had a client here who had some sort of coverage because his dad was military. And I can't even recall how we worked that out, but they had the military doctor come talk to our client, but that was in Durham.
And you mean for TRICARE, they went to Durham, to group home?
I mean, this was before computers, man. I don't even.
Okay, yeah. So what happens is that
they still have those.
Yeah.
It's still that insurance is still there for some of them.
Yes, the insurance may still be there. And in fact, people have billed. What happens is that person ends up in foothills, right? So our youth are starting to go to foothills. They end up in foothills and that it pops up that they were in our system starting with the day that they were arrested. Anything that somebody billed from that day to on, they can go back to that provider and recoup that. Yeah. So that's why people now, when they see them in our facilities, they'll say, we'll contract with you, will you pay us? And that's what we're also trying to do. We're also trying to figure out how we can find some other funding to provide services. I don't want people to be hopeless. We are working on it, and we are working on it. Yeah, but we are open because you all are good. You are the strongest advocates for our young people. So we're open to any kind of input or feedback or support for the young people. So just so you'll know that there is counseling and there are services. We expect our contracted clinicians to utilize evidence-based treatments, evidence-based practices like cognitive behavioral therapy, dialectical behavior therapy, seeking safety. There are certain things that we do expect our clinicians to utilize. So it's not they're not getting any kind of services. And that's something we've actually started tracking what's going on in that area. On the juvenile side, since I think most of you all have experience on that side, they belong to the community. So our whole goal is to get them back into the community, providing counseling to stabilize them, crisis intervention, motivational enhancement, those type of services. And we work heavily with the court counselors, coordinating appointments and assessments, et cetera. That we've had to make adjustments for youth on the adult side. So largely because the youth, we found that there's several areas where the youth on the adult side have different challenges and struggles, because the youth on our juvenile side, they process through with us pretty quickly, relatively quickly compared to the youth on the adult side. But they often have this magical thinking. You all know this is a hallmark of adolescence. It's not just them, that they will go home soon, and that the court system is not considering their high level offenses. So we have to deal with that in counseling. We try to help them with that. There's disappointment about family, court processes, legal involvement, including lawyers' absence. I will say when I hear a young person has a juvenile side lawyer, but they're on the adult side, that I see a lot of the same juvenile interaction. And not saying I don't on the adult, people who are traditionally working with adult, I see a lot more interaction. But that lawyer's absence, I will tell you, is a huge precipitant for depression, agitation, and aggression. When their lawyers are not present, because it is a long process, even just to say, hey, I'm just checking in with you, we see a lot more of those type of behaviors. And then the young people, if they've been on the juvenile side, they feel like if things are gonna happen, they're gonna go to court every certain amount of days, right? That's a huge precipitant for some of their agitation. Yes, sir.
And not to make an excuse, since I'm a state juvenile defender and it's largely my fault, but part of the problem is that the process and the culture has shifted in a very quick amount of time. Very few kids used to be transferred.
Yes, yes.
And I don't think we were doing our job then, but now
yes,
hundreds of kids are.
Yes.
And the two problems are like training lawyers to do what you say and to check in.
Yes.
Even if there's nothing to talk about. Lawyers generally will not talk to their clients unless there's some movement in the case. But we're trying to get them to say, well, but this is movement. Like
Yes.
this is part of your job to talk to them.
Yes.
The other problem is if you're used to going to the jail, that's in your county.
Exactly.
You're not used to going 4 to 6 counties over, and it's something we need to sort of talk to DJJ about more, remote access or whatever.
The virtual, if the lawyer contacts us and say, I want to virtually reach out to, and you all have a barrier with that, let us know. Because on the adult side, we want that lawyer contact, whatever we got to do to make it easy. Because we know we had a young person 2 years, had not had any contact with their lawyer in 2 years. And so we don't want that. So anything we got to do, and you have a barrier with that facility, let us know. We're going to make sure that that's going to happen.
That's what I had my hand up, that I know from the attorney side, I sometimes have a hard time getting access to my client. Like, I like in-person visits, but I'm calling, I'm leaving messages. Oh, we can't do this day. You can't do this day. We got this here, because the area that I have, that the facility had for me to meet with my client there was a long waiting line, right? So I'm calling this week, hoping to see my client next week, and it ended up being another 2.5 weeks before I could see my client because it was filled. And that was when my client, the one I'm thinking about in particular, that was when my client was staying in Dillon. And it took me forever to get that in-person meeting. So that is a issue far as attorneys trying to access their client. Now, and great, I didn't know virtual was an option.
Yes.
I was trying to say, hey, I need to see my client. Can I come in to see him?
If that happens, please reach out to them and link it to us, because we're gonna, whatever, even if the clinical person has to go, I go to Dillon all the time to support, I go to all my facilities. Whatever we have to do to support that, and then to model for our people that this is what we expect. We expect that if a lawyer wants to come in, now, if they have several virtual hearings at the same time, and you say, I need to speak to my client right now, that may be a barrier. But if you're trying to schedule, you should not have to wait 2.5 weeks to see your client. So I apologize for that. And so I think I appreciate the feedback, because we need to also tell our folks, if the lawyers are speaking, then the behaviors that you're seeing are gonna be lessened. They're not gonna be as pronounced. So helping them to see the connection so that they can reduce any barriers. So I'm sorry that happened. And we have to make sure who is the person at each facility that they need to talk to, so that they don't have that barrier. So, and our adult case managers also are going to start working on that piece too, to help with that. Yes.
And sorry to bring this up, but to
Yeah.
Adrina's point, there was a time where you would call the facility, you wouldn't get an answer because of there just wasn't the staff. And what that ends up doing is, then you're less likely, you've got all these other clients with this other stuff going on.
And you do.
You just stop, you just quit calling. So, yeah, we would love to work together on trying to figure this out.
And it should be our casework associates that are doing that work. And Dillon has 2 casework associates. So they should be the ones who are making sure that's happening. That's their job. So we'll work on figuring out what the barriers. So thank you for sharing that, because that should not happen. So I apologize for that.
We apologize for not showing up.
Yeah, well, it's not you all. I trust you. In fact, you're here on a Friday, it's not you all. And we do a lot of our counseling around acceptance of the situation. And this is the example I want to use. I think it's a great example. And we also put youth on mental health monitoring. They're not suicidal, but we want to make sure they're being monitored and followed. I was there on a Friday with our newest facility, because I was helping to fill in until we contracted. Somebody brought a discovery packet, which is great. The youth have the right to have that discovery packet on a Friday, like at 3 p.m. And so you guys have a right to bring them whenever, but just to understand that on a Friday at 3 p.m., all of our clinical staff, everybody is gone on the weekends. They check in every day. So I immediately put them on monitoring and said, they're going to be reading this all weekend. Please keep an eye on them. So just even that interface with them and thinking about what they're dealing with. It's like if you brought it on a Monday, for example, I'm not saying you have to do it that way, but if you brought it on Monday, then the social workers type staff and other people will be there to help, and the mental health clinicians will be there to help them because they're in person. They're in person during that time. And let's see. And then for some, this is their first offense, and we're also seeing that there's a lot of young people that have mental health issues, and this is the first time they've even touched our system. So we haven't even identified until we see them in detention. So we are putting some youth into trauma therapy. We have a trauma therapy pilot. We have some youth going on medications that did not have a history before. We first watch them to make sure it's not a detention thing, because most people get depressed and anxious in detention, and we do some assessments around that. All right, a few more slides and we're gonna get you out of here. So another thing I mentioned already, longer term youth are waiting for adult processing, and this can take months or years. One of the major obstacles, I think, because why we did not do any more standardized counseling is because we had some lawyers that would say, don't talk to anybody, right? And then the youth would say, I'm not talking to the counselor, I'm not talking to anybody. So we actually created a longer term youth consent form that we worked with Latoya Blackman Powell and Austin Long to ensure that it had the elements of what we needed to ensure that young person feels comfortable talking to the clinician. And we talk about them not speaking about their offense, right? We talk about with the clinicians, if they start talking about their offense, this is what you need to do, and they want to talk about it. But we know that on the juvenile side, we're never called into court to talk about their offenses. On the adult side, we could be potentially called into court. And we want to make sure to protect their rights around that. And so this process, we asked the family to talk to their legal team about accessing services beyond counseling. Counseling is regular. We don't need consent forms for counseling or suicide prevention services. Anything beyond that, we need a consent form. And so I'll show you the slide, the differences between the consent processes on the juvenile side and the adult side. And so on the juvenile side, the long-term service is still provided mainly by the community. We can bill Medicaid, we can get the Medicaid providers, all of those people can be involved. We focus most on coping skills, I talked about that. And those youth may end up in a YDC, but we're really focusing on preparing them for that YDC placement or getting back out to the community. And we have, through this UNC school government, developed a multi-party consent form to make sure that all of their rights and their families' rights are being protected through HIPAA, FERPA, other federal regulations. On the adult side, the long-term youth consent form is what's used. And that, again, we need that for psychiatric services. So anytime that young person needs medication for mental health challenges, they must have that longer-term youth consent form. We need that for substance use services, because the federal regulation 42 CFR, we want to make sure we're meeting that the young person's consenting, and we also get parental consent as well. The young person's consenting, but the parents consenting. And then when we have our trauma therapy, we're also doing the consent form for that as well. So that on the adult side, we want to make sure we have a whole different process to accessing services to protect them versus just saying, well, we don't want them to say too much because we want to protect them. And we have every 30 days, all clinicians are supposed to, some youth are meeting every week with the mental health clinicians, and then some youth are like, I'm good, I don't need to talk to anybody. We're asking them every 30 days, can you do a mental health check-in with us? Can you do a mental health consultation with us? And almost 99% of the time, they will do that. And we document that we check them for different areas to make sure around depression, anxiety, suicidal ideation, homicidal ideation. We're checking at least every 30 days for all of our long-term youth, or youth on the adult side. Any questions? We've got a couple more slides. Any questions so far? So this is our last section. So we had a survey that we did because we knew the legislation changed. Everybody familiar with the December 1st legislation? Okay, I just want to make sure. We knew the legislation changed, and we wanted to see what did the young people need. I'm sorry, did you?
No, we're adult people. We're just.
Oh, okay, I'm sorry.
Okay, we got it.
I'm sorry. Okay, well, the legislation changed that all of our youth that are 16 and 17 that have A through E felonies, they are automatically, and I'm automatically put into Superior Court. Is that? They start in Superior Court, and they don't have to be transferred any longer. They used to have to be transferred, and now they start in Superior Court. So because our court counselors don't deal with them, that's why we had to get adult case managers. We did a survey to find out what would be the biggest thing, and it could be family visits, it could be friends, whatever. What are the biggest things they said they needed help with? And we made it very broad. And you'll see what the theme is, that what they mainly wanted. 53% of those youth had been in the juvenile system, and 47%, this is their first time in the adult system. That's just like, it's only 19, so I don't want it to, it may not extrapolate to the rest of our population. And so these are the categories that they said they wanted support. Okay. You see a theme, right? What's happening in court? Monitor my court dates, and they can give up to 5 responses. So 19 times 5, and this is what they categorically responded. Monitor their court dates and times, speed up their court process, help me have a voice in court, help the DA or judge know good things about me, set up lawyer professional contact, and help others give me a second chance. So all of this was, even though they could talk about family, they could talk about what's going on in the facility, friends, they all said, I need help with court.
Can I ask a quick question?
Yes, sir. Yes.
So these categories, is this like multiple choice, or did they come up with
No,
this?
we did it where they could give qualitative responses. So they just said, I want I want this. And I took all of it. coded it,
Right.
and then put them in these categories.
Okay, good, great.
Yeah, so if I didn't want to limit what they could say. I wanted to see what came up as the top.
It's really striking that they want the court to know good things about them.
Yes, yes, everything is really about the court, even though they could have talked about anything. And then the three that said no issues at all, I asked them specifically and I pulled them aside and I said, you said there were no issues. The thing they said, all three of them, they said, I don't have any issues. I'm talking to my lawyer and they're telling me what's going on. Even if they're still there and they don't have the case is not moving, they said their lawyers knew what was happening and they lawyers were talking to them. And that's what you're saying, that key part that they're having those conversations. So youth with consistent contact, even if nothing is happening, and have anecdotally stated things were fine legally in this small sample, very small sample, but it was probably hopefully helpful. I think right on time. This was just a small short snapshot of services for young people while they're in our state JDCs. I want to say we're grateful for your willingness to increase your awareness of the needs of our young people because we know that your presence and your service is instrumental to their overall well-being, and we need to do whatever we can to make sure that you have access to your young people. So this is great because then it's going to hopefully help us shift some things in juvenile justice so that we can ensure our young people's needs are being met. And I want to say thank you so much for wanting to serve our young people. So thank you.
Thank you.
Yeah.
Another question. What is the best route, A, for getting records from a youth facility? And second, what do we expect?
So the records go through Aaron Hickey in Central Office. What you can do is if you send me an email, we'll get the information to you, but the records request will go through Aaron Hickey.
I mean, their facility records, like when they were.
Yeah.
Okay.
It'll go through there, and then we have a staff member that's their job is to pull records. And I don't know how they pull everything together. I don't want to tell you wrong, but they pull their records and then they send that out based on the records request.
And so that may be discipline and health. And
Yes, sir. Yes, sir.
Okay. I'm a subpoena right now.
Sorry.
Subpoena right now.
Oh.
It's like an off.
Guess I'm slow.
Thank you.
Thank you so much.
Everybody online, we are shutting down. Thank you for staying the whole time.
Yes, thank you.
Do we have the online evaluation?
We will send that out in our follow-up email.
Follow-up email, online evaluation, please let us know what to do or what to do differently. It's our job to serve you all. Have a great Friday. Thanks.
Thank you.
Be late. Most important, take snacks.
You want these?
Yes. Snacks out this door. You go out this door, there's nothing. You go out this door, there's food.
It's embarrassing. What is your family?
We try to help them, but
Cindy Callis.
once.
Cindy Callis.
I will not, yeah.